Yes.
My lord.
Well, may I mention this is a matrimonial appeal. Paper were filed and served also. Are they ready for hearing?
Hearing we are not adding now. Before the puja we cannot. Yes.
My lord, this is also matrimonial appeal. My
Please
lord,
wait
I am
after
for
the vacation.
my lord, 2019, my lord, till date,
Understood.
my lord, I am not getting, my lord.
Sorry, no hearing.
Well, I am for the respondent, my lord. Why not getting any maintenance, my lord?
File a maintenance application. File the
only due to pendency of the appeal, my lord. Nothing else, my lord.
Due to pendency of the appeal, you will get
Yes.
maintenance.
Yes,
Not that
my
you will not get maintenance. You
I
will
am-
get maintenance during pendency of the appeal only.
My lord, that
Unless you get permanent
my
alimony.
lord, actually, that order was passed regarding.
Have you got an application for alimony?
Yes, my lord.
Was any order passed there?
No, my lord.
Mention that application then. We'll take up the application. Where are you mentioning the appeal for hearing?
My lord, actually, this is the against
Next.
divorce.
My lord, I am mentioning one matter. APT number 150 of 2025.
What is the hearing application?
For correction, my lord.
Yes, to be mentioned for correction.
My lord, one matrimonial hearing, my lord.
Not now. After vacation, please come back. Yes. Right.
My lord, I am appealing for the appellant.
Yes, by mistake, it's against a remand order. We mentioned probably that the decree will be drawn up. We will correct that only. Okay. জাজমেন্টটা কোথায় আছে? এটা হ্যাঁ না by your judgment dated July 24, 2025, passed in FAT 30 of 2024, we had remanded the matter to the trial court. Full stop. However, erroneously, we had recorded that a formal decree be drawn up. Full stop. Let the said sentence, directing a formal decree to be drawn up, stand deleted. Full stop. This correction be deemed to be incorporated in the judgment dated July 24, 2025. Full stop. The office is to act accordingly. Thank you. জাজমেন্ট গুলো কোথায়? পাগল নাকি ওরা? জাজমেন্ট গুলো কোথায় রাকেশ? Sorry, Mr. Agarwal. Accordingly, MAT 224 of 2025 is dismissed on contest, thereby affirming the impugned judgment dated February 17, 2025, passed in WPA number such and such, dismissing the said writ petition. Consequentially, can is also disposed of, no address to cause certain sort of.
Grateful.
Thus, FMA number 1243 of 2025 is allowed on contest, thereby setting aside the impugned judgment dated May 23, 2025, passed in WPA 1125 of 25, as well as the order dated January 20th, 25, passed by the BLLRO Shantipur in miscellaneous case number such and such. It is hereby declared that the respondents cannot claim or proceed on the premise that the subject land was acquired and or vested in the state at any point of time. Any consequential action taken on the premise that the said land was acquired is hereby automatically annulled and revoked. Consequence, can is also dismissed, no orders to cause certain certified cause.
Deeply obliged.
Yes.
Deeply obliged.
Thank you. Yes.
Three, Your Lordship, this has come up at my instance, Your Lordship. The matrimonial
You're
dispute.
for the respondent.
Yes, Your Lordship.
Yes.
It has been resolved, Your Lordship. The appeal was against an order of granting divorce, Your Lordship.
So you have decided to part ways.
Part ways, Your Lordship, upon certain terms, Your Lordship. We were placing before Your Lordship that joint petition may be filed before Your Lordship, giving the terms of such settlement, and that may be made a part of the decree, Your Lordship.
Are you ready with those?
No, Your Lordship. Kindly.
So why didn't you mention? You could have filed that application in an application form or mention it after it's ready.
Kindly takes it up anytime next week.
Otherwise, you'll have to dispose of right now. Then that compromise goes.
Kindly takes it up next
File
week.
that application or
My lord.
come prepared with affidavit. We
Your
can direct you to file an affidavit. We'll keep that on record.
Your
Learned counsel for the parties submit that the parties have resolved the dispute between themselves and, upon certain terms, have agreed to the divorce decree passed by the learned trial judge. Full stop. Accordingly, the parties are requested to come with a joint affidavit containing the terms of the agreement in order for this court to pass a comprehensive decree and dispose of the appeal. Accordingly, full stop, let the matter stand adjourned till September 16, 2025, when it will be listed under the heading to be mentioned for such purpose. 1 week, next Tuesday, please come back.
Gratefully, Your Lordship.
And please let it be a joint one. And please check that both the advocates and the clients, it's otherwise informed, have signed and all.
Your Lordship.
Great. Thank you.
Gratefully, Your Lordship.
Thank you.
And I could have
We
handed
are
over,
grateful to you for
and I
filing
could have
this.
handed over, my lord, the on earlier occasion.
Could have
Yes,
sent
sir.
somebody to
Because, my lord, the resolution was.
resolution. Before the resolution, you called the matter before it was communicated to us.
Oh, because I.
The learned senior advocate, the learned senior, the learned AGP appearing for the state stroke review applicant files its written notes of arguments. Full stop. Let the same be kept on record. Full stop. Since the respondent has already filed its written notes of arguments, full stop, hearing is concluded and the matter is reserved for judgment.
My
Thank you.
lord,
very much.
item number 2, my lord, my lord, may I see the judgment, my lord, only? Because item number 2, that is.
We pass the judgment.
Yes, that I want to see the judgment here.
No, it will be uploaded during the course of the day.
My lord, only my lord held, my lord, what, my lord?
Unless the copy goes, it won't be uploaded. It will be late. By the afternoon, it will be uploaded. You can find in the site.
Yes, yes, yes. But my lord, I have gone through the, my lord, L. Chandra Kumar, all this. I do not know.
Check up.
Yes, sir.
Yes. Next.
I am for the petitioner.
Yes, Mr. Ghosh. Yes, what is that?
The can is the
Forget the can. Oh, leave.
yes, the why the after the filing of the judgment, the original applicant expert, so the can is filed by the
After
legal
passing of the impugned judgment original, who has the expert? 6.
father of the petitioner before my lord, the expert.
So that's why leave.
That's why legal.
We are allowing the leave application.
Yes.
Can 1 of 2023 is an application on application by the heirs and legal representatives of the respondent number 6 Lakshmi Sutrodhar, who died after the passing of the judgment impugned in the present writ petition, seeking leave to present the present writ petition. Full stop. In view of the said heirs having stepped into the shoes of the respondent number 6, such leave is granted. Full stop. Accordingly, can 1 of 2023 is disposed of by granting the heirs and legal representatives of respondent number 6 to proceed with the present writ petition. Full stop. The necessary consequential corrections to the cause title of the writ petition, incorporating the names of the added respondents shall be carried out by the learned advocate on record for the writ petitioner.
The petitioners are himself, the
Petitioners themselves.
yes.
আচ্ছা last sentence টা কেটে দিয়ে তার বদলে since the petitioners are already on record,
already in the petition, the heirs are already filed this writ petition.
আচ্ছা since the heirs of the deceased respondent number 6 are the writ petitioners themselves, no further order need be passed for rectification of the cause title. Full stop. What is the matter about?
The matter kindly comes to page 16 1
Mr. Dhar, you are for the state.
Yes.
You are for the private. Yes.
मतलब page 16 मतलब the मतलब my
One
mother
six.
16 मतलब my lord will find मतलब my mother was मतलब the occupier under the 1975 act मतलब the may I hand over the मतलब the copy of the act मतलब একটু just check দিন मतलब being a eligible occupier मतलब I am मतलब
1975 Act.
मतलब 75 homestead act मतलब this is a
ওটা নেই।
homestead act मतलब
Thank you. Yes.
now मतलब the being an मतलब occupier मतलब section 4 मतलब says मतलब who is the occupier
Forgotten. Just let us go through for section 4 once.
मतलब 4 मतलब the acquisition of land for occupier
Yes.
where an occupier has been in possession of any land on 26th day of June 1975 then मतलब this is the मतलब the appointed date
Yes.
26 June 1975 now मतलब my case is that मतलब the authority मतलब after observing all the formalities recorded the name of my father as the मतलब the homestead beneficiary so मतलब page 16 records frame in the name of Lokki Sutrodhar now मतलब the and the remarks column it has been written मतलब this is मतलब the transfer is restriction मतलब হস্তান্তর নিষিদ্ধ now मतलब the suit plot is मतलब the page 17 मतलब the area is 0.5 decimal मतलब page 18 is the मतलब the computerized records now challenging that my recording मतलब the original application has been filed by the private respondent मतलब the learned tribunal मतलब dismiss that original application मतलब the order at page 57
This is one of the specified acts.
yes मतलब
57. Yes. Oh,
No, मतलब
57. Sorry.
way
You went to the wrong page.
page 57 मतलब the
57. Yes.
the order passed by the learned tribunal in OA number 1205 of 2005 मतलब the ordering portion मतलब paragraph 7
Yes.
मतलब paragraph 7 मतलब the middle portion it has been recorded there is no provision such provision under the act as will render the eligibility of the respondent number 6 as an occupier on the appointing date 26 June 1995 extinguished मतलब their case is that we are holding land so on the date of appointed date the occupier has no land मतलब for that reasons मतलब the
As per the act, it would vest in you only.
yes and
What
मतलब
is their case?
मतलब based in favor of my mother and subsequently after the legal heirs
Yes. What is their case? We couldn't
their
understand.
case मतलब that person is holding land not a landless person
Oh,
मतलब that
unless
is
you are a landless person, you are not entitled.
yes मतलब that is recorded 2F 2F it has been sent मतलब the occupier means
Yes.
the no land
Who holds no other land? Right. They say you had other land.
yes
All right.
now मतलब the OA was dismissed मतलब page paragraph 8 having regard all the materials on record and having considered the submission made by the learned advocate the state respondents at the time of hearing it is evident that authority concerned had recorded the respondent number 6 as an occupier under section 4 of the act after having considered all eligibility criteria set out under the provision of the applicant has not raised any allegation that may render ineligibility on appointed date 26 June 1975. The Act has not voiced any eligibility criteria for subsequent deletion of the name of the occupier if the occupier or his or spouse inherits or acquired some
Right. Their
additional
case is that subsequently you acquired land. You say subsequent acquisition does not mean anything because it has already vested.
Yes.
Understood.
Now, Mala, the way
Happened then.
dismiss.
Yes. Then
Now they prefer the writ petition before this honorable court. मतलब page 67 WPLRT 687 of 2006 मतलब this writ petition was disposed of with a liberty to them to prepare approach before the authority under section 9. There is a provision for reference. If any dispute arose, so page 68, we also the applicant to raise dispute making an application before the collector under section 9. Under section 9 of the act says if any dispute arose, that will be the collector is the authority to decide that issue.
Very well.
Now thereafter the matter was placed before the collector. Now that proceeding as page 70,
yes. What happened there before the collector?
Now the page 74 concluding part, prior to that, page 73 bottom portion, the settlement of the dispute under section 9 of the said act will be made by the BLRO Lapur RO. Since the BLRO is discharging as a duty as a collector for this purpose.
No, we can't find that portion. Where? 73 bottom?
At page 73.
Bottom, what does the sentence start with? In the present case?
The section 2C of the said act.
In the present case. In the present case.
Yes.
That is the paragraph.
Read from there, Mr. Ghosh.
In the present case, one
recording of such and such.
Of 5 decimals lamp height plot number such and such, Moja such and such of Lokki Suttodhar as per provision of section 4 of the said act has been made by the BL and LRO Lapur as collector.
So this was a different collector.
Now under the provision of this act, BLRO is discharging as a duty as a collector. So the matter was again referred to the BL and LRO by the DLRO.
Yes.
For the next page, the applicant Sudha Krishna Rajok is direct to apply before the BLRO Lapur a collector under the 75 act.
But this was the DLRO's order.
DLRO order.
DLRO is not the collector, BLRO is the collector.
Yes.
Very well. Then
now
it went to that BLRO.
They went to BLRO.
Yes.
Proceeding number 35 of 1992.
Yes.
Now, the Bengali written the copy.
You read out the relevant portions.
I am reading the 77 last paragraph.
77. Yes.
Last paragraph.
All right.
Sudhakar Rajok, Pita Durga Rajok.
Sudhakar are them.
Sudhakar the private respondent.
You read out clearly so that my learned brother can also follow.
Yes.
Sudhakar Rajok.
Sudhakar Rajok, Pitak such and such, 83 মৌজায় এত নম্বর খতিয়ানের শুনানিকালে উপস্থিত করিয়া জানান যে উক্ত খতিয়ানে বিজয় সূত্রধর পিতা মতিলাল সূত্রধর নামে 206 নম্বর দাগে যাহা বাড়ি 8 আনা অংশে 3 শতক রেকর্ড সহ মোট 21 শতক জমি আছে এবং উক্ত বিজয় সূত্রধর পিতা মতিলাল সূত্রধরের কন্যা লক্ষ্মী সূত্রধর স্বামী মহাদেব সূত্রধর হইতেছেন কিন্তু অত্তকরণের রেকর্ড অনুযায়ী দেখা যায় যে বর্ণিত বিজয় সূত্রধর পিতা মতিলাল সূত্রধরের মৃত্যান্তে যাহাদের নামে ওয়ারিশ হিসাবে রেকর্ড হইয়াছে সেখানে লক্ষ্মী সূত্রধরের নামে ওয়ারিশ হিসাবে রেকর্ড নেই বিজয় সূত্রধর ইজ মাই the father. One point raised, I got this property. Lokki got the property from the parental property. So my case is that from parental property, I did not receive any property since records frame in
the other property which you are holding.
No. In the during here.
This is in respect of the other property which you are allegedly holding.
No, I am not holding.
Yes,
Allegedly, what does allegedly mean?
Yes.
So, Ghosh, you are arguing for too long. You are practicing for too long. You will not understand this.
Sorry. Now,
this is regarding that other property.
Other property.
You
property belongs
you
to
got it from like an ancestral property. So, what is your case?
My case as from fathers, I did not get any property. So,
by law of succession, you get property.
But the record of rights.
Record of right is not proof of title.
No. That is thing. The records frame in the name of my brothers. On the basis of title documents. Matlab whether they has any
So
deed
you say even if you had title as per law, you are not holding or occupying the property.
on occupying the
So
property.
you want us to interpret section 2F holds no other land,
No
holds
other
to
land,
mean
yes,
possession,
possess.
not title.
Matlab I have no title and the possession also in respect of my father.
You are denying the fatherhood of your father.
No.
Then
My-
how can you say you don't have title?
Matlab I did not get. Matlab my
You did
other
not get by operation of law, you get.
by operation of if matlab that is not known to me.
Mr. Ghosh, I think we were very clear. Let us not go in circles. Our specific question is that your father owned the property. By operation of law, you got a share in the property. Your case is not that you are not the daughter of your father. If you are the daughter of your father, you automatically get a share in the property title. But you say you are not actually possessing that property. It was never handed over to you. Is this your case?
And
Or
matlab
you
by
deny the fatherhood of your father?
no, matlab by operational law certainly I got this property.
But you are saying you are
But
not
matlab I
holding.
say by registered instrument matlab the property transferred to the other co-sharers.
Where does that come in? That's not recorded here.
Matlab that is not recorded.
You
So
cannot
matlab-
take a new point before this court.
No. For that is matlab record not framed in the
No.
name of.
This is a new case you are trying to make out, Mr. Ghosh, that it has been transferred, registered deed. Nothing was made out before the collector.
No. Since the records, matlab they backed on the title document.
Records do not records of rights do not record your name. Does not automatically mean you don't have title. It means maybe prima facie your possession is not there at best. So on the basis of that, their application was allowed.
No, matlab another thing a lot. Thereafter matlab if thereafter matlab the next paragraph. সুতরাং উক্ত আপত্তিতে অগ্রাহ্য হইতে পারে এই সকল প্রমাণপত্র হইতে প্রতীয়মান হয় যে লক্ষ্মী সূত্রধর মহাদেব সূত্রধরের নামে ভূমি সংস্কার আইনে বাস্তু জমি আইনে বাড়ি রেকর্ডভুক্ত হয়েছিল তা সমস্ত রকম আইন মানিয়ায় হয়েছে কেননা লক্ষ্মী সূত্রধর মহাদেব সূত্রধরের বংশানুক্রমে হস্তশিল্পী ছিলেন এবং জমির পরিমাণ ঊর্ধ্বসীমা নিম্নে ছিল এবং বাড়িটি নির্মাণ করেছিলেন খড়ের ছাউনি মাটির ঘর ছিল Now, matlab that was turned down. Against that, matlab they preferred
So
original.
why turn down? You can't understand this logic. Please repeat this. তাহার সমস্ত রকম আইন মানিয়াই হইয়াছিল কেননা পেশাগতভাবে লক্ষ্মী সূত্রধর মহাদেব সূত্রধর বংশ but the collector does not look into that your other property at all. In the previous paragraph it is recorded that you got it ancestrally, but
Matlab
then it says that the vesting happened.
Now, matlab
You
that
are
is
an artisan and all.
matlab that is recorded.
Because of her
লক্ষ্মী
profession.
সূত্রধরের নামে
Otherwise they do not dispute that you are an artisan or you are not otherwise entitled.
matlab
Their
again
premise is that you had other property. You say you got it ancestrally, not recorded in your name.
matlab again I am reading matlab this property.
No, they
that
need
was-
not. We have said it.
matlab যদি উপরোক্ত লক্ষ্মী সূত্রধর মহাধরের সূত্রধরে তাহার
They do not
বিবাহকাল
dispute
হইতে
you are an artisan. They say
No,
you
no,
had
no,
other
no.
property.
previous paragraph regarding land তাহার বিবাহকাল হইতে অদ্যাবধি স্বামী সম্পত্তিতে বসবাস করিতেছেন এবং দখল করিতেছেন তাহার পিতৃত্যক্ত সম্পত্তিতে কোনো দখল নাই ও বসবাস করেন না that is recorded. Now matlab here matlab my respectful submission is that in my parental property the name of my other brothers was recorded in the record of rights on the strength of matlab some title document. When matlab the authority recorded the name of my other brothers, so matlab they relied upon the title document. For that reasons my name was not recorded in
The
respect
question
to my
boils down to whether hold in section 2F means title
no land.
or title or actual occupation. It boils down to that only.
And matlab again now challenging that matlab the original application file. Now matlab the original application file 2707. Now that was disposed of by the learned tribunal matlab by holding that matlab the BLNLR is not the collector. So matlab again matter was referred to the under section 9 before the district land and land reforms officer, page 81.
Who is actually the collector?
The honorable court matlab that in view of the two sets of judgment the matter finally decided that
So somebody under the act, somebody has to be assigned as a the duty of.
initially in the act, BLRO was given power to act as a collector. Now, when the matter came up before this honorable court,
Now what is the position?
now position is the district land and land reforms
What
officer.
happened in before the district land reforms?
That is at page 81. Appeal under section 9 of the Homestead Act. Now, page 82. That was rejected.
No adjudication at all. Just because your name is recorded there, without considering the other property you have.
Now, challenging that original application file. This is the impugn before in this writ petition. This is learned tribunal. The hell.
Where is that? Which page?
The judgment start from page
85.
85 onwards. The kindly comes to the internal page 6. Now, internal page 6, the last paragraph, learned tribunal held I got 1/4 share of property left by my husband. My husband expired 4th March 1983. So, on that appointed date, no land is there. In the initial original application, the learned tribunal held on that appointed date, the occupier has no land. Now, in this impugned order, this learned tribunal means the subsequent original application did not consider the previous adjudication by the learned tribunal.
That adjudication has been reopened subsequently.
In the first, yes, first round of litigation.
First round of litigation ended with the matter landing up before the DLLR.
Yes.
So up to DLLR you cannot reopen because you are a party everywhere. You submitted to the jurisdiction of the DLLR lastly. DLLR, we do not find any application of mind regarding the actual aspect of their challenge. Tribunal has held that you have other land. This was not considered by the DLLR and has set aside that order and has also held that the vesting is bad.
Now, regarding that, my respectful submission of the learned tribunal below kindly comes to page 6, the paragraph, the
last paragraph.
Last paragraph. The respondent number 6 of the SOA could not be regarded as an occupier and she was not entitled to benefit under the 75 when she had 1/4 of 189 land which she inherited from her husband. My respectful submission, this is the wrong findings. My husband expired in the year 1983.
You inherited from your father.
No, this is from husband.
There is no two properties you have.
No property.
Only their case is that you have 1/4 out of 1.89 of from your father.
No, that is my husband.
A husband.
Yes. Husband expired in the year 1982.
Right.
So on the date of appointed date, I cannot inherit the property from my husband. After the expired of my husband, I along with my 3 sons became the owner of 1/4 property of this land.
You are saying your ancestral property, not your father's property.
Now, in the 2 properties, from father's property, from husband's property, husband expired 82, so that cannot come in
particular land which you are occupying.
Yes.
That belong to your husband.
No, that belongs to them.
Acha, very well. So that has been vested.
Belongs to the private respondent.
Vested.
vested.
So you had two other properties, one from your husband, which you acquired after this appointed date,
Yes.
and another property of the father.
Now, my lord, regarding that, my respectful submission, from father, I did not get any property.
You are not disputing that he is your father.
Yes, I am not disputing that.
Then you automatically, by operation of
Matlab,
law,
by
you get
operation
property.
of law, matlab, that may come, but matlab, when the records frame, matlab, lordship knows, matlab, the recording is backed by title document. So, matlab,
You are not denying that you claim by inheritance. Where is the question of title document?
no, inheritance, matlab, that is not.
You are not. You have never disputed throughout the proceedings that you inherited 1/4 share. You say that was not recorded in your name, and therefore you say you don't hold that property. That is your consistent case.
Now, my consistent case, matlab, after my marriage, I am deciding my matrimonial home.
So after marriage, you are deprived from your father's property.
Yes, matlab, that is my case. That is
the law.
Now, matlab, that is recorded here. Now, matlab,
That is recorded where?
matlab, in that, matlab, the BLRO proceeding, matlab,
BLLO, the arrest records, the authorities, the BLLO has the right to decide title.
no.
Then
Now, matlab, only regarding that, my submission, matlab, regarding my father's property, my property not recorded in the name of
Your
my
name.
name, since and my name of my brother. Now, matlab, this is not clear here, matlab.
Mr. Ghosh, recording of name of a person in the records of right, does it confer or take away title?
No, matlab,
What is the law on that?
now, matlab, if I say, matlab, this way, if matlab, that is
You
not,
answer, it can be yes or no. Does it confer?
no, matlab, that by way of
We are asking for a yes or no answer. First answer our question, then make your argument. Does recording in records of right confer or take away title?
no.
No. Then what is your alternative case?
Now, matlab, alternative case, matlab, when the records frame in the father's property records frame in my name of my brother, so matlab, that may
Does
be
it take away your title?
that may be matlab, some gift deed may done.
Maybe we are not on
that
maybe.
is
You
not,
did not prove your case.
matlab, that is not here for that reasons, matlab, the records not framed in my name.
It was your owners, Mr. Ghosh. That inquiry was never gone into at the time of the land being vested in you. It was your owners all along. You have not even pleaded that there was any transfer. You could have conducted a search and produced the documents, or even the deed number to show that there was a transfer in their favor. How do you know? In the absence of anything else, and in view of the admission that you are the daughter of that person who left that property, despite the names being recorded of your brothers, you have 1/4 share there. Unless you show it's your owners to show that there was a transfer in there.
Not in that even, matlab, kindly direct, matlab, the section 9 authority to, matlab, decide this issue afresh.
But you have never pleaded that there was any transfer. Why should it be relegated again?
What I am on, matlab, this is a, matlab, the settled law. Matlab, mutation is the prima facie evidence of possession backed by title document. Matlab,
We are going in circles, Mr. Ghosh. Let us hear them. Yes, what do you say? What is the interpretation of hold? Should not be.
Kindly read 2F.
Yes, come to 2F. Holds no other land in any capacity whatsoever. We will come to you also. You are the affected party here.
Occupier means an agricultural laborer or an artisan or a fisherman who is in possession of
First
any
part,
land
no difficulty.
of-
Held that she is an
Yes.
artisan.
Yes, of another person, either as a lessee or as a licensee or as a trespasser, and who holds no other land in any capacity whatsoever, and includes the heirs of such person.
So the use of the words in any capacity, doesn't it indicate that holds means possession? Because we have to be on a parallel footing. We are arguing for them. Because the scheme of the act is that if they don't have any other property, hold any other property, they are entitled to this property being vested in them. Since they're in possession of this property, they are in possession of this property. Their possession in respect of the other property not shown.
Kindly read this
Yes.
along with the preamble of this act.
We were going through the preamble. So what is your take on that? We were going through the preamble.
This is for those people who are downtrodden people. For them, this act provides vesting of that particular land.
Absolutely. But
So
is
keeping
she
in
equally
mind,
downtrodden?
if he or she is already owning a land, well, then, my lord, it entitles her or him.
The brothers are in total occupation, so she has to go and file a suit.
After
Even then-
all, title is there.
All right. So you say this hold should include title, not only possession.
Absolutely. Well, kindly come to the preamble.
Preamble you have seen, yes. Preamble does not give an indication on holds.
No, no.
Purpose of this
The
statute?
purpose of the statute.
Yes, because by vesting you are conferring ownership in a sense.
And he gets, the owner of the land
He
gets.
becomes owner of two properties then.
Absolutely. And somebody's land is getting vested.
True. True. Let us say them. Yes.
My lord, actually, this petitioner was the tenant under the SO number 6. We filed an eviction suit, we got a decree. In appeal, they submitted that it has been vested in their favor. And appeal, we lost the appeal. Then, my lord, this process has to take place. Only point is that, my lord, landlord even submitting that at the relevant point of time, whether he has any property or when they make an application before the concerned authority for vesting or patta, at that time he has or she has been property
No,
or
the
not.
father died after this appointed date.
Before.
Before.
Before. And husband died thereafter, 1982.
Husband died thereafter. Regarding the husband property, the reasoning of the impugned order of the tribunal is wrong, because the husband's property was the basis of the tribunal's order.
Husband property, my lord. This
Because the tribunal goes only on the husband.
husband and father, both.
Father, where is the finding?
Father to the
Show us the finding regarding father.
In that paragraph also.
This is page
Page 89.
मतलब page internal page 6 bottom portion.
89.
It is-
89 or 90?
89. Regarding the aforesaid bottom, my lord, section 2F.
Yes, reading the aforesaid.
Reading the aforesaid section 2F and section 4 of the Act 1975, simultaneously there cannot be an hesitation of a judicial quasi-judicial authority to understand that 26 June 1975 occupier under the Act in respect of his or her claim homestead, which is land another person, must not held any other land in any capacity whatsoever. If he or she had even a square inch of land in his capacity on 26 June 1975, such person cannot be said to be occupied in respect of any other land of another person under such act. In consequence, such person cannot claim benefit of any provision of section 47 of 1975, section 2F speaks that.
No, not these. Where is the consideration regarding the father's property? The last paragraph subsequently, as Mr. Ghosh was pointing out.
On the last two lines, it is the settled law that inheritance must not remain in.
That is in vis-a-vis the husband. Let us come to the first line. Accepted responsibility as an occupier.
No, that is not there.
Entirely on husband.
Yes.
No, and that she had no homestead land, that the land which she inherited from her father was not recorded. This is also there. Such view comes from misconception of law regarding father. That finding is there.
Each question and
এটার সাথে 76 টা পড়িয়ে দাও।
my lord, your lordship kindly come page 76 first. I mean, it has been categorically discussed, my lord. 76 middle portion.
76 no longer remains relevant after it was set aside. 76 we cannot look at.
Yes.
We have to look at only the tribunal's order, because the DLLR also did not look into the matter at all. DLLR only proceeded on the basis she is an artisan and therefore she is otherwise eligible.
Non-sleeping order.
No, not right. That we understand. No, tribunal said, we reiterate that a person who holds even a square inch land that is flowing from that father's property.
Kindly 87 bottom, 87 bottom. The only dispute.
No,
is
90. Please come to 90 directly.
90.
90 first few sentences is on father.
The person under section so in consequence, such person cannot claim benefit of any provisions. To speaks of automatic acquisition. You have to consider discussion subsequently. Yes, my lord. Subsequently, that case number 3592 RO accepted the respondent number 6 of this way as occupied on the ground that she inherited 1 foot share in 1.89 acres of land of her husband, which is less than 100 acres, and that she has no other land which she inherited from her father. Vijay was not recorded in her name, and she did not possess that land or house in homestead left by Vijay. Such view also comes from misconception of law. We reiterate that a person who held even a square inch of land other than the subject land cannot be considered as an occupier under 47 or 75, and therefore the respondent number 6 of this way could not be regarded as occupier and she was not entitled to get any benefit of 47/1975 when she had 1/4 of 1.89 acres land which she inherited from her husband. More so, she inherited landed property led by her father. It is no matter whether said land was recorded in ROR in her name and whether she had active possession in such land or not. It is the settled law that inheritance must not remain in abeyance and that possession of one co-share of a joint property tantamount to possession of each co-sharer in the entire joint property, and that record of rights neither creates nor distinguishes title of any person to landed property.
Reply.
The occupation, my respectful saying, occupation means the occupation in the property in question.
Physical
So,
possession, actual
physical possession is
The present challenge has been preferred against the order of the West Bengal Land Reforms and Tenancy Tribunal, whereby the original application filed by the private respondent was allowed, comma, thereby holding that the vesting of the land in dispute in favor of the mother of the present writ petitioners under section 4 of the West Bengal acquisition of homestead land for agricultural laborers, artisans, ARTISANS, and Fishermen Act, 1975 was illegal. For the next para, learned counsel for the petitioner submits that there is a checkered history to the matter. First up, initially, the land in question was vested in favor of the petitioner's mother. First up, next para. Subsequently, however, such vesting was challenged by the original owners, being the private respondents, by way of an application before the tribunal. First up, the tribunal relegated the matter. The tribunal, having adjudicated the same, such adjudication was challenged in a writ petition. First up, the writ court relegated the matter to the collector. First up, upon such relegation, the concerned block land and land reforms officer adjudicated the issue, full stop. Thereafter, the matter went up to the tribunal, which held that on the relevant date, it was the district land and land reforms officer and not the BL and LRO who was the collector under the 1975 Act. First up, accordingly, the matter was remanded to the BL and LRO for adjudication. DL and LRO for adjudication. First up, it is submitted that the DLRO turned down the challenge of the private respondents, which was upset by the tribunal. First up, learned counsel submits that the mother of the present petitioners, being an artisan and an occupier of the disputed land on the appointed date as per the 1975 Act, that is on June 26, 1975, the learned tribunal acted without jurisdiction in setting aside such vesting. First up, it is argued that the tribunal proceeded primarily on the premise that a property belonging to the deceased husband of the writ petitioner's mother, within bracket, that is the writ petitioner's father, bracket close, only devolved upon their mother on the demise of their father, which happened after June 26, 1975. Full stop. It is argued that once the land vested under Section 4 of the 1975 Act, the same could not be divested by taking into account subsequent acquisition of property by way of inheritance from her husband. Full stop. Next para, learned counsel further submits that one of the premises of challenge by the private respondents was that the mother of the writ petitioners, the occupier, also became entitled to a portion of an ancestral property on the demise of her father, along with her 3 brothers. However, learned counsel argues that the records of rights in respect of the said ancestral property indicate that the three brothers are in exclusive occupation of the same. Full stop. The name of the writ petitioner's mother was never recorded in respect of the said property, comma, thereby indicating that either there was a transfer in favor of the brothers of the writ petitioner's mother, or that the writ petitioner's mother never held such property at all. Full stop. Thus, comma, it is argued that the learned tribunal misdirected itself in holding that the vesting in favor of the writ petitioner's mother was illegal. So next para, learned senior counsel appearing for the state points out that in terms of the preamble of the 1975 Act, comma, read with section 2 within bracket F thereof, comma, it has to be construed that if a person, comma, even if an artisan, comma, is entitled to a different property on the appointed date, comma, he or she would not be entitled to vesting under section 4 of the 1975 Act in view of the specific bar stipulated therein. For some next para, learned counsel appearing for the private respondents, comma, in unison, comma, argues that the land disputed property belonged to the private respondents. Full stop. In view of the devolution of title in favor of a part of the ancestral property of the mother of the writ petitioners, comma, the latter could not be labeled as an occupier within the contemplation of the 1975 Act. Full stop. Upon a careful consideration of the arguments of parties, comma, we find that the district land and land reforms officer, comma, acting as collector, comma, did not advert to the acquisition of other property by the writ petitioner's mother at all, and proceeded merely on the premise that the said mother was an artisan on the relevant date, and accordingly the land was vested correctly under section 4 of the 1975 Act. Full stop. Thus, comma, the learned tribunal was justified in re-adjudicating the issue on all relevant aspects of the matter. Full stop. There were two premises of the judgment of the learned tribunal. Full stop. Insofar as the devolution of a further property in favor of the writ petitioner's mother by dint of the demise of her husband is concerned, comma, we agree with the contention of the writ petitioners that since such devolution occurred subsequent to June 26, 1975, comma, the appointed date under the 1975 Act, comma, the same could not have a germane bearing on the issue at hand. Full stop. This is because once a land is vested under section 4, comma, on the position as it stood on June 26, 1975, comma, an indefeasible right, title, and interest accrues in favor of the vestee, and the said title cannot be divested on some subsequent post facto occurrence. Full stop. Next para. However, comma, we are unable to accept the contention of the writ petitioners on the other facet of the adjudication of the learned tribunal, comma, to the extent that admittedly the writ petitioner's mother was the daughter of the person who owned another land, and that the father of the writ petitioner's mother had died prior to June 26, 1975. Full stop. Next para. The question which arises is whether, comma, in view of the said mother's name not being recorded in respect of the ancestral property on the demise of her father before June 26, 1975, comma, it can be construed that the said other property was held by the writ petitioner's mother within the contemplation of section 2 within bracket small f of the 1975 Act. Full stop. To construe the real significance of the expression double inverted mode holds, HOLDS, double inverted clause, used in section 2 within bracket small f, comma, we would impart an extremely restricted view to the statute, comma, keeping in view its object to facilitate the vesting of land in favor of artisans, fishermen, and agriculturists agricultural laborer who come from the marginalized sections of society. Full stop. The very fact that such a person owns another property, comma, even if he or she is not in actual physical possession thereof, comma, denudes the cloak of protection given to such person on the very premise of the helplessness, comma, since such person comes from the marginalized sections of society. Full stop. A person having title even in a portion of a different property, comma, if clothed with the right of artisans, comma, fishermen and agricultural laborers who are entirely landless, comma, would defeat the very purpose of this statute. Full stop. Next para. We also have to keep in mind that the 1975 Act is an artificial intrusion on the right to property of the person in who is the actual owner of the vested property as on the date of the vesting. Full stop. Although Article 300 capital A of the Constitution has been taken out of the fold of fundamental rights, comma, fact remains that the true owner of a property has a vested right in a property unless such right is taken away by statute. Full stop. In such view of the matter, comma, the statute in question has to be read strictly so as to ensure that a balance is struck between the title of the original owner and the beneficiaries of the beneficial legislation, comma, so as to make it so as to ensure further that persons who are not strictly entitled to the benefit of the statute do not take undue advantage of the same. Full stop. Next para. In the present case, comma, the writ petitioners and or their mother have failed to plead or prove that the ancestral property of the mother was ever transferred exclusively to the brothers of the said mother. Full stop. Next para. That apart, comma, since it is an admitted position that the father of the writ petitioner's mother met his demise prior to the appointed date, that is June 26, 1975, and the devolution of a title in a portion of the property, that is 1/4 share in respect of the ancestral property, happens by operation of law. Full stop. Thus, comma, even if the writ petitioner's mother was not in actual physical possession of the property, ancestral property in question, comma, it is a settled legal fiction that the possession of any of the co-owners is deemed to be the possession on behalf of all the other co-owners, comma, including the mother of the writ petitioners. Full stop. Next para. That apart, comma, we are also to look at the fact that upon a vesting occurring under Section 4 of the 1975 Act, comma, the person on whom such property is vested absolutely has ownership rights for all practical purposes, comma, defeating the rights of the original owner without any fault of the original owner. Full stop. In such circumstance, comma, we have to construe the expression double inverted holds as used in section 2 within bracket F on a parallel footing as a right which the statute intends to vest on the occupier. Full stop. Therefore, comma, if a person already owns a portion of a property prior to such vesting under section 4, comma, a double benefit cannot be given to such person by vesting the property in her favor by taking advantage of section 4 of the 1975 Act, comma, thereby making her the owner of both the properties simultaneously. Full stop. Next para. Keeping in view such aspects of the matter, comma, we are of the opinion that the learned tribunal was perfectly justified in holding that the vesting in favor of the writ petitioner's mother was illegal, comma, since despite her being an artisan on the appointed date, that is June 26, 1975, comma, she did not come within the definition of double inverted occupier under section 2 within bracket small f of the 1975 Act, comma, since she held other land in the capacity of a co-owner in respect of her ancestral property. Full stop. Accordingly, WP LRT 111 of 2023 is dismissed. Full stop. Dismissed on contest. full stop, can 1 of 2023 is also disposed of accordingly. No address to cause certain settlement.
Deeply applies.
I'm deeply upset.
এই হোমস্টেড অ্যাক্ট একটু আনিয়ে নেবেন তো, এই এটা রেখে দিন একটা কপি, আবার ঢুকিয়ে দেবেন, অ্যাক্টের নামটা ঢুকে নেবেন। এটা ওয়েস্ট বেঙ্গল লজে পাওয়া যাবে, আলাদা করে বইটা নাও পাওয়া যাবে, ওয়েস্ট বেঙ্গল লজে থাকবে, ওরা পাঠিয়ে দেবে library, যেখানে আছে। নেক্সট ম্যাটার।
সাফ টাফ করেছিস?
But I'm for the petition. I'm
Yes, sir.
challenging an order passed by the Land Reforms Tribunal.
সাফ করেছিস?
That is the most crucial question.
Yes.
Mentioning এর আগে করা হয়েছে।
Mr. Soumitra Bandyopadhyay was appearing on the last of
Yes.
But, in fact, apart from him, Lord, I require, Lord, the private respondent because this pertains to, Lord, mutation.
Was it appearing? It was appearing before another bench. Should we request you to serve another copy on Mr. Soumitra Bandyopadhyay, Priyobroto Bhattacharya were appearing for the state, so there is no issue regarding that.
Apart from them, Lord, the private respondents are required.
Are you enjoying any interim order?
No. My scope of challenge is very limited. Lord, I purchased the property and I mutated my name.
Yes.
But there was a counter contention of title. On the basis of that, Lord, there was a recording of, Lord, the Nitai Lord Mundol's name in, Lord, the record of rights pursuant to the order passed by the BLNR. Now, Lord, that was set aside in the appeal under 54A.
No, initially after purchase, it was recorded in your name.
Recorded in my name.
Then Nitai came.
Then they said that they are the title holder and, Lord, applied for, Lord, their name being recorded. It was, Lord, turned down. They went up in appeal. The appeal court, Lord, said that because there is a pendency of, Lord, a civil proceeding, I'm sorry, Lord, I stand corrected. Initially, the BLLRO said that since there is a civil contention concerning the title,
Civil suit between you and Nitai.
no, that was not subsequently. That was subsequent.
Civil contention আছে.
Civil contention. Therefore, Lord, he is not going to, Lord, change the mutation.
Oh, he said he won't.
No. Thereafter, Lord, it went up before the appeal. I'm omitting, Lord, certain facts because in the meantime, there had been back and forth between, Lord, the first appeal and, Lord, the BLL.
Very well. Let us.
Ultimately, Lord, in appeal, Lord, it was held that the BLLRO could not have decided a civil contention. And therefore, Lord, the order passed by the BLLRO in favor of, Lord, the private respondent Nitai, that
No,
was
you
set
said that
aside.
BLLRO said that this is a civil contention, so he cannot go into it.
Lord,
He proceeded
to change, Lord, the record of rights,
Yes.
holding that, Lord, Nitai Mondal had the right and his name should be recorded.
Acha. Now, Nitai
That is
Mondal, what is
BLLR.
the basis of Nitai's claim?
But he is claiming, Lord,
Heir of your vendor.
year of my vendor. My vendor
But you
had,
produced your title deed.
my vendor had, Lord, 6 years according to them.
Ah.
But this particular property from which I had purchased was recorded in the name of one of the daughters. So there was a chain of, Lord, transfer through one of the daughters in whose name it was recorded. Ultimately, the property has, Lord, devolved upon me and, Lord, pursuant to the deed that was executed, I had my name, Lord, recorded.
But you purchased not from the daughter, but
From Lord, the subsequent purchases.
So they purchased from the daughter.
her grandsons.
Daughter to the grandson and
It goes to the, it goes back to the source of the daughter. The daughter was the original vendor or the main.
one of the daughters. Out of 6 daughters,
One of the daughters sold the entire property to you,
not to me,
to your predecessor in interest.
a portion of it.
So therefore, Nitai Shah obviously would be a co-sharer.
No,
No.
Nitai claim-
Nitai claims through, Lord, the other
Parallel,
daughters,
a
parallel daughters.
Yes, therefore they also had right title in the property.
They say,
How can you deny that?
they say that other 5 daughters of my, Lord, the predecessor vendor, they were also, Lord, the legal heirs,
Right.
in respect of that property.
Apparently right. Yes.
Lord. And, Lord, so far as my purchase is concerned, he do not challenge that. He
You
says that
you
the
cannot be the
survive.
exclusive. It cannot be mutated exclusively in your name
No, Lord,
because
so
there was
far
no
as-
partition.
So far as, Lord, the extent of purchase by my client,
Yes.
that should be mutated because subsequently when he filed a suit,
Hmm.
in that suit he did not challenge my title deeds.
No.
Secondly, in
I
the
appreciate. But Mr. Mukherjee, unless there was a partition by meets and bounds, one of the co-sharers transferring, you cannot transfer a demarcated portion. So how can it be mutated? That demarcated portion be mutated in your name?
No, Lord, here, Lord, what the tribunal has held, that since there is a title suit pending at the instance of Nitai for a declaration that he is the owner in respect of this land, Therefore, the PLLRO should await till the decision of the civil court. My argument will be, when I take your lordship to the plaint, not the property is not dag number, LR dag number 1087. So, Lord, 1087 is not the subject matter of the suit, first of all. Secondly, Lord, in the suit, your lordship will not find that there is a challenge to the purchase deed of my client. Therefore, Lord, relegating it back to the BLLRO after decision.
No,
of the civil suit,
it's not a subject matter of the suit. Suit is for declaration of his exclusive title.
in respect of Lord 1081 plot number. Whereas
Not this plot.
No, this is not concerning one.
So in the suit, Nitai does not even claim any title regarding this plot.
Lordship. That is the reason my challenge will be in a very short ambit, that relegation of Lord this to the BLLRO on the pretext of Lord the suit being pending, when the suit doesn't challenge my title deed, or it pertains to
So
the
you
dag
would
number.
actually
is not
be happy with us remanding it to the LRTT by asking the tribunal to proceed on the basis of whatever material there is and clarifying that this is not a subject matter of the suit and that
Yes.
there is no challenge in the suit to your title deed.
Yes.
So on the premise of that, whatever may be the.
Lordship. Lordship.
But our conscience is not satisfied that because there is no partition of the property, how could it be? Anyway, we won't go into that.
Without
We
the
may not.
partition, Lord, by dint of Lord the purchase,
One of the co-sharers sold.
the co-sharer sold Lord, not the entire property, a part of the property.
A part of the property, demarcated part, she cannot have a right.
Lord, it
They
is
also have right over a branch.
undemarcated portion, she has a right to sell.
But then how can it be mutated?
But
It has to be
this is
mutated
muted.
as a co-owner. You can be muted. Your name can be mutated.
But in respect of that dag number, my name can be mutated with reference to the area purchased in the dag number. Suppose in that particular dag number 1087.
It's a share ultimately.
Yes, that is
That
a share.
that area, that share covers the entire property. How can there be mutation?
Your lordship has seen the record of rights. The entire dag area is mentioned.
Yes.
Thereafter, Lord, the percentage owned by Lord the record.
That is what we are saying. That can be recorded.
That is what I see. That is what I see. I cannot ask for a recording of Lord the shares which I don't own.
No, obviously. Let us see the order of the tribunal once.
Yes, Lord.
And you will also show us, Mr. Mukherjee, obviously the schedule of the plaint.
Lord, that has been taken in the supplementary evidence.
Whatever.
কিন্তু ট্রাইব্যুনালে ফাইল হয়নি
Not filed.
No, Lord, there is one difficulty. I must first admit.
No, no.
Huh?
It was the case. They only referred to the
I know that.
title
I
suit
know
in
that.
the
That's the
written
reason
notes.
That's the reason I see. Because in the written notes, Lord, before the tribunal, it was mentioned by Lord the appellant therein that there is a civil suit pending in the year 2020.
The plaint, have you got a copy at all?
Now that I got a
Now you have got a
yes,
copy.
and I have given that Lord by you have a supplementary affidavit.
That was filed.
Yes.
Yes, but
No
the
copy given?
tribunal was not Lord benefited Lord by this plaint at that point of time. That is what
Even then we can look into instead of
Very good. Lord,
unnecessarily. Supplementary affidavit has been served on the other side.
It was served in court.
You are sure?
Yes.
You are sure?
Yes. But you will kindly come to Lord page.
Yes.
Lord, that is the impugned order.
Yes.
The original application has been filed challenging the order of the appellate authority.
No, but BLL, Mr. Mukherjee, in the same breath, directed it to be mutated in the name of Nitai and also said it should await the civil court.
No.
The DL recorded in our name.
Yes. The
And-
Lordship will kindly see the DLLRO's order.
Let us see that.
That is at page, Lord, the operative portion is 205.
205, yes.
Is directed to revert and sustain the shares appertaining to the appellant in regard to the suit property as they existed on the erstwhile orders initiated
Lower
before.
court come
This was
respondent
not
means?
the appellant means
No,
I was the appellant.
lower court come respondent, what is that?
Lower court means not the
DLLR.
BLLR.
This is a
He is
DLLR.
referring to BLLR. This is the DLLR's order in 54. An appellant here is my client. Because I challenged Lord the order passed by the BLLR.
So your appeal was upheld.
My appeal was upheld, giving rise to the application by Lord the Nitai in the tribunal.
So it was completely in your favor.
It was in my.
They challenged and then
challenged
the
before the
PLA
tribunal.
Acha.
Now kindly come to the tribunal's order.
Yes, yes.
Now, Lord,
You can come to page 3 directly if you
Lord,
want.
I'll rather, Lord,
Yes.
just page 1, the fact contained in the
Yes.
way in nutshell, the case land comprised in LR plot number 1087.
Right?
I stop at that.
Yes.
Nothing more there. Then, Lord, how it has devolved 44 decimal Kumudbala. Kumudbala had 6 daughters. As I was saying, it was erroneously in the name of Rijubala and Rijubala to others. Lord, the derivation of title are there. Then, Lord, how the proceedings, Lord, went on, Lord, that has been narrated. Then, Lord, kindly come to, as your Lordship said, page 3 after hearing both the parties.
Yes.
And after producing the entire materials on record, we do hold that when the applicants have filed title suit before the learned civil court for asserting the right, title, and interest over the case land, the revenue authority should act in terms of the judgment of the civil court for the purpose of preparation of the record of rights of the case land in the name of the parties. When there is a backdrop of series of mutation applications pending and disposed of, and when there are series of transfers of the case land, the civil court is the appropriate authority to ascertain as to whether any challenge deed has any force to convey title and interest to the transferee, whether any challenge deed has any force to convey the title. Kindly mark this. There is a specific that some registered sale deeds were executed by the parties and the genuineness of the deeds were challenged by the other parties. The revenue authority is not the appropriate authority to ascertain as to whether any challenge deed can be banked
So
by
obviously,
the purpose.
Mr. Mukherjee, have seen the tribunal was obviously uninformed of the suit not containing this.
The suit, not about the suit, it was contained in the written notes. That I mean, the applicant's written note, Nitai Mondos.
Right.
But what was contained in the suit, that was not before the tribunal, because nobody filed that. They only informed about the pendency of the suit.
That's what we were saying. It was uninformed about the contents of the plaint.
So, that is exactly
This
where
might have been otherwise upheld by us. We are being very candid, Mr. Mukherjee.
Lordship.
Because yes, really the civil court had to, there is no error apparent on the, I mean, no palpable error. But if you say the property is not included in the suit,
this is I'll just be.
We'll remand it to the tribunal to
Lordship.
take note of that.
Lordship. Now your Lordship will kindly come to Lord, the
supplementary.
The supplementary page 92. Lord, page 92 is the prayer. I should start from Lord,
yes,
the plaint, because your Lordship will see Lord page 88, who are Lord the plaintiffs. The Nitai Mondal.
No, that you are saying we will go by your.
Lord, I may be
we are
wrong,
not
but
so suspicious of counsel.
Nitai Mondal and my clients Sanjay Shah and Anna
But
Shah,
we want to satisfy just our conscience regarding the property not being a subject matter.
That is, Lord, I'll come.
That we have
come to that. This is Lord valued at 300 rupees. Then Lord, page 92 is Lord, plaintiff are therefore prayed that your honor would graciously be pleased to pass an order that a decree declaring the plaintiff have right, title, and interest and possession of the suit property against the defendant number 1 and 2. Decree in permanent injunction declaring defendant number 1 and 2, restraining the defendant number 1 and 2 from forcibly and illegally occupation in the suit property and from making any attempt.
Actually, Mr. Mukherjee, the other point which we were raising were not even raised by this person. He does not ask for a partition. He wants also exclusive title regarding a different
No
plot.
partition, no challenge to the deed. Secondly, my lord, kindly come to the schedule. Your lordship will find 1019.
Different.
The tribunal has held 108.
We'll do this, Mr. Mukherjee. We'll take note of this supplementary affidavit, this plaint. We'll remand the matter to the tribunal, subject to what you say. Remand it to the tribunal to take note of the fact that this property is not contained in the schedule of the plaint, and that whatever argument you are making, that your deed has not been challenged and no partition has been claimed. Therefore, in the light of those, taking into consideration the plaint to re-adjudicate the issue. So that would serve your purpose. Acha, notice previously was given to private respondents.
Yes, my lord, before the matter was mentioned before your lordships,
Private respondents also?
Yes.
Oh, very good.
Because their advocate, one Mr. Satyajit Tripathi, was appearing on the first occasion.
So you better file that, yes.
Should I file it in form of an affidavit?
Advocates, you served on advocates.
Yes.
Why affidavit? The receipt in respect of mentioning of the matter filed today by learned uh, filed today on behalf of the petitioners be kept on record. Full stop. Despite service, none appears either for the state or the private respondents. Full stop. Next para. Learned senior counsel appearing for the petitioners contends that the matter, the genesis of the matter is the mutation of a property in respect of the present writ petitioners by on the strength of their purchase from one of the daughters of the original owner of the property. Full stop. The purchase, comma, it is contended, comma, was in respect of LR plot number 1087, comma, Mouza Kodampur, comma, JL number 25, comma, measuring 0.27 acre. Full stop. It is submitted that initially such mutation was effected in favor of the writ petitioners. Full stop. However, comma, subsequently on the same being challenged by the private respondents, comma, the BA concerned block land and land reforms officer, comma, after an initial round of litigation, comma, ultimately observed that since the dispute was civil in nature, comma, the mutation standing in the name of the private of the writ petitioners would not be cancelled. Full stop. Challenging the same, comma, an appeal was preferred by the private respondents before the appellate authority, that is the concerned SDL and LRO, who, comma, by the order impugned before the tribunal, comma, decided the rights of the parties at length and ultimately came to the conclusion that the recording that the mutation ought to be reverted back in the name of the private respondents, comma, who are the heirs of the original vendor, original owner. Next para, the writ petitioners challenged the said order before the tribunal. The learned tribunal, comma, by the impugned order, comma, came to the conclusion that the decision passed by the revenue authority was the correct decision, wherein it was observed that the dispute is civil in nature and that it can only be adjudicated by the civil court. Accordingly, the direction contained in the judgment of the appellate authority was set aside. However, comma, while doing so, comma, the learned tribunal observed that liberty was granted to the parties to approach before the BL and LRO after disposal of the civil suit filed by the private respondents, along with the judgment for the correction of record of rights of the case land in terms of the said judgment of the civil court. Next para, learned senior counsel argues that since a specific area of the property in question was sold by one of the heirs of the original owner in respect of a particular plot, comma, there could not be any impediment in mutating the name of the petitioners in respect of the said portion of the property. Next para, secondly, comma, by placing reliance on a supplemented affidavit filed in this court, comma, annexing a copy of the plaint of the pending suit, comma, it is argued that in the said suit, that is title suit number 355 of 2023, pending before the learned civil judge, junior division, first court at Barasat, comma, district North 24 Parganas, comma, neither the sale deed in favor of the writ petitioners was challenged, comma, nor was the plot number in dispute at present a subject matter of the said suit. As such, comma, the very premise of the postponement of the consideration by the learned tribunal till after the disposal of the suit has been challenged. Mr. Mukherjee, your client, your stand is that this is the only suit pending. There is no other suit pending regarding this property.
It is Nitai Mundo's case before the tribunal that they have filed a suit in the year 2020.
This number was given.
This
Number was never given.
Number was also not given. In
Very
the
well.
written notes, they have only mentioned.
The number was not given there also.
No.
Very
We
well.
subsequently took out this and then found out what the scope of this.
জজ সাহেবকে দেখিয়ে দাও না রিটেন নোটস এর ওই একটাই
Upon hearing learned senior counsel for the petitioner and perusing the materials on record before us, we find that the plaint of the suit allegedly filed by Nitai Mondol and others
this is the only one
does not contain the subject property in the present dispute, that is plot number 1087, as the subject of the said suit. Full stop. Moreover, the sale deed in favor of the present respondent, present writ petitioners in respect of plot number 1087 has also not been challenged in the said suit, nor has any partition been sought or any claim been made that that plot number 1087 is a joint property. Full stop. Next para. In the before the tribunal, the private respondent filed a written notes of arguments where it was merely mentioned that the private respondent had filed a suit before the civil court. Full stop.
And same is pending.
And that the same is pending. Full stop. Since it was not the case of the private respondent even before the tribunal that multiple suits are pending, and the present writ petitioners have furnished the copy of the plaint of a suit filed by the said Nitai Mondol and others, which is in respect of a property different than plot number 1087, and where the title deed in favor of the writ petitioners in respect of plot number 1087 has not been challenged, we are of the prima facie opinion that the pendency of the said suit cannot by itself be a reason for postponing the adjudication regarding the mutation of the plot in favor of the writ petitioners unnecessarily. Full stop. Next para. However, we leave it open for the tribunal to adjudicate on the issue as to whether the challenge to the setting aside of the mutation in the name of the writ petitioners can be adjudicated by it in the teeth of the plaint of title suit number 355 of 2023, not containing as the subject matter of the said suit the present plot, and since there is no challenge before us to show in respect of the sale deed of the writ petitioners in respect of the said plot. Full stop. Next para. Accordingly, WP LRT 76 of 2024 is disposed of by setting aside the impugned judgment of the Tribunal of the West Bengal Land Reforms and Tenancy Tribunal in OA number 1159/2023 within bracket MA number 460 of 2023 bracket closed, above within bracket LRTT bracket closed, dated March 15, 2024, and remanding the matter to the tribunal for a fresh consideration in the light of the observations made above, as well as the plaint of title suit number 355 of 2023 pending before the first court of civil judge junior division at Barasat district, North 24 Parganas. Full stop. The learned tribunal, the learned tribunal shall rehear the matter on merits in the light of the above observations, upon giving adequate opportunity of hearing to all concerned, all parties, to address the issues before it. Full stop. It is expected, in view of the long pendency of the matter, that such exercise shall be concluded by the learned tribunal as expeditiously as possible, preferably within, it's very hard pressed, 8 months from the date of communication of this order to the tribunal. Full stop. No orders to cause urgent certified copies.
Much obliged. Thank you. But may I rely upon the supplementary in the tribunal below? Because these are not part of the documents. That's the reason.
একটা line add করে দিন. It will be open to the writ petitioners to rely on the contents of the supplementary affidavit filed before this court, including its annexures before the learned tribunal. Full stop. If so, comma, the respondents, including the private respondent, shall be at liberty to controvert the same by filing counter affidavit and arguing on the same.
I'm great. I'm great.
Single नहीं है आज के. Oh.
My lord, in this matter, I am appearing on behalf of the petitioner, my lord. My lord, this is, my lord, for a direction upon the learned tribunal.
Expeditious
Your name should not be recorded.
Not certainly, if you
Even her name should not be recorded. You both of you are competent enough to contest these matters.
fully agree. My lord,
Date has been
last but one page.
Yes.
29th April is the date fixed. 2026.
What is the stage of the matter? The challenge arises from what? What sort of a challenge?
What's consideration or representation by the PLA?
So direct that to be done directly. Will render this infructuous.
Yes.
What representation regarding what?
147. Representation, my lord, for correction of record of right.
He is more prepared than you. In your...
147, but there
Yes.
are private respondents. Oh. There are private respondents?
No, we'll direct the. You have served on the others.
Yes, yes.
We'll direct a notice to be given to the others, right of opportunity of hearing to be given to others. Who has to consider BLLRO?
PLLRO, Sirampur.
Very good. Learned counsel appearing for the petitioner expresses anguish at the delay occasioned by the learned tribunal in disposing of the original application of the writ petitioner, comma, seeking merely an expeditious disposal of the representation of the writ petitioner by the respondent number 3, that is the Block Land and Land Reforms Officer, comma, Sirampur-Uttarpara. Full stop. Next para. It is contended that the next date has been fixed by the tribunal on April 29, 2026. Full stop. Upon hearing learned counsel for the petitioner and the learned senior government advocate, comma, we are of the opinion that in view of the innocuous nature of the order proposed to be passed, comma, further service of notice on the private respondents in respect of the writ petitioner is deemed redundant. Full stop. Since now to evidence that service has already been effected, to show that the service has already been effected on the on all the respondents, comma, affidavits of service are filed today, which are kept on record. So next para. Since the entire dispute before the tribunal is the delay in disposal of the representation of the petitioner by the respondent number 3, comma, we are loath to relegate the matter to the tribunal for a futile exercise and instead choose to direct the respondent number 3 to dispose of such representation from the present proceeding itself. Full stop. Accordingly, where is the representation? Which page?
147, Lord.
147.
Dated 26th March 2025.
Accordingly, WPLRT 145 of 2025 is disposed of by directing the respondent number 3 herein, that is the Block Land and Land Reforms Officer, comma, Sirampur-Uttarpara, to dispose of the representation dated March 26, 2025, given by the writ petitioner, comma, as annexed at page 147 and 148 of the present writ petition, comma, upon giving adequate opportunity of hearing to all interested persons, comma, including the private respondents, as well as the state, comma, in accordance with law as expeditiously as possible, comma, preferably within 8 weeks from the date of communication of this order to the respondent number 3. Full stop. Next para. It is made clear that the that this court has not gone into the merits of the contention in the representation, and it will be open to the respondent number 3 to decide on the same in accordance with law. Without being prejudiced by any of the observations made herein. Full stop. Consequentially, comma, OA 1471 of 2025 within bracket LRTT pending before the second bench of the West Bengal Land and Land Reforms and Tenancy Tribunal is deemed to stand disposed of. Full stop. No orders to cause urgency.
Instead of 8 weeks, puja vacation ensuing.
Oh yes. Within
I think
within 8 weeks from date of communication, within a por hobe. No, we'll fix a date. What?
By December, October is
Enter November you get. Acha, very well. Within December 15, 2025. Within December 15, 2025. Lordship. Thank you.
grateful.
Thank you.
Appearing for the appellant wife in this appeal.
Mr. Bush, no objection has been filed by your client. Because there's a report of the office. Allotted copy of paper could not be served. It is pertinent to mention here that learned advocate Ms. Ria Kundu had filed Vokalatnama. No objection obtained.
When
Filed. Last report is that
when?
she has filed her Vokalatnama without without there being a no objection on that.
No objection থেকে নিয়েছিলি আগের ডেট কোথায়? কোথায় দিয়েছিস?
Just ensure, Mr. Basu, whether that the Vokalatnama
Yes,
filed
I-
by her that carried that no objection.
ওই যে বকারাতনামাটা জমা দিয়েছিস তার মধ্যে নো অবজেকশনটা অপর পক্ষের উকিল বাবু ছিল সেটা কোথায় জমা দিয়েছিস?
When did she file it? When? Ask him when. Ask her when.
When? May 2025.
8th of September recording. So you have to check that. Otherwise, your appearance will be. This will also become pro bono. Pro bono or pro bhaio, we don't know. Whatever, but it will
I
become.
will take it up day after tomorrow. Check.
We find from an office report dated September 8, 2025 that there is some issue regarding the Vokalatnama filed by the current learned advocate on behalf of the respondent. Full stop. To resolve the same, comma, let the matter stand adjourned till
Sorry, instead of 11th, can it be on 17th? I have taken consent from.
till September 17,
I'm
2025.
extremely grateful. হ্যাঁ আমার নাম কল্লোল বোস রতিন দে।
Intended effect has taken place. Next.
Number 10.
Yes.
For the appellant.
Yes, Mr. Manoj.
Application for maintenance, my lord.
Yes.
On 2nd of April 25, your lordship disposed of the application for injunction.
Acha.
And your lordship also recorded, my lord, in 6th paragraph that husband, my lord, has given an address which is part of the decree. We served at that address. It
But
is-
very difficult without the affidavits. Now Rajneesh versus Neha stares at her.
My lord.
Can you please try to
Kindly permit me, my lord, to serve to the employer, my lord. He is the employee of Reserve Bank of India, my lord.
that will itself be cruelty.
Lordship will kindly once, my lord, see paragraph 6 of the order dated 2nd of April, my lord. Or cruelty. 2nd April 2025, paragraphs 5 and 6.
ডিপার্টমেন্টের অর্ডার আমাদের অর্ডার সব একই কোনটা ডিপার্টমেন্ট কোনটা আমাদের অর্ডার For injunction, we have done that, Mr. Banerjee, actually.
For
Because
maintain-
unless there is injunction, they'll remarry and
He has to appear, my lord. I've served, my lord, it has come back with the endorsement, same endorsement that intimation served, but he is not, and this is left without any instruction. This is, my lord.
then we'll have to pass ex parte order. Well, we'll take up, we'll come back in 10 minutes and we'll carry on with this matter. Mr. Banerjee, we were thinking,
Fine.
you have served at the residential address of this person.
My lord.
Now you said
Two addresses. One is the staff quarter of Reserve Bank, my lord, which was in the part of the decree. The other is the residential. Both addresses we have served.
both returned as left.
No, staff quarter, my lord, has returned with the endorsement left without any intimation.
And
And other, my lord, has not yet come back.
Now, therefore, you said that we may direct you to serve on the employer instead of serving on the employer. Can you get his workplace address and add that and serve him, but at the workplace? I think we think that will be better because alimony, saddling him with alimony won't be workable
Unless the
ultimately if you
person is
don't get, yes.
Fine.
Affidavit of service filed to be kept on record. Full stop. The service was sought to be effected on the respondent husband at two places, hyphen, his residence as well as the staff quarters, comma, which is his other address. Full stop. Insofar as the latter is concerned, comma, the envelope has returned with the endorsement addressee left without instructions. Full stop. Regarding the residential service, comma, no indication is found from the postal website. Full stop. Next para. We are of the opinion that before saddling the respondent with an order of alimony, comma, it would only be prudent to direct the petitioner to serve at the respondent serve the respondent at his workplace. Full stop. Next para. Accordingly, we direct the petitioner to serve a copy of the alimony application on the respondent at his workplace address and file a fresh affidavit of service to that effect on the returnable date. Full stop. Leave is granted to the learned advocate on record for the petitioner to amend the cause title of the memorandum of appeal as well as the alimony application by incorporating the said address of the workplace of the respondent by tomorrow.
By day after tomorrow, I'll have to procure the address.
Yes, by September 12, 2025, by Friday.
Right.
Full stop. Next para. The matter shall next be listed on September 24, 2025.
Right. Develop.
Just before the election.
Right. What is it?
Lord, I am appearing for respondent. I am filing repetitive in opposition.
Today, well, I have not been given any copy.
No. I will sub the copy.
You should have given a copy to him previously.
My lord, yesterday my junior came, but he did not find out. That's
Well,
why
I have not been able to controvert also see
So
also.
where will give you 1 week's
But
time?
only
This is
one,
regarding the section 5.
one,
yes, my lord. Yes,
one more thing. First of all, my lord, so far Somabho Ghosh is concerned,
I am appearing for my junior.
my lord, that
Your lordship directed that the notice should be.
Oh, yes, yes.
affidavit of service is here, my lord. And possibly, my lord, he is not challenging the affidavit of service, I believe.
No, there is no question of.
No,
And my lord, one more thing, my lord, I want to file a supplementary affidavit. There was a mistake on my part, and at this stage, my lord,
we cannot compel this person to come
no.
again and again.
No,
So, what is the allegation against him in your?
the allegation, nothing is allegation, my lord.
Let us see the paragraph.
My paragraphs kindly, my lord.
Have you gone through a copy of this?
Yes, my lord.
Yes, Mr. Mukherjee, what
Yes.
is the nature of the?
As if, my lord, it has been portrayed in the application under section 5 that my junior has kept the file without filing the memorandum of appeal within the time of the statutory period of limitation.
Yes.
My lord, today, my lord, I can, my lord, say before your lordship, my junior, my lord, held a conference with me. The memorandum of appeal, what should be the probable grounds, I have narrated to him. Thereafter, my lord, the conference fee, so far as regards, my lord, mine is concerned, that was paid by the client. Repeated occasion, my junior requested him to pay at least some ad hoc amount so that, my lord, he can start preparing the memorandum of appeal, my lord, draft of the memorandum of appeal. Thereafter, and the vakalatnama to be executed to that effect so that he can take steps.
This is precisely what we are apprehending.
These two things has never been done. On the contrary, on a once in a fine morning, this.
What two things? One is vakalatnama was not.
Vakalatnama was not executed in favor of my lord junior.
Not your junior's fees.
Any fees, my lord, so far as regard the draft copy of memorandum of appeal is concerned. Once in a fine morning, over telephone, intimated he wants to take back the fine that my junior has.
Well, will kindly look in this connection, paragraph 5. My lord, this is not
Will not allow this.
admitted situation, my lord, that he was briefed. And it is an admitted situation that he could not draw the memorandum of appeal. But the question of fees, my lord, question of fees, my lord, would be coming from him, my lord, from the junior, my lord, if he had written a letter to me that no, please give me the fees. My lord, no question of.
Oh, nowadays advocates have to write letters to the client to get
This is a
fees.
Section 5 application.
I'm very sorry.
Well, it is a Section 5
It's a very unfortunate
Well,
submission.
I will have to
This is
treat-
not a Section 5 application. Once you approach an advocate, he also drafts the memorandum of appeal.
No, my lord, I have
And
not got.
you have to
I
write.
have not got.
Did you write a letter to your client to get your fees?
I have given the letter.
To get your fees.
WhatsApp
Your
communication.
client should suffer.
Well, WhatsApp
Be rejected outright with costs equivalent to the fees of the learned advocate.
Once Malad will kindly look at the WhatsApp communication.
Yes. Absolutely malafide application.
Well, Malad will
What
kindly
one
look at
malafide?
page 27.
What WhatsApp
Well,
application?
he has not given the answer.
No, you are saying this is the submission made from the bar on behalf of the
withdraw that
petitioner.
submission, Malad.
No, there's no question of we will
Well,
record
I
the
will-
submission.
I may be wrong.
We'll
Malad.
record your submission.
Kindly
That
put this submission.
an advocate is now has to stoop down to that level that he has to write to his client for his
Malad will
fees.
kindly, Malad,
And for the first
Malad, I
draft,
withdraw my submission, Malad. Malad will kindly pardon me. Malad will kindly look at page 27. I'm seeking pardon from your lordship.
27 what?
Page 27.
You should seek pardon from the bar, not from me.
Malad, I'm very sorry.
Bar is our family.
Malad, I have given him brief. Malad, I took return because, Malad, he did not.
So
give-
easy. So easy. From a
But
junior member of bar.
page-
They are vulnerable people. So easy.
Well, page 27 and kindly look at, Milord, I have given I have given the communication to him. That is the exact communication. He did not answer to me. That is the point I want.
This is just on your advice to prepare manufacture evidence for this section 5.
Well, section
You
manufacturing.
understand these things.
Sir, I am not manufacturing anything.
We are not newborn babies on the bench.
Well,
I practiced for 22 years. My learned brother was there in the judiciary since long back. We understand these things.
The only thing, Milord,
same point.
You had the time to send a WhatsApp message asking for আপনার তরফ থেকে দেরি হয় অনেকটা দেরি হয় just to manufacture evidence for this section. This makes it more clinching that your client had no bona fides.
Well, in that case, Milord, will kindly look at my
Please let us complete. Yes.
My lord, will that case look at my paragraphs? What I have said in paragraph, Milord.
Yes.
16th paper 12.
Is even without looking into the affidavit in opposition will reject this application.
Well, will kindly not, Milord. Well, it is section 5 application, Milord. It's no fault from my client. Milord, it is an admitted situation that he briefed this gentleman. But it is an admitted situation, Milord. Today, Milord, he is suffering because there was no memorandum of appeal. Milord, that is the reason why, Milord, I have given him the WhatsApp communication.
After returning
No, Milord, after returning, certainly, Milord, because Milord, I have said, Milord,
Please read out page 27. Please read out page 27.
Lordship has read out.
No, you will read out. You are relying on this, please read out. The others should also know. Read out. No.
I read out.
You have to read it out. Otherwise, no.
I read out also on the last occasion.
Please read out this occasion also. We have forgotten whatever. We are not supposed to remember whatever your client has said. Your client is not special to us. Please read out loudly.
Lordship has seen সমস্ত documents.
Please read out from
I am
Amar
reading,
divorce case.
Milord will kindly not be angry on me. Milord, Amar divorce case.
One second. These comments, loose comments, please don't make these comments.
I will not.
Nobody is angry on you. We are angry with the way in which your client is proceeding with the matter. Let us be very clear on this. Now you make this loose comment, don't get angry with me and as if giving an impression, a wrong impression of the court. You must desist yourself from doing this. These give wrong impression to the people who are sitting behind.
No, Milord, I am very sorry.
Court is not angry with you. Our voice is turned because of the way in which your client is proceeding. And when we ask you to read out a paragraph, please do that. You are placing your application, please read out page 27.
Milord, there are many other.
Let us forget anger or anything else. 27.
Milord, আমার ডিভোর্স কেসের জাজমেন্ট বিরুদ্ধে মহামান্য হাইকোর্টে অ্যাপিল ফাইল করতে সমস্ত ডকুমেন্টস আপনাকে দেওয়া হয়েছিল, কিন্তু সেখানে অনেকটা দেরি হয় আপনার তরফ থেকে। হয়তো আপনার ব্যস্ততা এর একটা অন্যতম কারণ। যাই হোক, বর্তমানে মামলাটি মহামান্য হাইকোর্টে ফাইল করা হচ্ছে, কিন্তু অনেকটাই দেরি হয়ে যাওয়ার জন্য লিমিটেশন একটা বাধা হয়ে দাঁড়িয়েছে। ফলস্বরূপ একটা লিমিটেশনের একটা পিটিশন মহামান্য হাইকোর্টে।
So what was the occasion of informing him this? Unless to prepare a ground for this section 5?
Well, I am truthful. In this, Milord, in this.
We'll also be very truthful in our judgment.
Well, may I file, Milord, may I file my affidavit in reply in respect of the allegation?
We are not looking into that opposition. we are rejecting it, your section 5 on the face of it.
Not, my lord, he will suffer totally.
He will.
My lord, my lord, one
Definitely.
more thing, my lord. Your lordship knows, my lord,
Definitely suffer.
that so far the merit of the concert, your lordship will see, my lord, once the merit of the matter. My lord will kindly look at the situation that in 2003, my lord, the marriage happened. In 2004, the child born. In 2008, my lord, the lady went away from me, my wife, and thereafter no return, no union, nothing, my lord. So, my lord, in this situation, my lord, we are, my lord, it's really a situation where both the parties are suffering. My lord, it may be possible, my lord, after admitting this case, my lord, we will be able to patch up the matter by taking, if your lordship send
Patch
me,
up, your divorce suit has been
my
dismissed.
lord, in
Go
the
and
same
patch up.
way, my lord,
Who
if
prevents
your
it?
lordship send it to the mediation also, my lord, this matter can be, my lord, solved, my lord. I will be only requesting your lordship, my lord, to take it, my lord,
The
not
present
very,
application has been filed. Can 1 of 2025.
my lord, will
The
kindly
present
not-
application has been filed for condonation of delay of about 119 days in preferring the appeal. Full stop. The
my lord, I have
primary grounds for the delay, comma, as sought to be portrayed in the application are as follows. Colon দিয়ে paragraphs 5 টা পুরোটা কোট করবে,
my brother also suffering from the several ailments, my lord. I had to look after
5 থেকে 7 পর্যন্ত কোট করে দেবে। Next para. Insofar as the alleged eye ailment of the elder brother of the petitioner is concerned, comma, we do not find much merits in the said flimsy pretext, comma, in the absence of any specific details having been pleaded that the elder brother was completely unable to look after his treatment by himself. Full stop.
I have given.
A case has also been made out that
Jaundice,
the
no?
said elder brother was diagnosed with jaundice, comma, apart from his eye operation, comma, in similar lines. Full stop. Next para. However, comma, the primary refrain of the pretexts for filing the appeal late is found in paragraphs 5 and 7 of the application. Full stop. In paragraph number 5, comma, a particular learned advocate, comma, who is a very junior member of the bar and is present before us, comma, led by his senior, comma, upon specific direction by us for the said learned advocate to be served, comma, although assured from time to time that he was in the midst of preparation of the draft memorandum of appeal, comma, he could not make the draft ready, full stop. Ultimately, comma, it is alleged, comma, the said advocate expressed that he was too busy in respect of several other matters for which he was unable to prepare the draft, full stop. It is also alleged that on that day, the said advocate handed over the papers to the appellant without the draft memorandum of appeal, which he expressed he was not able to prepare. For the next para, also, comma, it has been alleged in paragraph number 7 of the application that the appellant, much dependent upon the advocates, comma, including the said learned advocate, comma, but ultimately the said learned junior member of the bar was unable to do the work in preparation of the draft of memorandum of appeal and failed to prepare the required work due to his busy schedule. Full stop. Next para. We have also heard the said learned advocate, comma, who is present in court along with his senior, Mr. Mukherjee. Full stop. Next para. Upon hearing the version of the said learned advocate, comma, it is clear to us that although the initial conference fees of the senior was paid, comma, no amount was paid to the said learned advocate by the petitioner for the expenses of not only drafting but filing the appeal, drafting the memorandum of filing of the appeal and or having the same settled, comma, which gave rise to the delay. Full stop. Next para. Learned counsel for the petitioner also relies on a WhatsApp communication, a purported WhatsApp communication annexed at page 27 within bracket annexure B bracket close of the present application, which indicates that after taking back the file from the erstwhile learned advocate, comma, the petitioner wrote to the said learned advocate that although all documents were handed over to the said learned advocate, comma, much delay was occasioned on the part of the said learned advocate, comma, which might have been due to the busyness of the said advocate. First up, it was further informed thereby that be that as it may, comma, at present the appeal is being filed in the High Court, but due to the delay, comma, due to the long delay, comma, a limitation petitioner is having to be filed. Full stop. Next para. It is evident from the very tenor of the judgment in Bengali vernacular, within bracket, roughly translated and paraphrased above, bracket closed, that the said message was merely for the purpose of preparing a ground for the present condonation of delay application. Full stop. As such, comma, much reliance cannot be placed on the same. Full stop. Next para. A practice, we cannot but take judicial note of the fact that a practice is developing of late of blaming erstwhile advocates, comma, without any specific proof of the allegations made against such advocate, and or furnishing any document to show that any fees were paid to the said advocate, or that the litigant approached the advocate in time. Full stop. Next para. It is such practice is most unfortunate, comma, since in most cases, comma, the said learned advocate, comma, against whom the allegation is made, comma, is not present before the court and does not have a platform to ventilate his or her defense. Full stop. Next para. We take particular note of the fact that the learned advocate against whom the allegations are made comes from the junior section of the bar and is more vulnerable than his senior counterparts. Full stop. The making of blanket allegations against such an advocate, comma, taking undue advantage of his small number of years in the bar is all the more unfortunate and merely shows the malafide on the part of the petitioner. Full stop. Next para. Such blame game cannot be given a premium with the blessings of the court in each and every case. Full stop. Next para. It has been held by the Supreme Court and several high courts time and again that the reasons furnished for the delay and the quality thereof, comma, and not the span of the delay is what is material in considering an application for condonation of delay. Full stop. Next para. In view of our above discussions, comma, we are of the opinion that the condonation application has been founded on flimsy grounds and unnecessary aspersions have been cast on the unnecessary and unwarranted aspersions have been cast on a learned junior member of the bar merely to serve the purpose of the petitioner. Full stop. Next para. We strongly deprecate such practice and are of the opinion that the present application has been made malafide. Full stop. Next para. Although learned counsel for the respondent files the respondent's affidavit in opposition to the condonation application, comma, we choose not to look into the same in view of the fact that the application does not merit being entertained at the threshold, and since we have not given any opportunity to the petitioner to controvert the allegations in the opposition. Full stop. Next para. Even on the basis of the averments made in the application itself, comma, we are of the opinion that the same ought to be dismissed. Full stop. Accordingly, can 1 of 2025 is dismissed on contest. However, comma, without any order as to costs, comma, full stop. Consequentially, comma, FAT 205 of 2025 is dismissed as time barred. Full stop. Yes, this much.
At least, your lordship has not given me.
5 থেকে 7, 5, 6, 6A আর 7, চারটে আছে. Thank you. Next.
I'm thankful to your lordship. Your lordship has not given any cost against me.
Thank you. Yes.
Lordship, I'm led by Advocate Shubhoshai Chatterjee. He's engaged in another court. Until he arrives, I will assist your Lordship in the matter. Your Lordship, on
Want to assist us?
Yes.
You're most welcome. Please.
And thank you, Your Lordship.
Yes. What is your name?
My name is Aritra Ghosh.
Yes, Mr. Ghosh. What is the matter?
Your Lordship, on last occasion, Your Lordship had directed for some corrections to be made in the application. We have made the necessary correction along with the advocate on record. Your Lordship, on 8/7/2025, Your Lordship had passed an order which has not been complied with by the respondent. Your Lordship, there are three contentions that I wish to submit before this court. Your Lordship, firstly, since the passing of the said order, there have been 8 occasions where I could meet with my child. But Your Lordship, the mother didn't bring the child on the first 2 occasions. So technically, I could meet only on 6 occasions with my child.
On 2 occasions, you could not meet?
No, Your Lordship, on the first 2 occasions, I could.
First 2 occasions, but next 6 you have been able
Yes,
to.
Your Lordship. But Your Lordship, the place of meeting that has been fixed in the order dated 8/7/2025 is that one Mohua Shongo Club is where the mother will bring the child, where I will meet with the child. Your Lordship, however, that has also not been complied with, and the mother brings the child to one dilapidated building where no one lives.
I have also.
You are there, Mr. Agarwal.
Malad,
You look
one
into
more-
this matter.
Malad, we have also come
These
out
are
with
relationship matters.
Malad, the violation they have also done out, my lord. In
Forget
every
those.
week they come
Why
out.
in a dilapidated house?
No, no, man. The venue which has been fixed by the honorable court, my lord, that is already been followed, my lord. And he also takes a tuition at that place only. The Arabic teacher.
Why did you change the venue? We directed you to
That Mahua club only, my lord.
oh, there only.
There
Mohua
only.
Shongo Club.
No, Your
Because
Lordship.
the child is every day goes for a tuition for Arabic classes near that
It
club
was
also.
passed in your presence.
my lord.
Alternate
That
Sunday,
is the
5
place.
p.m.
Means-
No, give the visitation not at the tuition site, but at the Mohua
No,
Shongo Club itself.
just beside that club, the tuition.
No,
center.
no, beside,
Oh, my lord, he
above,
stands
below,
everywhere.
side.
Every time, every week he comes up. The appellant every week comes up here. Before
Give it
that,
in the Mohua Shongo Club. What
yes,
is it?
my lord. In the club itself, my lord. That can be inquired, my lord. If the club people can also tell out in regard to that, my lord.
This we
And
cannot
every
resolve.
week, my lord, he comes up there. It was alternative weeks. And what he makes out a threatening, my lord, if you do not come every week, your maintenance will be stopped and the mother maintenance will be stopped. And
Lordship,
even
I
the,
oppose this.
yes, my lord, every time that is the allegation. And every time a hatred in regard to the mother has come up. He's ready to give out all
Trying
the
to
best.
counteract. You have the entire time to inject hatred into the child.
My lord,
So he only has 2
my
hours
lord,
to
he
inject
had
hatred.
made out a recording also.
The poor child is a sufferer.
My lord, that can be asked
Lordship,
by the
another
child.
point, since the order dated 8/7/25 has also
The venom between the parents should not go into the
Yes,
child.
my lord, that's the thing I'm saying. But
You
what-
are nodding here, he will nod here, but
My
the
lord,
parties won't listen.
But the child is every time he set out hatred in regard to the mother. You leave your mother. I'm ready to give out the entire wealth. You come with me. You leave your mother every time. He
Then
made
we'll
out a
have to.
recording.
You are the father.
My lord, mother.
You're the mother. Then we'll have to appoint a special officer at your cost. In any event, that will be adjusted from the maintenance.
Lordship, I have to take
So we'll appoint a special officer.
A very small amount.
Choose
of
a special
maintenance is
officer.
given.
Both of you choose a common special officer.
But my lord, the maintenance amount is very small.
What is the maintenance amount?
4,000 rupees, my lord.
4,000. Then he cannot afford a special officer.
That's
What can be done? We are disposing of this application. If you have any grievance, they are not complying, file a proper application for contempt. We'll look into that. But what about the appeal? You have prepared the paper books. Trial court records have come. Appeal cannot be delayed indefinitely. We'll dispose of the application by maintaining our order, and we'll say that the parties shall strictly adhere to the order. We cannot do more than that. There are allegations and counter allegations. We'll dispose of the application. Did you pass directions for paper books or something like that?
on the last occasion, my lord. The
No,
paper
not
book
the
was
last
not
occasion,
been directed,
previously.
my lord.
No, Your Lordship, there's no direction for paper.
No, right. I will give that right now. Allegations and counter allegations are made by the parties. Full stop. The appellant father alleges that the child is being brought to a dilapidated house instead of the place assigned by the order of this court, that is the Mohua Sangho Club.
Yes, Your Lordship. Your Lordship, another point, just Your Lordship, one small point. The mother always stays there when I went to interact.
Mohua Sangho Club. So it is further submitted that the respondent mother always stayed during the hours of visitation, comma, thereby disrupting the privacy between the father and the child. Full stop. Learned counsel for the respondent, learned counsel for the appellant further submits that out of 8 due dates, comma, on 2 dates the visitation was not given by the respondent mother, comma, although on the other 6 occasions the visitation took place. For the next para, learned counsel for the respondent submits that the appellant is allegedly issuing threats every time to the child, to the effect that the maintenance for the child and the mother will be stopped if the visitation is disrupted. So it is further alleged that venom is injected into the child by the appellant on every occasion of visitation. Full stop. Next para. Where there is acrimony between the parents, comma, the child is the worst sufferer. Full stop. It is extremely difficult for the court to adjudicate on merits as to what exactly is transpiring during the visitation rights. Full stop. As rightly pointed out by the respondent, comma, keeping in view the minimal maintenance directed to the mother, comma, we are doubtful as to whether the appellant would be able to afford a special officer on each of the occasions of visitation, and as such, comma, stop short of appointing such a special officer. Full stop. However, comma, we make it clear that the respondent mother shall not intrude into the interaction between the appellant father and the child during the visitation hours, but shall remain away from the exact spot of visitation and may be there in the close vicinity thereof. Full stop. On the other hand, comma, it is expected that the appellant father shall not issue any threat to the child regarding maintenance or otherwise. Full stop. We make it abundantly clear that by introducing the above riders, comma, we are not accepting on merits the allegations of either of the parties, but put in such observations as an abundant caution to ensure that the child does not face the wrath of the acrimony of his parents during visitation. Full stop. Next para. Be that as it may, comma, can 1 of 2025 is disposed of in terms of the above order by continuing the arrangement for visitation as per our order dated May 19th. Was that? No.
My lord, it was 8th of July 2023.
8th of July.
My lord, one more thing I say, my lord. If they say
Order
8
dated
times,
July 8, 2025 till disposal of the appeal. Full stop. However, comma, it will be open to both parties to approach this court by way of a proper application in the event the visitation right is not being complied with by the other party in the true sense of the term, and or there any issue comes up in such visitation. Full stop. There will be no arrest to cost. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Yes, you are going to.
on the order which was passed on 8th of July, my lord, the first visit starts out on 13th July, my lord. If we take into 8 weeks, means
We are
the
not-
order says about the alternative weeks, my lord. But if
Yes.
8 weeks we take, means it is been understood.
I have
every
not
week,
accepted
my lord.
either of your allegations. Let this continue, but please put in the special messenger cost and prepare the paperbooks quickly so that we can hear out the appeal as well.
Grateful, Your
Right,
Lordship.
my lord.
Next. Mr. Ghosh, well are good. Yes. Yes. What is the matter about, Mr. Shanal?
Matter is, Lordship, regarding, Lordship, whether compensation will be granted under 2013 Act or Lordship, the earlier act, under the earlier act. Now,
My
there
lord, on
is a
the last
section-
occasion, my lord, I raised the maintainability issues, my lord, regarding this CAN application, my lord.
Yes, what was your ground, please? Just
My lord, my ground is, my lord, my learned friend did not want to proceed with the appeal.
Mhm.
My lord, here in the CAN application, my lord, neither he challenged the order of the writ court. My lord, he challenged the order which has already been decided by the writ court, my lord.
Please show us that order because
My-
it's a preliminary
lord-
challenge. We must.
My lord, on the last occasion, my lord, sixth line of your lordship's order.
Yes. 6 July.
My lord, in the same breath,
আবার অর্ডার তলায় চলে গেছে 6 জুলাই এর অর্ডার কোথায় এখানে আছে 22/9 26/8 21/8 তারপর ডিপার্টমেন্ট 6 জুলাই বলছে আওয়ার অর্ডার 6 জুলাই
my lord.
you are saying 6 July pay compensation to our officer
My lord,
yes
I tendering my apology, my lord.
yes what did he hold
My lord, in the sixth line from your lordship's order, in the same breath, seek a direction which tantamounts to setting aside the impugned order of the learned single judge, my lord. My lord, this impugned order, my lord, the order of the that has been challenged before the learned single judge, my lord. This is not the impugned order, my lord. My learned friend, my lord, nowhere placed the order of the learned single
where
judge.
has he stated in the application that he does not want to
My lord, page 28.
28 yes that challenging the aforesaid order of this court.
My lord, it is my fault, my lord, page.
Yes, yes, page 28, para 30.
My lord, para 30, my lord.
So the appellants are not ready and willing to proceed with the.
My lord, in the next paragraph, my lord, that is this to quash and set aside the order dated 24 January 2024. My lord, that order had already been decided by the learned single judge, my lord. In the prayer also, my lord, they asking, my lord, seeking for the set aside the order of the.
Not the order of the writ court.
My lord. My lord, kindly come to page 71, my lord. Exact prayer, my lord, my learned friend made before the writ court, my lord.
What did the writ court do?
My lord, they appealed the order of this order, my lord.
This is maybe bad drafting also.
Bad drafting.
My lord,
What bad
maybe, my lord.
Yes becomes no.
This is my fault.
Not ready and willing to proceed with the said appeal.
My lord, and more so, my lord.
You challenge the first authority's order by bypassing the writ court's order. You never, there is no challenge to that.
My lord.
But the memorandum must disclose the
Well, I
challenge.
don't have the copy of the memorandum, my lord. My lord, in this case, my lord, neither, my lord, our documents we are relying upon, my lord, have been annexed. Well, kindly allow us, lordship, to file a paper book, my lord, so that I can produce our documents.
No, no new documents.
No, my lord, no new document. Lordship, the documents which are relying upon before the writ court, that document had not been annexed in the CAN application, my lord. Kindly allow me, lordship.
What is the scope of interim order, Mr.?
My lord, not place any interim order. There is no stay petition, my lord.
This is something which is
What is this application for then?
not appropriate order.
Well, what appropriate order
I
against?
was allowed.
Section 5 was-
There is section.
So it is recorded in the defective, my lord, in the cause list.
That is why it is not allowed.
Section was not allowed. What is the delay?
11 days delay, my lord. They mentioned in the 11 days delay.
We were allowing the section 5 and regarding the main application, we
Yes.
hear him. In view of sufficient reasons for the delay in preferring the appeal of about 11 days having been made out, CAN 2 of 2025 is allowed, thereby condoning the delay in preferring MAT 863 of 2025. We'll just check up whether it was allowed previously.
No.
Sometimes
subject
that
to-
happens.
No, my lord, there is no.
Very well.
My lord, what
CAN 1 of 2025 is now taken up for hearing. Yes.
My lord, in this matter, my lord, I want to produce a objection regarding this maintainability of this CAN application, my lord. Lordship, kindly allow me, lordship, to place the oppositions regarding this maintainability, my lord. Because neither lordship, now our documents has been relying upon my learned
What
friend.
is the relief sought in this application? First, tell us that. We may reject it at the outset.
Yes. Now, my lord, can I turn what happened, my lord?
You have asked for the main relief to quash and set aside
My
the
lord,
order of the respondent authority.
Yes, my lord.
Appropriate authority.
We'll dismiss this application and we'll direct the appeal to be heard out.
Only one thing, because it is for the purpose of only one word is required to be interpreted by your lordship, and or.
Where?
Yes.
My lord, in that case, lordship, he have to redraft the prayer portion, my lord. On what?
Where
basis?
and or where? No, no. Let him
My
complete.
lord.
Yes, Mr. Rai, where and or?
That your lordship will kindly turn to page 135.
No, no. First, you have to cross the hurdle of your own application. What is
Yes.
the relief sought here?
Yes.
Quashing the respondent authority's order. This application is not maintainable. This will be premature. I mean,
Only
granting the relief
granting.
will dismiss this application
Well, then,
and direct you to prepare paperwork.
Grateful to your
only
lordship.
one thing, my lord, if you logically consider on the face of the recording, I can satisfy your lordship that
No.
what has been done, the single coordinate bench order has been reviewed on the basis of which you have logically
You have
considered.
not brought in all the papers also.
Yes. Only
Then-
two documents are not there. If they said two documents with me, my lord, with the photocopy is there.
Can 1 of 2025 is an application for double enumerated appropriate order, comma, whereby a quashing of the respondent authority's order, comma, which was upheld by the learned single judge in the order impugned in the present appeal, comma, has been sought. Full stop. Granting such relief would tantamount to pre-deciding the appeal at the interlocutory stage. Full stop. Learned counsel appearing for the NHAI stroke respondent takes an objection as to maintainability of the application. Full stop. It is argued by learned counsel for the NHAI that in paragraph 30 it has been stated that the appellant's petitioners are not ready and willing to proceed with the present appeal, and in the same breath have challenged the order which was upheld by the impugned order. Full stop. Next para, it is further submitted that all the materials which were before the writ court have not been annexed in the application. Full stop. Next para, insofar as the first objection is concerned, comma, reading the averments made in the application as a whole, comma, particularly paragraph number 31 and the prayer, comma, it is evident that the use of the word within double inverted not in paragraph 30 was a palpable typographical error. Full stop. It is well settled that an application is required to be read as a whole and not stray comments and stray words therein taken out of context. Full stop. From approaching the matter from such perspective, comma, we do not construe the statement made in paragraph 30 of the application as an unqualified withdrawal, unqualified expression of interest on the part of the appellant to withdraw the appeal, comma, since all the other averments made in the application as well as the memorandum of appeal itself indicate that the sole intention of the appellants is to challenge the order of the learned single judge. Full stop. However, comma, in view of our above discussion, comma, the relief sought in the application cannot be granted at this stage. Full stop. Accordingly, IA Can 1 of 2025 is dismissed without any orders to cost, without going into the merits of the contentions of the parties. Full stop. Next para, the records shall be brought from the writ court at the no question of putting special messenger. Records shall be brought from the writ court at the earliest. Full stop. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records by incorporating all relevant documents, including the documents which were there before the writ court, as expeditiously as possible, comma, positively within November 7, 2025, 7 days after reopening. You get time from now. November 7, 2025, and serve advance copies thereof on the learned advocate for the advocates for the respondents in HAI state others are there. Respondents, full stop, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm grateful to you.
I'll prepare, my lord, date may be, so it will appear in the list, my lord. Only one thing, my lord, this only the land losers, only for that purpose,
No,
my lord.
Not right.
Only one thing, that is
Too many persons are already languishing. One is just behind you. Languishing and making it very evident in every hair of his mustache.
Only leave us better to appear.
No special priority, Mr. Yes. Yes, Mr. Basu. What
On
is-
that they started, but evidence service was not there, so it could not complete.
Yes.
This is, my lord, the allotment by the Refugee Rehabilitation Authority. Condition laid down in the notification that a person who is in possession, I repeat,
Oh,
a
that one.
person who is in possession can be allotted. So possession is sine qua non for allotment.
Yes.
I made an application for allotment in my name in respect of a particular plot. I have produced the documents evidencing my possession there. The private respondents who is residing somewhere else having no possession of this plot has been allotted that plot. So I prayed before the authority that to cancel that and to allotment in my favor. The difficulty, my lord, in the prayer cancellation of a registered deed has been sought for at that way with the honorable single judge. In the writ petition, you cannot ask for cancellation of the writ court. But our contention before my lord is that the basis on which the allotment was made and which resulted in a registered document is wrong. So if the original the thing is wrong, then my lord, it does not require any formal cancellation by a writ court. Look, I two, three documents I will show to your lordship. Kindly come to page 34. This is the, my lord, the notification relying on which allotments are made. First part, your lordship did not. Kindly turn over the page and come to Roman 2.
Yes.
In terms of the existing government policy, freehold.
Give us half a second, Mr. Basu. You are for the private respondent?
Lordship.
I'm on the state.
State. Thank you, please.
In terms of the existing government policy, freehold right and title deed may be executed only in favor of the displaced person from erstwhile East Pakistan who is in effective possession of an urban plot or part thereof. Rest will not be necessary. To strengthen my possession, my lord, I have relied on certain documents which you lordship will get at page 17 onwards.
Possession at the relevant time.
Relevant.
Yes, right.
The ration card I have given. Can you mark the 11H is the
11H.
holding number. 11H.
Right.
I have made this. Now, my lord, private respondent is in occupation of another plot. Kindly come to page 21. This is, my lord,
Settlement was in respect of 11H only.
11H. I will come to the order portion later. Hey, Milan Dotto, my lord, they are in separate premises, premises number 132. I have produced the relevant documents at that relevant point of time, so far as these properties concerned.
This was the only document regarding his position.
There are others.
You have produced.
Kindly come to 21, then my lord, 22. 1615 right hand side, my lord, you will will get at premises number 132.
These are for different periods.
Yes, this is, my lord,
1988. No, this is both are same.
Both are same. Both are same. My lord, we kindly turn over next page.
Yes.
Yes, because
And so far, 23 is in my favor. The then member of the Legislative Assembly given certificate that my clients are residing in such and such these days. Now, my lord, on the basis of this, the writ petition was moved and directed to be considered by the court. Representation not made at page 37. And my lord, the order.
Why is page 25 annex, Mr. Basu? You are energetic and sincere in discharging your duties and you have bear a good moral character. That is one of the eligibility criteria of.
No, this part is not 11. 11 is 11.
That is the only certificate in that.
11H. Given by the councillor that he is residing in 11H.
Right. And the next page also. So, yes.
The
Very good.
encouragement of a lawyer to appear in a particular court. Only serious things are always.
No, Mr. Basu was appearing, Kollal Basu was appearing in a matter in the morning. There was some defect in his client's Vokaladnama. No objection was not filed, but new Vokaladnama. When I impressed someone initially, he was hesitant. He started arguing, and I said that this matter will become pro bono if the Vokaladnama is found defective. Because his name cannot be recorded, everything else will follow. So he was convinced, he took time and.
Pro bono, for them, it is a card.
I told him pro bono or pro bhayo, I don't know, but it will become free of cost. So he understood, you took the clue and left.
That this is nowadays, I will not find so much people to understand this.
No, yes, people misunderstand and many things happen also. You become
time.
YouTube heroes for the wrong reasons.
22 happened, my lord, miserable. I will tell you later.
All right.
On this, my lord, this lighter moment creates a havoc.
Yes, they are creating havoc. Lighter moments are taken very heavily by some sections. So let us not care about those.
We not.
No.
Page 37, my lord, kindly come. 37, I made a representation.
Where is the first decision by the first authority?
I am coming to the decision, my lord. Kindly come to the order impugned. 42. Kindly come to
Not the single judges first.
before that.
Yes,
But
yes.
it's at 45. Page 45.
Right, right.
This is in terms of an order of your lordship court directed to consider. Let me place it. In compliance with the directive of the side, not necessary. The petitioner, the Gautam court stated that the advocate would not be present. These are also not
Not
relevant.
necessary.
Kindly come to next page, second paragraph.
I have gone through.
It appears from office record that a freehold title deed was issued in favor of the Milan Kanti Dotto. Respondent number 5, in respect of SP number such and such for a quantum of land measuring 0.2 kata 30 square feet, white bearing number such and such. The Monoranjan court now deceased. The petitioner's father is recorded as the occupier of SP number 11, measuring 3 katas of 12 katas such and such. There is, however, no record of any occupier in respect of SP number 12A. The two plots of SP number 12 and 12A are noted as joint plots. No freehold title deed has yet been issued in respect of the SP number 12 and 12A. The petitioner claimed that the having possessed the piece of land measuring of 3 katas and 5 chataks for years together as a refugee is entitled to get freehold title deed in respect of the said land. That is SP number 11 and 12A taken together. The submission of the petitioner and the learned lawyer for the respondent number 5 are hard and considered. The consideration of official record as the submission of the respondent number 5 and also the fact that the petitioner, the Gautam court, is now possession of refugee plot number SP number 12A measuring of 1 kata 5 chitaks of square feet is.
You are the petitioner.
Yes.
So 12, you have shown position of 12A and it has been.
11H, I have shown to lordship the documents.
That was overlooked apparently.
And not only that, why the others has been allotted the deed.
That is not gone in.
It is also not gone into it. This is the original order.
Achha, so two aspects of the matter. One is your petitioner's 11H documents not considered.
Not considered. And why the private one has been allotted, having not in possession. That document so I also showed. Private facie. So that was also not considered.
Very well. How did the learned single judge proceed?
Single judge, my lord, is of the view that why this cancellation of
No, let us first see the relief sought in the writ petition.
Yes, that is
because that goes against you, as you said.
Yes.
You would obviously point out, but
writ
petition is not annexed.
No, I have told my.
Is it quoted somewhere, anywhere in the application, the reliefs? It may have been quoted in the application somewhere. They won't quote because if that is quoted, everything is.
Told my learned junior assisting me that this is the mistake you have done. Kindly allow me to hand over to this is parts of the record. I want to copy this.
You say this would be the fallout, but the premise was the challenge to the allotment. So if the allotment goes
automatically,
that should be read into this. Very well. Let us see the learned single judges.
Yes.
We'll look into the certified copy. Mr. Basu, please just refer to the internal pages.
My lord, this is a very short order. 17th March 2025.
Yes. If you just refer to the internal pages, it will be easier for us to follow from the memo itself.
Very good. Madam, kindly come to internal page 2.
Second
Paragraph.
Second or third?
Second paragraph. I make it clear that the petitioner is acting
yes.
on a deed of gift, which was registered by the concerned authority. He may approach the appropriate forum to challenge the deed of gift according to the provisions of law.
He has to give other reasons. We'll just.
In considering the impugned order passed by the respondent authority, it is clear view of the authority that the father of the petitioner, namely Monoranjan Kaur, was occupier of settlement number 12, and it is also fact the settlement number 12 and 12A are joint plots. The authority is also of the view that the settlement plot number 11 was given under a deed of freehold title deed in favor of Mr. Milan. The authority concerned has disposed of the petitioner, directing the petitioner to approach the authority to prove his heirship after demise of his father Monoranjan Kaur. That is in respect of the other plot, where I am not occupying. Insofar as the writ petition is concerned, it appears to me that the rescind order was passed by the authority after giving appropriate opportunity of hearing. The authority has passed the rescind order on the basis of documents and evidence on record. On plain perusal of the impugned order, I find no infirmity, illegality or unreasonableness. Moreover, the rescind order is not at all perverse or suffers biasness. Thus, I find no justification to interfere with the order. Then, my lord, land counsel for the petitioner challenging the appeal opposition. This part, my lord, may not be necessary for your lordship consideration.
Yes.
Can we come to the conclusion in this?
Yes,
case?
we'll hear that. Yeah. You
My
for the
lord-
private testimony, we'll hear you first.
Yes, my lord, I will submit you some documents that from the beginning I am in that.
No,
11H.
we're not looking into the documents because why we are saying that will be prejudging the issue. Two things we'll ask you, as Mr. Basu pointed. Now, apparently, learned single judge failed to observe one or two things. We'll put you the question, then you give your answers. One is that although the gift deed in your favor has been challenged, from the composite reading of the paragraphs of the plaint of the written statement, it is evident that the premise of the gift deed was challenged, that the allotment should not have been made by you, gift deed was a result. So this finding that gift deed should be challenged before a court, that is preceded by this allotment. So they are challenging the allotment. The relief would have been molded. One, on merits. On merits, you might have several documents. That opportunity was not even given to you. Before that, the learned single judge observes that yes, this finding I will not interfere with. Two things are not looked at. One is their documents regarding 11H. The second is about the BLL, the first authority did not consider your documents, whether those were correct. You may have very good documents, but that exercise was not done by the BLL, by the, what is the first authority? Which authority?
Refugee.
Or the department. He did not do it. So why shouldn't it be sent back to look into his documents and also your documents and come to a fresh finding as to whether that allotment in your favor was right?
Lordship, but only I will highlight you.
Yes, yes.
Mr. Anna is here, madam.
Yes.
Before, my lord, before allotting, the refugee department has already checked and verified. The officer went over there. They have examined and checked who is on a perfect position there or not. And from the beginning, respondent number 5, 6, and 7 are there. Now, at present, they are outraged from the suit.
They are ousted.
They are outraged from the suit purpose.
Outraged means?
That means they are not in that property till now.
You?
So, yes.
You are not in that property?
No.
Why?
Because they have filed the case and in the lower court, my lord, several cases pending. Injunction is pending, my lord.
Why should you be ousted from the premises? They did not ever get any eviction degree.
My lord, the lower court, my lord, order has been passed and several.
We propose to dispose of this appeal by modifying the by setting aside the impugned order and directing the first authority which passed this order, that is the Refugee Relief and Rehabilitation Department Secretary, to revisit the issue, look into their papers, look into your papers, and decide their representation on merits in accordance with law. We'll do that. State is neutral.
Last paragraph, page 48, my lord.
48, yes. Last paragraph.
It is my considered opinion that freehold title deed in respect of the said court may be granted in favor of the petitioner.
That is also not proper. Why should he be given a
Subject to his
Yes.
providing to the satisfaction of the competent authority that he is a legal heir of the bona fide deed.
This is regarding the petitioner. No, that also you should not have done. Did he ask for that? Did he ask for an allotment regarding the self-same plot? Then how could you do that also if he is in proper?
Your next page, page 16, P16, Lord. There is in the name of the Milan Kanti cause, private respondent.
Milan Kanti Datta is who? Them?
Respondent, yes, my lord. Private respondent number 5.
What will challenge?
No, this they have challenged in the writ petition itself.
Only deed had been challenged. It had been challenged.
তাই করছি ডিসপোজাল করে নতুন করে অ্যাডজুডিকেট করতে যে ডকুমেন্ট গুলো প্রডিউস করছে আর এদের ডকুমেন্টও দেখেনি, কোনোটাই করেন। Right. The present challenge has been filed against an order passed in a writ petition filed by the present appellant. First of the writ petitioner challenged the allotment and execution of deed of gift in favor of the private respondents in respect of a particular plot of land, comma, being plot number 11 by H at Chandpur Colony -1, comma, PS Regent Park, comma, Kolkata 7,40,000. Full stop. Next para, the Secretary, refugee, relief and rehabilitation department and refugee rehabilitation commissioner, West Bengal, by an order dated October 21, 2008, pursuant to an earlier direction of this court, disposed of the appellant's representation, by coming to the conclusion that the appellant would be entitled to settlement of a particular plot of land as a bona fide refugee, subject to proving the same to the satisfaction of the competent authority. Full stop. Learned senior counsel for the appellant submits that, however, the veracity of the allotment in favor of the private respondent, which was under challenge in the representation, was not considered at all by looking at the basis of such allotment. Full stop. Next para. When the said order was challenged before the learned single judge, it is submitted by the appellant that the learned single judge proceeded merely on the premise that relief A, as sought in the writ petition, challenged the gift deed, which had to be canvassed before a proper civil court. Full stop. On the other hand, the learned single judge also did not enter into the omission on the part of the rehabilitation commissioner to consider the challenge to the veracity of allotment in favor of the private respondents. Full stop. Next para. Thus, it is submitted that the order impugned herein ought to be set aside. So next para. Learned counsel appearing for the private respondent submits that the refugee relief and rehabilitation department, only upon scrutiny of all documents and the factum of possession of the private respondent, had allotted the land and executed a gift deed in favor of the private respondent. Full stop. As such, it is submitted that in the absence of any evidence to the contrary, the learned single judge was justified in rejecting the writ petition. Full stop. Moreover, it is pointed out that the writ petition challenged the gift deed itself and not the allotment. Full stop. Next para. Learned counsel for the state places reliance on the concluding portion of the order dated October 21, 2008, passed by the Refugee Rehabilitation Commissioner, where liberty was given to the appellant to approach the appropriate authority to prove to the satisfaction of the authority that he is a legal heir of a bona fide refugee for the purpose of settlement of plot number plot number 12 capital A, measuring 1 quota 5 chetaks land, which is recorded in his name. Full stop. Next para. Upon hearing learned counsel for the parties, we find that the plinth of the appellant's contention before the Refugee Rehabilitation Commissioner was a challenge to the allotment and consequential deed of gift in favor of the private respondent in respect of plot number 11/H. Full stop. Next para. We do not find from the order of the commissioner dated October 21, 2008, any consideration or scrutiny and or examination as to the premise on which the allotment was made in favor of the private respondent. Full stop. Rather, the documents produced by the appellant before the commissioner in respect of the appellant's purported possession of this plot number 11/H were also not considered. Full stop. Next para. The learned single judge proceeded on the premise that the deed of gift was proceeded on the premise that the writ petition threw a challenge simpliciter to the deed of gift, without looking into the pleadings of the writ petition, which made it abundantly clear that the basis of the challenge was against the allotment, of which the deed of gift was merely a consequence. Full stop. As such, the challenge in the writ petition was, with utmost respect, misread by the learned single judge to the extent that the same assailed the very allotment in favor of the private respondent and the consequential execution of a deed of gift. Full stop. Next para also, comma, the omissions on the part of the rehabilitation commissioner, refugee rehabilitation commissioner, comma, as pointed above, were not entered into by the learned single judge. Full stop. As such, comma, in view of our above observations, comma, we are of the opinion that the matter ought to be sent back to the commissioner for a fresh adjudication on merits upon giving opportunity of hearing to both sides on the basis of the representation of the appellant. Full stop. Accordingly, MAT 739, FMA 952 of 2025 is allowed on contest, comma, thereby setting aside the impugned judgment dated March 17, 2025, passed in WPA 32184 of 2008, and as well as the order dated October 21, 2008, passed by the Refugee Rehabilitation Commissioner, comma, West Bengal, in the matter of Gautam Kaur versus State of West Bengal and others. First up, we hereby remand the matter to the Refugee Rehabilitation Commissioner, West Bengal, for a fresh consideration and adjudication on the representation of the appellant upon giving adequate opportunity of hearing to both the all the interested parties, including the private respondent and the appellant, and in accordance with law, in the light of the observations made above. Full stop. While making in the course of such fresh adjudication, comma, the Refugee Rehabilitation Commissioner shall advert to the documents of purported possession of the appellant as well as the basis of the allotment in favor of the private respondent and decide on the same in accordance with law without being prejudiced in any manner by any of the observations made above. Full stop. It is expected that such exercise shall be concluded by the commissioner as early as possible, comma, by the commissioner, that is respondent number 3, comma, as early as possible, comma, preferably within December 31, 2025. Full stop. No arrest to costs. Urgency.
Disputed plot should be plot 11, not 8 million. For the record, I find is in order as well as the
11?
Only 11, yes. Settlement for number 11, not 11, 8 million.
যেখানে যেখানে 11 by age বলেছি
11 by age
ব্র্যাকেটে 11 ব্র্যাকেটে as per the appellant, comma, না সরি প্রত্যেকটা জায়গায় করবি 11 ব্র্যাকেটে as per the appellant, comma, 11 by age যেখানে যেখানে 11 বলেছি their version we are making their
no, there is no 11, there is 11 age, there is no
heart H is heart. Can one of such and such is also disposed of accordingly.
Well, is there any fresh application to be made by the appellant?
On the basis of our order, fresh consideration of your representation.
2, not 3. 2 is the
3 no, commissioner
2.
No, in the application writ petition we found 3. Refugee Rehabilitation Commission is 3.
2 secretary.
তাহলে রেসপন্ডেন্ট নাম্বারটা দেওয়ার দরকার নেই কমিশন। We are not giving the respondent number.
I am for the appellant led by Mr. Shomojit Dashmapatra. My lord, I am not pressing the application.
Learned counsel for the appellant submits that the appellant does not want to proceed further with the appeal and the application. Full stop. Accordingly, FMA 1083 of 2025 and IA number CAN 1 of 2025 are dismissed as not pressed. Full stop. No arrest to cost. Interim order, if any, stands vacated.
My lord, I'm appearing for the state led by Mrs. K. Hussain.
Please just give the names. Yes, give the names.
Deeply.
Thank
I'm grateful, my lord.
In this matter, I'm appearing on behalf of the appellant.
Mr. Chaudhary's virtual.
Oh, right.
For the
Yeah,
respondent corporation.
Right. Yes, Mr. Chaudhary.
This is
my lord, affidavit of service I have served. There is an application under section 5. There is a delay of 42 days.
42.
42.
What is the reason?
The reason is the appellant was ill and could not contact his
Yes,
learned
Mr.
advocate.
Chatterjee, what do you say to that?
Section 5, I generally don't
Private, you are
oppose.
for the private
I'm
respondents.
for the corporation, Hindustan Petroleum Corporation.
Corporation is the main contesting party.
Main contesting.
Private respondent. Fair. We have heard all of you. Affidavit of service filed today be kept on record. Full stop. In view of the sufficient explanation furnished in the application for condonation of delay in preferring the appeal, comma, CAN 1 of 2025 is allowed on contest, thereby condoning the delay in preferring MAT 1214 of 2025. Full stop. There will be no arrest to cost. The appeal and the connected application are taken up for hearing. What is the appeal about?
And it is against an order. But it is in connection with appointment of petrol dealer
Right.
by the HPCL. The order dated 25th May 2025. And it is not a tender case. It is a case of appointment of dealer as per brochure of their oil company.
All right.
All the judgments they have relied all relating to tender, this and that, it cannot be. And the main question has not been decided, which I will place.
Mr. Chaudhary, you were given the dealership. They had challenged, or the other way around.
No. I am challenging the dealership of respondent number 8.
So you are the writ petitioner.
Writ petitioner.
Right. What is your ground for challenge?
I have two grounds. One, the requirement of land has not been fulfilled.
Right.
Number one ground.
Hmm.
And main ground is the lease deed is invalid.
Pardon, lease deed is?
It is invalid.
Invalid. Why?
Lease deed is invalid.
Why?
And as per stand of the HPCL, the lease deed is invalid, which has been taken in other case by the HPCL.
Why do you say that?
Lease deed is required to be executed by the all co-owner.
Achha.
That has not been done.
All right.
There are three categories. One, if he is owner and family members are owner, then no objection is sufficient. No objection of other co-owner is sufficient. Now, if it appears the applicant or his family members are owner of part and there are other co-owner, then no objection is sufficient, because I think that they have right to go into the land as owner. So the place offered by them would be sufficient if the no objection is granted, because they have ownership. Now, if in respect of a plot, all are outsider, then
not members of the family.
Not member of the family. Then lease has to be executed by all co-owner.
No objection by the other co-owners would not suffice, according to you.
Not suffice. It is the brochure and it is the stand of the HPCL in other cases. I will submit a decision of division bench.
All right.
To cut short the matter, my lord, taking pause from my learned friend, my lord, if your lordship peruses the interim order, my lord, the submission now been made by my learned friend, that was not the subject matter of argument before the writ court. They are taking additional grounds in the appeal, which is, there is no whisper of that in the writ petition itself.
Yes, Mr. Chaudhary, what do you say to that?
My lord, kindly come to ground number
No, in the impugned order, it has to be reflected that you took this ground before the learned single judge or in the writ petition.
It is a on the ground of eligibility. Kindly see page 15, the ground number 10.
No, that is before this court you are making this.
No. Before the writ
Before
court.
writ court, right? Page 15.
For that, the private respondent Sangeeta Maji was not at all eligible for the subject relapse due to lack of her eligibility.
Page 15 of what?
Of the stay application, my lord? Oh, I'm sorry, my lord. I'm handing over the
petition we don't have, yes.
writ petition, opposition, and reply.
Also the brochure.
একটা দাও না ততক্ষণ তাহলে কাজটা এগিয়ে যাবে
Before, kindly take up the writ petition. Before going into the grounds, if you will still kindly have a look to
yes.
Now I will be arguing on the point of his eligibility. And also, I have stated the deed are not correct, legal. That has been stated in ground number 2 and 7. It is not sufficient. And ground number 10 is sufficient, my lord, for arguing on the ground of eligibility. Moreover, if you will actually come to page 70, just for a moment to page 70.
17.
70. It is one of the clause in the brochure, clause number 22.
Yes, 22.
If any statement made in the application or in the documents uploaded, submitted, or subsequently uploaded, submitted in pursuance of the application by the candidate at any stage is found to have been suppressed, there is suppression, I will show. Misrepresented, there is misrepresented in the application, I will show. Incorrect, it is incorrect, I will show. Incorrect or false. Then the application is liable to be rejected without assigning any reason. And in case, this is very vital, the applicant has been appointed as a dealer, the dealership is liable to be terminated.
Yes.
So there is no question of any infractuous. Another day, my learned friend was saying that it has become infractuous. Even this point can be taken by any person, even the other 3 applicants. And there is no limitation on this point.
Yes. Yes.
Well, I'm drawing your lordship attention to the brochure. Now, before that, I'm drawing your lordship attention to the lease deed.
Yes.
I'll be submitting there is insufficient land in order to show the arbitrariness on the part of the authorities, although it is not my main ground. If you logically come to lease deed.
Yes, lease deed.
I'm showing it. In this case, what happened? One lease was obtained by 2 persons. That is in page 87. Page 87. Lease of
yes.
the 2 decimal was taken by in page 89. Sri Gautam Majhi and Pintu Mukherjee.
Right.
Majhi possibly is the father or brother of the private respondent applicant. Can you see their schedule of the land? That is in page 93.
Yes.
In the north 85, south 72, in west 122.6, on road east 122, in north south. But I'm submitting one map, that is LR map, and one sketch map prepared by me as per the schedule. LR map
These to have been annexed, my lord, by handing over these documents. These
Yeah,
are
These are not annexed, Mr.
and these were
Chaudhary. We
never
cannot look
before the
into these.
report also.
my lord.
So if it is
report.
not, no, we won't. Devan, we can't look into these documents for the first time. And we cannot go into a fact-finding inquiry as to the identity of the land sitting in jurisdiction in appeal also.
One requirement is this. I submitted.
Yes.
My lord will find that land requirement from page 42. Brochure.
Page 42, yes.
The applicant is the candidate under group 1.
Yes.
My lord will find the application of the applicant from the opposition of the respondent number 2 to 4 in page 16.
Yes, application.
And they have offered land dimension of 35 and 35.
Which column?
I'm showing that. On page 17. (35) and 35. Requirement is
yes.
Now can we come to again the land requirement condition.
Yes.
I submitted earlier from the brochure. It will appear that if the applicant or his family members are owners.
Where is that requirement of land in the brochure? Page?
Page starts from page 42, my lord. Oh, in the brochure, in the writ petition I have annexed, but may not be better copy. That
No.
is an
Show us from the writ petition, which page, because you are following the writ
page
petition.
42. Land applicable to all categories.
Yes, that we have found, but where is the measurement? 35, 35, this thing?
Oh, that thing in their application page, in the opposition.
35, yes. Very well.
35. They have offered this, but
yes.
requirement is 30-30.
Where is that requirement? In the brochure?
In the advertisement.
Where do we find that? Which page?
I'm sorry. Page 23.
Which item?
114. 1, 2, 3, 4. 4 from bottom.
Yes, 114. But this is the minimum requirement we suppose.
So they minimum requirement. For
more.
this, they have more.
So
there is a reasons. No, I'm saying.
Yes.
There is a reasons he has to offer more in the as per brochure. I have no objection on that. And regarding land requirement, I submitted if the applicant is the owner or family member is the owner, then no objection is sufficient under as per in format clause 3. Now, kindly come to page 42, land and A. The other condition with respect to offering land are as under. Land should be available within the applicant as on the date of application and should have minimum lease of 19 years and 11 months as advertised by the respective company from the date of the date or after the date of advertisement, but not later than the date of application. If the offered land is on long-term lease and there are multiple owners, then lease deed should be executed by all owners of the offered land. In case lease deed is not executed by the all owners, such lease deed shall be treated as invalid. It is the stand of the HPCL in other cases. I am submitting one decision of division bench.
But where do you get this relaxation that if it's same family, no objection and all these things?
From the deed itself, lease deed itself, my lord will find.
No, you say that
from the
if
record of right. From the record of right.
Mr. Chaudhary, at the inception you said, but if it's the same family, then no objection would suffice. Where do you get that? That is not there. Relaxation is not there.
D.
D.
Page 43.
Yes.
And there are page 44, various situation of ownership for defending own.
G is there also, page 43 itself.
Yes, yes.
On the consent file, such consent letter.
Letter.
Very good.
Now, Malna, can you see the record of right? They have offered two lands. They have offered two lands. One part in 901 and another part in 900 by 2354. It will appear. It will appear from the lease deed itself and also their application. There is no dispute on this point.
There are two lease deeds.
No, one lease deed combined.
You have annexed two lease deeds in your writ petition. Why?
First lease was obtained in 2018 by two persons, and all those two persons have, along with another owner, have executed another lease deed in favor of the present applicant.
Right. Very good. So the schedule is must be the same.
There is a dispute. I cannot go because I cannot. There is also misrepresentation. Can you come to page 116?
We are there. Yes.
Schedule.
Yes, we are there.
Schedule A, they have not mentioned the schedule boundaries, but in lease deed 2018 there is a boundaries. Now, in respect of B schedule, the boundary is agricultural land in west.
Both A and B have been given, or B is the entire and something like that?
No, it is A is separate, B is separate.
Achha, to both have been given by this lease deed.
Yes, both have been given.
Achha.
But description of boundary has been given only B, because boundary of A is available from the lease of 2018.
All right.
Can you see that it is the boundary of the B schedule property?
Yes, we have seen.
There is a road, metal road. I just want to.
So, what is the wrong committed by them? We are not yet to understand.
In the schedule, there is the wrong. There is no road in B schedule property.
Oh, we cannot go into that.
I am not going, my lord, on this point. I am going on the strict on that point, that lease deed must be executed by all co-owners.
Show us from the lease deed any reflection that there were other co-owners. In the lease deed, it's mentioned that there are other co-owners.
No, nothing has been mentioned. Can you record of right?
Where is the record of right? Which page? Record of right?
129.
Same plot?
Yes, yes. 129 is the 901, plot number 901. There are several co-owners, out of them, two are scheduled tribe. That is Murmu and Mandi.
Yes.
They have not obtained the lease from all co-owners. Now there is another land that is 900 by 2354. That is in page 131. There are several co-owners, 1, 2, 3, 4, 5, 6, 7, 8, 9. And one of them is the relative of the applicant, that is Bijoy Maji. So, in respect of this plot, no objection is sufficient. But no objection has not been taken.
One point, Mr. Chaudhary, which they may take is the record of right is not a proof of title. They may say that they may, but prima facie you have something to show that they are recorded as owners. It's their owners to explain the presumption.
Yes, or they have obtained lease. The measurement has been mentioned in the top. Can you see page 129?
Yes.
Again, total measurement of this plot is 46 decimal.
Right.
They have obtained lease of 22.
Maybe a portion has been given.
But they have to obtain the lease from all co-owner.
Right.
No, it has not been granted by all co-owner.
Let us see the impugned judgment of the learned single judge now.
Can you see for a moment 131?
Yes. 131 we have seen. Yes.
One of the owner is the relative, but no objection has not been granted by Sheila Mukherjee or any of his heirs. She has died.
Which is the relative?
Relatives have not been recorded. I have the certificate of the Gram Panchayat relating to the relative of Sitola Mukherjee.
Sitola, very well.
Sitola, neither from Sitola nor from heirs of Sitola. So no objection has not been obtained by them.
Well, I'm very sorry to say, man, these arguments are
Let us see the impugned judgment once,
very
Mr. Chaudhary.
clearly dealt with by the learned.
Let us come to the impugned judgment.
And so far the lease is concerned, is it invalid? Because all co-owners have not been
That
taken.
you have argued, yes. Let us see whether you made these arguments before the trial court, the learned single judge.
No, I have not. I don't know. I was not in the trial court.
Then, Mr. Chaudhary, we cannot entertain any point. It was not before the learned single judge.
It's not even pleaded.
Cannot take for the first time.
And can you see any person can come with this point, Malad? Can you see the
are not-
20?
We
It is the point, Malad.
At the selection stage, and the vested rights have accrued in their favor. Now you are taking this point for the first time in appeal, no? And this ownership is also, I mean, this is to be gone into at length. Appellate court is not the, and intra-court appeal in any event our scope is limited. We are also High Court, learned single judge is also High Court. High Court sitting over High Court. So you know the latest patent appeal scope. Let us see what point you took before the petition and another person applies for defective in title. Completely different point, Mr. Chaudhary, that the vendor, that the lessors, you should have been there in the trial, in the learned single judge.
No, I was not there.
Vendors have been taken.
But
No, that
dealership is liable to be cancelled. Dealership has
no,
yet
not
not
only
been
you are
granted.
there, your client also did not advise, because any advocate, Mr. Chatterjee, Dibyendu Chatterjee was there, he must have taken this point if it was told to him. It's fully satisfied and categorized.
My dealership has yet not been granted. My dealership is liable to be cancelled if it is found there is a.
Understood, but it's a subjective satisfaction of the authority which is to be looked into. That's also settled. Although you say it's not a tender, we appreciate. But it's, after all, they are giving the license. Unless it's gross, there is something gross. Ineligibility is gross on the face of the for these questions, we have to enter into
Violation of the violation, there is violation of the brochure. It can be shown, my lord, at this stage.
Yes. If it is
They have not.
If it is palpable, Mr. Chaudhary, we can. But
Yes,
the
it is palpable. Can you see?
No, we
The
don't know whether
brochure says-
these are co-owners. They are co-possessors at best. Don't know whether they're co-lessors, co-owners. The requirement is co-owners. There is nothing concrete before us to show these are co-owners. Secondly, this point was not taken. Defect of title was taken.
Let me indicate, my lord, two things, my lord. There is one deed which was suppressed by the writ petitioner before while filing of the writ petition. That was disclosed in the affidavit. We had
Not,
disclosed all
I
serial
have
deeds
not
that was-
suppressed.
These are annexes of the writ petition, which have been
Yes,
annexed.
but that was suppressed before in the writ petition. So we have disclosed that in the affidavit, my lord. And we have indicated how the title had flown. That's the first part. Second part was they have indicated that there is a dispute with regard to the measurement. That also on both we had indicated that there is a land evaluation committee of the corporation who evaluates the land and gives a report, and based on that appointment is being granted, man. But that has clearly been dealt with.
What
in
about
the
co-owners, other co-owners? Records of rights were before the writ court.
records of right, but because the, Malad, the lease deed which was suppressed before the writ court, we have disclosed that.
No, records of rights were before the writ court. It appears that there are other co-owners, riots recorded there. What is that explanation?
That was never a point taken before the writ court, my lord. That was never a point taken before the writ court. If your lordship peruses the impugned order, my
We
lord,
have perused the impugned order.
my lord.
Primarily, this authority is the best person, as we are saying. Those judgments, yes.
Then it's actually it's not, it's my learned friend indicated it's not a tender. It's a tender being floated where he was the
Principles should be same.
yes, principles will be same, my lord.
Brochure, advertisement, these are basically
There is no
invitations.
illegality per se at the on the documents itself.
No, Mr. Chaudhary, we are not entertaining. Sorry.
On the point of requirement of land, that is measurement, that point I can take, my lord. That was taken before the writ court.
Measurement, they have offered more land,
They have
larger measurement than required.
There is no land such type of.
How do you get that?
Yes, I am showing. That is why I am showing. And kindly come to their lease deed, first lease deed. The schedule of the first lease deed.
Yes.
Page 93.
Page 93.
Measurement has been given.
32.32 acres.
I have prepared a sketch map.
Sketch map we can't do.
Hand over.
Can't
Can
look.
you see this sketch map, my lord, kindly.
No, Mr. Chaudhary. This is not the writ court. 32 acres.
My lord,
requirement was 30.
My lord, kindly one thing, my lord. I have prepared a map which cannot be only involved as per this schedule.
You see the map?
Yes, I have handed over.
You have a good drawing hand, but Mr. Chaudhary, apart from appreciating your drawing, we can't do anything. We are not the writ court.
But they have submitted a map that has not been produced before the court. It was not fair on their part.
Nothing new in appeal. No springing surprises. Sorry, Mr. Chaudhary, we are turning down. The present appeal has been preferred against the order of the learned single judge, whereby the petitioner's challenge to the grant of what is the license called?
Petroleum. Setting up
Petroleum license. Petroleum license. License for setting up
retail outlet.
Retail petroleum outlet.
Dealership.
In dealership in favor of the private respondent has been challenged. For next para, learned counsel appearing for the appellant argues that the property / land offered by the private respondent did not satisfy the criteria as stipulated in the brochure containing the terms of such grant. Pointing out to clause 22 of the brochure, it is argued that in terms of the same, if any statement made in the application or in the documents uploaded or submitted or subsequently uploaded or submitted in pursuance of the application by the candidate at any stage is found to have suppressed / misrepresented / incorrect or false, then the application is liable to be rejected without assigning any reason. And in case the applicant has been appointed as a dealer, the dealership is liable to be terminated. It is contended by counsel for the appellant that the schedules of the lease deed furnished by the private respondent for getting the license indicate that the measurement of the land does not tally with the requirements in the brochure. Full stop. Also, comma, it was disclosed in the application of the private respondent for obtaining such license that they were providing land of dimensions with a frontage of 35 meter, comma, depth of 35 meter, and total area 1225 square meter, comma, which is not tallied by the schedules of the two lease deeds produced by them. For sub next para, that apart, comma, learned counsel for the appellant seeks to place reliance on a map, sketch map, in order to allege that the dimensions of the property as given in the schedules of the lease deeds is incorrect on the at the ground level. For sub next para, learned counsel further submits that there was gross contravention of the eligibility criteria as stipulated in the brochure, comma, inasmuch as in clause 4 within bracket small vi bracket small a within bracket, comma, it has been stipulated that if the offered land is on long-term lease and there are multiple owners, comma, then lease deed should be executed by all co-owners of the offered plot. Full stop. In case lease deed is not executed by all co-owners, comma, such lease deed shall be treated as invalid. Full stop. Subclause small g within bracket of the self-same clause provides a relaxation in case of family members, comma, where a consent letter in the form of affidavit has to be tendered from the concerned other family members than the applicant. Full stop. In the present case, comma, the concerned records of rights in respect of the lands offered by the private respondent, comma, it is submitted, comma, clearly indicate that there were other co-owners, comma, some of whom belong to the scheduled tribes, comma, who are not the family members of the private respondent. Full stop. Even in respect of one of the co-owners as recorded in the records of rights, comma, no consent in the form of affidavit or otherwise was offered. Full stop. Moreover, comma, the lease deeds furnished by the private respondent, comma, it is contended, comma, should have rendered the private respondent ineligible in terms of clause 4 within bracket vi within bracket small a itself, comma, since none of the other co-owners, comma, whose names appear from the records of rights, comma, were co-signatories to the lease deeds. Full stop. Next para, learned counsel appearing for the private respondents at the outset, comma, objects to the nature of arguments made before this court, inasmuch as the said arguments were not made before the learned single judge in support of the writ application. Full stop. Next para, it is submitted that new grounds cannot be taken before the appellate court for the first time, comma, thereby taking the respondents by surprise. Full stop. Next para, inasmuch as the reliance of the learned single judge on certain citations given by the private respondents pertaining to tender process, comma, it is argued that the contention of the appellant that those are not applicable, comma, since the genesis of the present dispute is not a tender, comma, is also incorrect. Full stop. It is argued that for all practical purposes, comma, the invitation of applications by way of advertisement stroke brochure for the grant of petroleum dealership licenses partakes the character of a tender process, and as such, the learned single judge was justified in passing the impugned order. Full stop. Next para. Upon carefully considering the arguments of the parties, comma, we are of the opinion that the reliance sought to be placed by the appellant on purported sketch maps for the first time before the appellate court cannot be entertained, comma, for the simple reason that such documents were never produced before the learned single judge, comma, nor any argument was advanced on the same in the first forum before the writ court. Full stop. Next para. insofar as the dispute raised before the learned single judge is concerned, comma, pertaining to the title of the lessors of the private respondent, comma, we are of the clear opinion that the learned single judge was justified in turning those down, comma, since it is not for a writ court to enter into a detailed fact-finding inquiry upon taking evidence, comma, which comes squarely within the domain of a regular and competent civil court. Full stop. Disputes as to title cannot be raised at the stage of a selection process, comma, that too in a writ petition. Full stop. Next para. Inasmuch as the other argument regarding the measurements not tallying, comma, we find justification in the arguments of the private respondents to the effect that upon obtaining land reports from appropriate authorities, comma, the tender issuing authorities inviting the applications selected the private respondent as an eligible candidate. So we also find from perusal of the lease deeds and the schedules thereof, comma, which are offered by the private respondent, comma, that the land furnished as per the said lease deeds was rather more than the minimum requirement as per the advertisement stroke brochure. Thus, comma, we do not find any ineligibility of the private respondent on such count. Next para, the issue of co-ownership, issue of co-owners not having signed the lease deed is taken for the first time before the appellate court, and, comma, as such, comma, cannot also be entertained. Full stop. However, comma, even if we broadly construe the arguments of the private respondent before the writ court regarding the eligibility of the private respondent in general, comma, we are unable to convince themselves that the question as to whether there are other co-owners can be entered into by taking evidence either by the writ court or the appellate court. Full stop. Next para. Even if the records of right reflect the names of other persons as riots along with the lessors of the private respondent, comma, it is
My lord,
too well
I
settled.
am not being allowed to take the clause 4, my lord.
What clause?
Regarding illegality of the lease deed.
No, we are recording our findings on that. We have not followed us. Ki bollam? It is too well settled. It is too well settled a proposition of law that record entries in the records of right do not either confer or take away title in respect of the concerned property, but are at best a prima facie indicator of possession. Full stop. The language used in clause 4 within brackets small vi within brackets small a of the brochure is that in case lease deed is not executed by all double inverted the co-owners double inverted close, comma, such lease deed shall be treated as invalid. Full stop. However, comma, the mere recording of names of others in the records of right do not create or confer title on such other persons per se. Full stop. In order to decide such issue, comma, it would be only competent for a regular civil court to enter into evidence and decide the same on merit. Full stop. However, comma, it is not for the writ court, comma, far less at the threshold stage of a selection process, comma, to enter into the title of the applicants. Full stop. Thus, comma, we are also unable to entertain the arguments made by the appellant on such count. Full stop. Next para. In fine, comma, we do not find any irregularity or illegality in the impugned order of the learned single judge, comma, since the learned single judge relied on propositions of law pertaining to tender process, which are also broadly applicable to the case at hand, comma, since we do not find much qualitative difference between invitation of applications for handing out licenses of petroleum dealerships and a tender process for any other purpose. Full stop, next para. In view of the above observations, comma, the present challenge fails. Accordingly, MAT 1214 of 2025, along with CAN 2 of 2025, are dismissed on contest without any orders to cost.
My lord, may I just
One, subject to correction, I did not intend to interrupt your lordship, my lord. My lordship is indicated that the judgments which were placed before the learned single judge by the private respondent, that was placed by the corporation. With
My lord, one thing, my lord, as per the direction in the impugned order, the Gram Panchayat is not issuing the NOC. My lord, it was directed in the impugned order to issue the NOC with in respect of the respondent number 8, private.
No, that has not been directed by the.
It has been, but they are not doing.
We are not interfering. We cannot go any further. You implement, have it implement. একটা জায়গায় না, relied on by the corporation, Hindustan Petroleum Corporation, by the HPCL.
Oblige, my lord.
Sorry, Mr. Chaudhary, and
Grateful, madam.
thank you. Next.
My lord, I am for the appeal. I have
Yes,
an
Mr. Chatterjee.
application for leave to appeal.
I'm for the respondent petition.
I was
You
not
are
a
not party
party
in the-
there. I was one of the participant where Mr. Shaharai's client has participated and he got the license. Now, what has happened, Lordship? Kindly come to the order. And I.
No, who are you?
I was one of the
Our
participants.
candidate,
I was
license
I
has
was
been
a
granted,
participant.
allotment has been made. I am running the business.
FPS.
EFPS.
FPS has been granted to him.
Yes.
Who challenged it?
My lord, I have challenged it.
In the writ court?
In the writ court, it was challenged by them. They said it was granted initially, but I made a complaint before the authority saying that the plinth level, which has been recorded, that has been manipulated and recorded. And that was one of the ground of my objections, which I raised before the authority initially. Authority decided to hold an inquiry and send it to the higher authority. That is reflected in the order.
No, the
also.
writ court set aside
Thereafter,
that rejection.
They came before the writ court and they prayed for immediate grant of the license so that he can run the business.
That has been done.
That has been done. That has been directed.
You
by
were
the
a party. Why were you not a party?
I was not a party there.
Who was the respondent there? No private respondent was.
Private respondent was not there because, Lordship, obviously my candidature was earlier rejected.
Oh, yes.
I became a minimum. I
So
became
you are
complete.
ineligible. So why should we give that leave?
No, that eligibility, Lordship, I will demonstrate
Yes.
from their documents. Number two, my lord, on the same day, though it is not part of this appeal, my separate writ petition was in the list. That writ petition was taken up and direction for affidavit has been given in that writ petition later on. My lord, kindly come to the order impugned, Lordship. Kindly come to the order impugned.
For leave to appeal is concerned, I am opposing the prayer. On
Leave.
Leave to appeal.
Yes, yes, definitely.
12
Just
August
I can
2000.
Primarily, we are also opposing, but let us say.
There is no order. Court has directed to consider my prayer.
My lord, may
That's
I
the only issue.
to take back the brochure. Or
You gave a separate brochure?
yes, separate brochure. Or if your lordship that brochure.
কি brochure দেখে দিন? Writ petition copy you had given?
Yes, another brochures are there.
খুলুন কি brochure আছে? হ্যাঁ ওটা ফেরত দিন brochure।
My, that's
দুটো কপি ফেরত দিয়ে দিন।
May I get 5 minutes time? I can demonstrate an order has been given effect to.
We have come back from. Let us come back from the brochure first.
That's all right.
Both brochures you have got?
no,
আর brochure দিয়ে দিন।
Adjourn.
sorry.
তাড়াতাড়ি। Yes.
Just
Yes.
5 minutes. Page 58.
May
So, Shara, this is too much.
Because order has been
You're taking undue advantage of your seniority.
order has been given effect to subsequent.
Mr. Chatterjee is better on public platforms, so he has to have an upper hand.
Yes, absolutely.
They have to concede to that. So he has to have a priority.
My lord, kindly come to the impugned order, my lord. The petitioner applied.
No, you are added as a respondent in the writ court.
That was
Added respondent name is appearing.
Has been recorded.
this was
I don't
added,
know how.
but for not
I
formal.
don't know how. This is not an interfinal event.
I made.
So the order
I
should be
was
cancelled on
present in
that
the
ground then.
I was present in the court. My submission was not recorded. My kindly come to this petitioner
Yeah,
applied
the-
for the license in terms
You
of
had
vacancy
you
notification
appear to have a great influence on the court because you are present in court. Your name was recorded as you had no application for.
appeared. I said that I want to interfere and intervene in this matter immediately. That probably it was the mercy of the court. Or
Let us see the impugned order. Yes.
Now, you kindly come to the internal page 2. Mrs. Such and such learned counsel appears on behalf of the state, place on record the case history of the instant matter. The case history reflects 14/5/2025 following all procedure. The Food and Supplies Department had approved as eligible candidate for APS business in favor of Sri Subroto Ghosh. 15, that is the petitioner, man.
Oh, the entire scope of the writ petition, Mr. Chatterjee, is that license has been issued, but no allotment was being made.
Now, Lordship, kindly
You
come-
don't have any eligibility at this stage.
Lordship, the next
You are
page-
unsuccessful candidates. The
I was
license
concerned-
has already been issued. You have not challenged that.
I have challenged by separate writ petition that is pending and direction for
So
affidavit.
let that take its natural
Lord,
course.
Lordship, kindly come
Here
to
you
the
don't
next
have-
page, paragraph 11. Lordship,
This will be subject to your writ petition.
no, that kindly record that. Kindly come
Achha,
here.
let us hear Mr. Shahara only on that.
Paragraph 11, kindly, this is very important. Why I am before your Lordship?
You have nothing.
This is their observation. It is denied that argued that after receiving the complaint, the inquiry had been done by a
You
team.
have no locus standi whatsoever here.
Only
They
this
were
is of my
granted
com-
license. They
After
complained before
that,
the
on
writ
the
court. I have been granted license. Allotment is a natural corollary. You are an unsuccessful candidate at a previous
They
stage.
themselves decided to form an
What
inquiry
do
team.
you have to do with it? It's between the authority and them.
An inquiry team observes something which goes against the
Not in this. In this matter, you have no locus standi.
and 3.616 inch respectively. That go down addition to that, the height of the go down that goes against the
Height, length, breadth, whatever. You are unsuccessful. You have no
that
locus
they
standi first.
themselves admits that he was not eligible. Because the minimum criteria, Lordship, for the go down was 1 feet. And now
We cannot hit at the issuance of license within the scope of this writ petition.
Lordship, kindly
We are making ourselves clear, Mr. Chatterjee.
my-
License has been issued. It's a closed chapter as far as this writ petition is concerned. Now they want an allotment on the basis of that license. Nobody challenges that license in this writ petition. So we cannot go behind the writ,
I
the issuance
understand.
of license.
Well,
So you have
my
no
writ
locus
petition
standi.
is
You
there,
reject
my
your
lord. Kindly I am providing
Your
that.
writ petition, you will get your whatever happens
So
to
that subject to the result of my writ petition, let it be decided. It will because it is pending.
Order, Your Lordship, kindly see the
pending.
order in portion. What is the challenge? Page 58.
Yes.
What is the order passed by the Honorable Single Judge? Kindly turn to my lord, page 60. There is a
60
mandatory direct, page 60, last paragraph.
Yes.
Having heard the learned counsel for the parties and also considering the grievance of the petitioner, it is true that license has been issued in terms of the notification in favor of the petitioner. The petitioner has deposited the entire requisite fees to run the license. From the case history explained by the concerned department, it appears
Yeah,
that
you
the
can also call it cash history. Sometimes it's a Freudian slip.
slip of tongue. It appears that the petitioner's business was stalled due to the same complaint. However, the entire inquiry has been done. The matter has been placed before the higher authority. The department should take appropriate steps promptly so that the petitioner may run the business. Under the above observation, the petitioner has no direction, nothing. And in subsequent thereto, allotment has been made. A post petition has been handed over. I am handing over a copy.
My lord,
I have started distribution. I am running my business. So order has been given effect to.
my lord,
Today
one
nothing
thing.
remains.
No, but they have challenged the issuance of license itself. Why shouldn't this whatever order has been passed be subject to
That
that?
petition was
If that succeeds, then
after granting
then your license goes.
After granting license, I moved this petition. An order has been passed. Thereafter, their petition has been moved.
But by virtue of this order, this was on the premise that there is a valid license issued in your favor.
Doctors,
That is to be implemented.
Their petition was not taken up at that material point of time.
That is why you are saying, Mr. Shahara, this direction has been given on the premise that there is a valid license issued.
That license was granted
That license is valid, but if they succeed in that challenge, that license will go. So why shouldn't this, whatever order has been passed, be subject to the outcome of that writ petition?
Subject to
How would that affect you?
subject to lordship consideration. This is a direction to take a decision. To make kindly, there is no mandatory direction to give allotment. The authority has been directed to take a
This
decision.
does not confer any extra right on you than what you have on the license.
But so far their repetition is concerned, your lordship kindly consider on the
We
day
are not
when
saying that their repetition should be allowed. Maybe rejected, maybe rejected. That is, there is more chance of rejection, maybe also. But this has to be subject to whatever happens in that. If they win that writ petition, then the license goes. Then whatever will happen
but
to
so
your
far my lord, this is today the challenge is that an order passed by the learned single judge. The learned single judge says the authority concerned is direct to take a decision. The authority concerned take a decision.
We are dealing with their application for leave. So we have to say why they don't have locus standi. While dealing with that, Mr. Chatterjee has made a specific argument that there is a writ petition pending at their behest.
First
So
of all,
we'll have to deal with that.
My lord, they have not been called for in the interview because they are not the eligible candidate. He is not an unsuccessful candidate. He is not an eligible candidate.
Take all those points in his writ petition. Who prevents you?
So whether he is a person aggrieved or not is the first question. So your
All
lordship
questions will come up in that writ petition. We are not interfering even. We are not granting him leave.
Your lordship gives me observation in this matter.
No.
There is no relation so far there it is concerned.
There is absolute relation. If the license is
subsequent there too.
License is the root of your right.
When this writ petition was moved, before the court there was no other writ petition. So what is the wrong committed by the learned single judge?
You are not saying that any wrong has been
there is
committed.
No wrong, my lord. Possibly your lordship will not interfere. Why I am saying when
possibly we are not even granting him leave to prefer this challenge. Listen to our order, Mr. Chade, we won't be. We will be passing our own orders. We prefer to
only one thing I want
subject to the result.
The application for this stay, if your lordship consider,
yes, we are not granting you leave.
No, only one thing.
We'll grant to limited
round
stay.
of my challenge was that they have manipulated.
We won't look into that.
So that yes, ma'am.
So your lordship will give order that subject to the result.
Will listen to us. Then, if you agree,
So far my business is concerned, that will possibly, my lord, there is no
nothing. Nothing.
As well. Well, may I have over the documents, my lord? So far the
No, we are not going into that. We are not. If you
order has been given effect to it is binding already.
Oh, that I will record that you have submitted.
And I am running my business.
Learned counsel for the petitioner. Now, the present challenge has been preferred against an order of the learned single judge, whereby the writ petition filed by the private respondent was allowed. Push up the private respondent claims. The private respondent claimed in the writ petition that despite issuance of a license, of an FPS license on the basis of a vacancy notification dated May 29, 2024, the concerned authority had not made any allotment in favor of the writ petitioner / private respondent. Full stop. Within the limited conspectus of such writ petition, the learned single judge ultimately held that it is true that license has been issued in terms of the notification in favor of the writ petitioner, and the writ petitioner has deposited the entire requisite fees to run the license. Full stop. Next para. It was further observed that it appeared from the case history that the writ petitioner's business was stalled due to some complaint. Full stop. However, the entire inquiry was done and the matter had been placed before the higher authority, and as such, the writ court directed the department to take appropriate steps promptly so that the writ petitioner / private respondent may run the business. Full stop. Next para. Learned senior counsel appearing for the private respondent, at the outset, points out that such order has been implemented and the private respondent is running his business, his or her, his business. Next para. Learned counsel for the petitioner, in support of the application for leave to prefer the appeal, submits that despite the grant of allotment in favor of the private respondent being stalled due to the complaint lodged by the present appellant, the present appellant was not implemented in the writ petition. Full stop. However, the appellant was represented by counsel at the hearing of the writ petition, although wrongly recorded as an added respondent. Full stop. Next para. Be that as it may, it is submitted that the present appellant is directly affected by the impugned order, since there was a pending writ petition at the behest of the present appellant at the juncture when the impugned order was passed, comma, challenging the issuance of license to the private respondent itself. Full stop. Next para, thus, comma, in the event such writ petition succeeds, comma, it is submitted that a valuable right would accrue in favor of the present appellant. Full stop. As such, comma, the appellant ought to be granted leave to prefer the present appeal. Full stop. Learned counsel for the appellant also seeks to address the court on the merits of the appeal. Full stop. However, comma, this court does not entertain such arguments at this stage prior to adjudication of the leave application. Full stop. Next para. Learned senior counsel appearing for the private respondent refutes the contention of the appellant and submits that the appellant does not have any locus standi to challenge the impugned order on several counts. Full stop. First, comma, it is submitted that even the writ petition filed by the present appellant, even the other writ petition filed by the present appellant is not maintainable, comma, since the appellant himself was held to be ineligible in the process of selection for the purpose of issuance of FPS license. Full stop. Himself being ineligible, comma, the appellant does not have locus standi to prefer the appeal or the other writ petition. Full stop. It is further submitted that the issuance of license to the private respondent was not even the subject matter of the writ petition. Full stop. Moreover, comma, by the impugned order, the learned single judge has merely directed the authorities to take steps in expediting the complaints and disputes pending before the higher authority. Full stop. As such, comma, the appeal itself ought not to be maintainable as well. Full stop. Upon hearing learned counsel for the parties, comma, we are unable to accede to the prayer of the appellant for leave to prefer the appeal for the following reasons. Colon, niche. Roman 1. The appellant himself, comma, being an unsuccessful participant in the process of selection of FPS dealer applicants, comma, does not have the locus standi to challenge the impugned order. Full stop. Roman 2. Secondly, comma, the limited scope of the writ petition, comma, where the impugned order was passed, was that on the strength of the license already issued in favor of the private respondent, comma, allotment was not being given to the private respondent, comma, in which context the writ court directed the higher authorities to expedite the adjudication on the complaint, which was holding up such allotment being given to the writ petitioner stroke private respondent. Full stop. Thus, comma, there was no manner of challenge to the issuance of license to the private respondent itself within the four corners of the writ petition. Full stop. The very premise of the locus standi claimed by the present appellant is the challenge to the issuance of license, comma, which was not even the subject matter of the writ petitioner from which the present appeal arises. Full stop. Thus, comma, on such count as well, comma, the present appellant does not have any locus standi, comma, being an outsider to the subject matter of the writ, comma, to prefer the present appeal. Full stop. Next para. As such, comma, we are now in any event, comma, since the appellant submits that the appellant has an independent writ petition challenging the issuance of license itself, comma, the merits of the same will be decided independently by the writ court upon giving opportunity to both sides to present their respective cases, comma, including the challenge of the private respondent to the locus standi of the appellant on the ground of ineligibility. Full stop. It would be premature for this court, comma, sitting in appeal at this stage, comma, to comment on the outcome of the said independent writ petition. Full stop. At the best, comma, we can observe that the findings rendered by this court shall not be construed to affect adversely the rights and contentions of the parties in the pending writ petition. Full stop. Next para. We'll say that only, Mr.
Well, only one thing I want to point out. Mr. Shahara has contended that I was ineligible. Lordship, there is 125, page number 125 of the stay
We make it
application, which says that
abundantly clear that
I-
all questions, including the alleged ineligibility stroke locus standi of the appellant in the other writ petition shall be kept open for being decided independently in the said writ petition without being influenced in any manner by any of the observations made above. Full stop. Next para. In view of the above observations, comma, can 1 of 2025 is rejected, comma, refusing leave to the appellant to prefer the present appeal. Full stop. Consequentially, comma, Mat 1359 of 2025 is dismissed as not maintainable without any order as to costs.
Grateful, man.
Any other connected application?
There is can 2 is there, Malas.
Can 2 of 2025 is also disposed of consequentially. Grateful.
State is representative.
Pardon?
State is representative.
Yes, yes, fair. প্রথমেই একটা লাইন করে দেয় হার্ড লার্নেড কাউন্সিল ফর দি appellant, comma, the private respondent as well as the state. Next. Yes, Smith.
Mr. Bandyopadhyay is there, my lord.
You are appearing on two sides.
My lord, I am, my lord.
This will continue for some time.
May not continue, my lord.
May not continue.
My lord, before my lord, my learned senior friend starts, my lord, I am, my lord, informed, my lord, because of the Department of Commerce and Industry, my lord, respondent number 1 and 2, my lord, LR is in the process of engaging another set of counsels, apart from us who are representing 3 and 4 respondents. So, my lord, that is one. My lord, so far as, my lord, the essence, my lord, subject to, my lord, what he says, my lord, the lease has already expired in 2024. So, my lord,
he has not even opened, Mr. Bandhu.
My lord, I know, my lord. So, my lord, let it be taken up because we also need some more instructions. We are waiting for those
Tell us when. We are on 9th today.
My lord, any day next week, as per your lordships, my lord.
Monday then. Subject to Mr. Bandyopadhyay. Mr. Bandyopadhyay, I have been allotted certain second appeals in sitting singly. So tomorrow, from tomorrow itself, we will indicate that Thursday and Friday, both days, second half, I will be taking up singly. And my lord will be sitting singly also. So in any event, if we don't take it up tomorrow, we won't be able to take up this week.
Yes.
So let us put it on Monday then. On their prayer.
Only one intelligence I can only ask.
Yes.
If it is taken up at 2 p.m.
First half, you have some difficulty.
Yes, because of my convenience. My lord, I have, every day, my lord, I cannot reach court, my lord, by 10:30. That is my lord, now your lordship will.
Oh, you are in the same bracket as Mr. Probal Mukherjee.
No, I am far worse.
Oh, you are worse than him.
I am in Sirampur. I have to travel.
So Bandyopadhyay will do this. We will keep it in the list wherever it appears because we won't disturb the.
Passover, my lord.
Yes, yes, we always.
Only because
if nobody is present, we record that nobody is present also.
Yes, yes.
Several occasions nobody present, then we dismiss for default. Otherwise, if your time is
not better, 2002 minor.
But whoever is asking for time will be at the peril of starting the matter. That much we can indicate. Particularly if he or she is a raw junior, then they'll be at the peril of being asked to start the matter. Otherwise, they'll be under threat of. No, he's practicing.
He's not raw.
He's not raw. We are speaking of raw persons. Anyway, let us come back on the prayer of learned counsel for the respondent numbers 3 and 4.
Hey, Paul.
You are for 3 and 4.
My lord.
3 and 4.
3 and 4. Yes, my lord. Yes.
On the prayer of learned counsel for the respondent numbers 3 and 4, the matter is adjourned and shall next be listed on September 15, 2025 under the same heading.
Grateful, mother. Grateful.
Next. Yes, Mr.
I'm appealing for the respondent number 10, Haldia Municipality.
I am for respondent number 11, Haldia Development Authority.
Acha.
State is.
On append is this, my lord, your lordship was kind enough to, my lord.
What about the others? So many people are not appearing.
State is the main respondent. No, sir.
You are the primary respondents.
No.
Main allegations.
Main allegation against the.
You are development authority.
For the development authority.
Municipality development authority.
State, which is Chondi.
What about service on the state? Service. Mr. Das is not there.
Chandicharan, they have learned.
No, we want the affidavits. Ms. Maiti says state is not appearing. Would you like to give another notice? Otherwise, again, an order will be passed. They'll come and recall.
Yes, yes, yes.
We'll take it up tomorrow itself. Tomorrow
Tomorrow
itself.
I tell your lordship, tomorrow and day after tomorrow, I could not be able to come to you.
Oh, acha.
And Friday, your lordship is sitting singly. That is why, my lord.
No, Friday, Thursday also. This Thursday we may be taking up.
Monday, your lordship, kindly takes it up, my lord.
Monday, very Monday.
15th, my lord, your lordship. Again, I shall sub, my lord. Again.
Since none appears for the state at the time of call, comma, let the matter stand adjourned till September 15, 2025. When?
My lord, one and instead of September 15, 16, if possible.
16th. On September 16, 2025, when an affidavit of service shall be filed by the appellant with regard to the state respondents.
My lord, again I shall sub.
Thank you. ওনাদের নামটা রেকর্ড করে নিতে হবে।
কথা বলো না again to your lordship.
নিন, ডাকুন। Yes, Mr. Mukherjee.
Your Lordship.
What happened to Mr. Chatterjee?
I'm led by Mr. Chatterjee, Your Lordship. I'm praying for not today, Your Lordship.
Why?
Your Lordship, tomorrow you can keep. Your Lordship.
Custody matter.
Yes, Your Lordship. Your Lordship has already stayed the impugned judgment on the by your last order. Your
You're
Lordship.
already enjoying a stay. Mr.
Yes.
Mukherjee.
Yes, because I am enjoying at stay, but your lordship directed them, both of us, to discuss the matter between ourselves and to fix a place where they can.
Yes, yes. What about that?
In regards with the joint visitation,
So what about that? What is the development of that?
That is the only thing.
We are
that your
coordinating on that.
lordship wanted to take,
For the
instruction.
time being, Your Lordship wanted a joint visitation that could be coordinated.
So
Then
have
the
you
man.
decided on the place?
We are deciding, Your Lordship.
You have decided?
We are deciding, Your Lordship.
Deciding or decided?
Is deciding, Your Lordship.
Deciding. How long will this ding dong go on?
I'll again.
I had a talk with Mr. Chatterjee. He suggested any place in Barrackpur, Lord. So any mall or.
We don't know malls in Barrackpur, so you have to suggest the exact place. Put it in writing on a piece of paper. We don't want a signature of the parties, but something like a mentioning slip, something should be there. We'll put it on record and pass a direction on that. So we should put when should he keep it? Tomorrow?
Tomorrow.
Agree to a place within that.
Yes.
On the prayer of the respondent, the matter is adjourned for the day. We're not recording anything. Please agree to some place. Give it in writing. Come prepared with that slip of paper. The place. Next. Matrimonial, land.
But I appear for the appeal.
Yes, this is matrimonial or custody or land or what? We are in between things.
Food safety.
But they are not. They are consistently not appearing.
But
No. Yesterday.
appearing but served and delivered also.
Yes. Then we'll hear it.
Yes, because there is a fine involved. I would pray for stay of the.
What? Just satisfy us on the primaries, on the preliminaries.
Yes. But before I start, I am seeking your lordship's leave to file a supplementary affidavit. The appeal which I had preferred before the appellate tribunal, Food Safety Appellate Tribunal, unfortunately, due to inadvertence, we have not annexed it. It is mentioned in the petition.
Yes.
By way of a supplementary, I am annexing it.
Right.
But I'll tell your lordship that before your lordship goes through the documents, the fact is, a sample was taken.
No, this is under which act?
The Food Safety Act.
Food safety. Yes.
But
Sample.
Sample was taken. It was tested. Now, the analyst came to the finding that it is not adulterated, but it is misbranded. Now, two provisions. If something is adulterated, then prosecution. If it is misbranded, then adjudication proceedings, and ultimately, if it culminates into a guilt, it will entail fine. Now, in this case, the food analyst said that it is not adulterated. It is as per the rules, but it is misbranded. And he held that this misbranding is under a particular rule of the food safety rules. Now, thereafter, adjudication proceedings was held. But two things. Once the
analyst report comes to me, I have an option to file an appeal before the designated officer within a particular period of time. There is a form for preferring the appeal. I will be candid before your lordship. We preferred an appeal, but it's not in proper form, in the form of a representation. But from the sum and substance of the representation, your lordship will find that it's an appeal. Now, that was not considered by the designated officer. Be that as it may, my lord, the process is that even if there is an appeal or no appeal, the designated officer will decide the issue and he will take a decision whether, if he finds that yes, there is something wrong, he will find whether it is to be prosecuted. In that case, he will send it to the Commissioner of Food Safety, who will initiate prosecution. And if it is a case of misbranding or something which entails fine, then he will authorize the food safety officer to file a complaint before the adjudicating authority. Now, this part is missing. The designated officer did not authorize the food safety officer to file a complaint against me before the adjudicating authority. That's one. The second part is that even though there is no
So what did
sanction,
you do? Directly refer it to the adjudicating authority?
what he did was, a note sheet was placed. There has to be a complaint. The rules provide that there has to be a complaint or an application before the adjudicating authority. What he did was, he forwarded a note sheet.
But it is technical. How are you affected?
Very well. But if I get a complaint, then I can deal with it.
Is there any provision for service of the complaint to you prior to it going to the adjudicating authority?
No, but once
got the note sheet ultimately from the adjudicating.
Note sheet was not given to us. Note sheet was not given to us.
The broad contours of the complaint were not before.
But what I am trying to impress upon your lordship is, I am missing the opportunities. I have several opportunities before ultimately I am found guilty.
But Mr. Roy, that is not an opportunity as such, because
I'll straight away come to the points, which according to me are more important. I will take your lordship through the order of the adjudicating officer. There is no finding of misbranding. There is no reasons recorded. These are the two main points. It's very cryptic, and simply it goes on the basis of the report. But it doesn't even discuss the report. It doesn't even say why it is misbranded. That's one part. And what is missing has ultimately been the reasons have been supplanted by the appellate tribunal, which in my respectful submission is not permissible. That's one.
No, supplanted by tribunal means the report has been supplanted.
No, the lack of reasons in the order of the adjudicating authority has been supplanted by the learned tribunal, and the learned tribunal says that no, this is because of that, this could have been.
New reasons have been given.
New reasons meaning, in the adjudicating
that can be done, the conclusion.
Adjudicating order does not bear any reasons. But, while hearing the appeal, the appellate tribunal says that no, this is all right, that is all right, I'll place it before your lordship. That's one part. The other part is, while imposing penalty, a particular guideline is provided in the act itself. From both the orders, your lordship will find either from the adjudicating order or from the appellate order, your lordship will not find that there is any finding as to why this quantum of penalty has been imposed upon me. And the third point which I want to place before your lordship is, the misbranding is on violation of a particular provision of the rules. But at the appellate stage, the tribunal relies upon some other rule which is not the charge, and on that basis it is found to be misbranding. But this, in my respectful submission, is impermissible in law. I am charged under a particular provision, my guilt must be under that provision and that provision alone. But the appellate tribunal cannot say that no, this may not be, but you are violating this and therefore this order is valid.
No, appellate tribunal cited other rules.
Yes.
Which are not a part of your initial allegation.
No, that I will demonstrate before your lordship. That I will demonstrate, it is not there.
What is the nature of the imputed order? Let us just come to the operative portion first.
Yes. But first, kindly see what is the rule which has been
We'll stay operation of this 2 lakhs. So,
Well,
arguable case has been made out. This is in the nature of a first appeal because questions of facts.
yes, yes.
We'll admit and
both.
we'll direct you to serve copy.
Well,
We'll grant a stay of operation of this penalty.
page 62, it's the judgment starts.
Yes, we have seen 62 and the relevant. The present appeal has been preferred against an order by the appellate tribunal affirming the order of the adjudicating authority under the Food Safety. What is the full name of the act?
Food Safety and Standards Act 2006.
Food Safety and thank you. Food Safety and Standards Act 2006. Who's the next para? Learned senior counsel appearing for the appellant takes several objections to the impugned judgment of the appellate tribunal. First, it is argued that the entire premise of the order of the adjudicating authority, which was affirmed by the tribunal, was a purported report of an analyst. However, the adjudicating authority did not attribute any reasons or even arrive at a specific finding as to misbranding, nor discussed the report of the analyst prior to affirming the same in a perfunctory manner. Next para, the appellate tribunal, while affirming the said order, supplanted reasons, some of which cited rules which were beyond the rules which were part of the original charges framed against the present appellant. Next para, learned senior counsel next argues that the statutory guidelines as to awarding penalty was not adhered to or discussed while fixing the quantum of the penalty against the appellant for the alleged misbranding of the appellant's product. Next para, it is also argued that although the Act and the governing rules and regulations provide that if the designated officer is of the opinion that a case of misbranding has been made out, she has to authorize the food safety officer, FSO capital, to file a complaint or application before the adjudicating authority. However, in the present case, such steps were completely bypassed and the designated officer merely issued a note sheet to the adjudicating authority, Dihor Zillah. Next para, upon hearing learned counsel, senior counsel for the appellant, we are of the opinion that a sufficient case for hearing of the appeal on merits have been made out. Accordingly, there shall be stay of operation. Penalty is the only operative. The stay of operation of the impugned judgment dated July 23, 2025, passed by the West Bengal Food Safety Appellate Tribunal in Food Safety Appeal number 2 of 2025 till November 15, 2025 or until further order, whichever is earlier. Next para, the appellant shall serve copies of the application, memorandum as well as a supplementary affidavit filed in court today with the leave of court on the respondents, indicating that the application shall next be listed in the monthly list of November 2025 when an affidavit of service shall be filed to that effect by the appellant.
I'm great.
Thank you. প্রথম লাইনে একটা অ্যাড করে দিও, affidavit of service filed in court to be kept on record despite service none appears for the respondent. You have petition.
Contempt petition.
Yes.
Pursuant to your lordship's direction, passed in the last occasion, I have served both the parties as well as the advocate on record for the respondent husband. As in earlier occasion, neither the advocate
better than the earlier occasion.
Yes. Much better than the earlier.
Yes.
The only thing I will tell you, lordship, my lord will kindly come to your lordship's order. My lord, it starts from page 14 of the petition, and the operative part is at page 16, paragraph 9.
Yes, current alimony. What has he not done?
My lord, until filing of this contempt petition in July 2025, my lord, a sum of rupees 1,35,000 and odd was due in terms of your lordship's order. My lord, only 30,000 was paid.
Current is being paid.
No. One unquantified 30,000 is credited to my account. Then my instruction today, my land client is also present in court, that a further sum of 10,000 without indicating as to whether this is a current alimony or towards areas.
40,000 in total.
40,000 in all has been paid. Even then, my lord, in terms of your lordship's order, my lord, a sum of rupees I have stated in my petition.
And no litigation cost has been paid at all?
No. My lord, I have stated in paragraph 11.
In any event from April, the current alimony, even if from May, we grant directed current alimony to be paid from May, no April. April, May, June, April since, I mean, today we are in September. So 6 months, about 6 months.
Only 10,000 plus that 30,000.
So that comes to 60,000 itself, current alimony. 10,000 for 6 months. Current alimony would be 60,000.
Yes, of course.
Plus arrears.
Plus arrears.
And litigation costs also. Yes, what do you say?
We have not contracted with my clients. Lastly, I have seen my client has paid 10,000.
We'll issue a rule.
Kindly issue a rule.
But several times we made contract.
Understood.
My client, Mala, kindly see my mobile number and
No. You are saying from the bar you are submitting.
Switch off.
Then he's appreciate my land friend's agony. But it happened on the earlier occasions also, and
send notice.
The order of this court. The local police station was directed to ensure.
Let us repeat that exercise.
Very
unfortunate.
He's 76 years old. I don't know whether
He's
76.
76.
May I tell your lordship only one thing? But he
is ill or
owns a three-storied building. I used to stay in the ground floor of the same building.
Anyway.
Three-storied building.
Affidavit of service filed today be kept on record. Footstep learned counsel having instruction to appear on behalf of the alleged contemptor submits that despite several efforts, he failed to establish contact with his client, whose phone is also switched off. Footstep next para. Since the alleged contemptor chooses to abstain from appearance before us, despite service of notice, and in view of the allegation that out of the current alimony as directed by the order dated April 8, 2025, which itself comes to about 60,000 till date, over and above the 20,000 of litigation costs and huge arrears of alimony, only an amount of rupees 40,000, by two separate installments have been paid to the petitioner wife. Thus, a palpable case of deliberate and willful violation of the order dated April 8, 2025 on the part of the alleged contemptor by not paying the alimony as directed therein to the petitioner has been made out. Accordingly, a rule to issue calling upon the alleged contemptor to show cause as to why the alleged contemptor shall not be penalized in terms of the prayers made in the contempt application. The rule is made returnable on November 7, 2025 November 4, 2025 at 10:30 a.m. 4th November, 10:30 a.m.
Great.
The rule run up of it.
Anup Bera. Madam.
24, Anup Bera, yes.
But I am for the applicant.
Your list is with your clerk.
Pardon?
Your list is with your clerk. You're asking the name
in the mobile.
Oh, in the yes.
This is my application for contempt.
This is appearing for the first time. Contempt.
First time.
What is the nature of contempt?
Content, my lord, the lordship was pleased to, my lord, direct the, my lord, the alleged contemptor to produce the, my lord, the child for visitation by the, my lord, petitioner.
Not produced.
Not produced. But even on several occasions, my lord, at the scheduled time, my lord, my lord, the particular place, my lord, I went, my client.
It was an expert order. You have served copy of
My
the
lord,
order.
I have served, my lord, in spite of service, my lord, none appeared.
Have you produced anything to show service?
Yes, my lord, I have annexed, my lord, the.
Yes, you have annexed the track report. A prima facie case of contempt has been made out, since in apparently deliberate violation of the order dated June 18, 2025, passed in FMAT 166 of 2025 with Can 1 of 2025, the respondent has failed to give visitation rights to the appellant in respect of the minor child of the parties. Full stop. Accordingly, the petitioner shall serve a copy of the application on the alleged contender, indicating that the application shall next be listed on September 10, 2025. Full stop. Affidavit in opposition, if any, shall be filed within September 23, 2025. Full stop. Reply, if any, shall be filed on the returnable date with advance copy to the appellant, advance copy to the alleged contender. Full stop. The petitioner shall file an affidavit of service with regard affidavit of service on the returnable date.
Not September, but kindly, but this is the September is going on.
Pardon? Oh, November. September gulo November kora. Thank you.
$25? What are 25?
24, 25 taken up together.
Hearing 25, I'm the petitioner in person.
What is the number?
25. Dr. Miri Day versus Bond Standard.
That is 26.
26.
Not 25.
Sorry, ma'am.
I am for the Respondent Union of India.
25 contempt and appeal, the two action made. Well, the
26 is an assigned matter. You are appearing in person.
Appearing in person.
You're an advocate. You're appearing in person.
Yes. So, PhD holder of Calcutta University, I am after retirement from the post of Assistant Manager Personnel and Administration from Bond Standard Company Limited, I enrolled my name as an advocate.
Can you, ma'am, please take the microphone more towards you, because we. Yes.
Yes.
You're not very good at shouting, so you have to take the microphone.
So I'm suffering from so much.
We have seen you waiting for several days. So at last your matter has been called up.
Yes, Lordship.
What is the matter about? Tell us.
The matter before saying that Dr. Devipal appeared on my behalf being my.
Is that 2007 appeal, Mr. Chakraborty?
Yes.
Yes, this appeal is against what order? Give us the basis of the case.
The basis of the case is that before that, I said that the company which I'm working as an assistant manager personnel and administration, that was taken over by Eastern Railway, but only the property is not the company. As such, whether Mr. Chakraborty can appear, whether he got locus standi, I have no idea. That your lordship may please decide. But the fact of the case before that, I want to say that I was prevented. I was not allowed to work on 5th September 2001, and the case is going on for a long time and on protracted litigation. The case came before Justice Oshin Banerjee division bench, where Dr. Pal appeared for the last time 8th November 2011. And thereafter, I also appeared in the case in person. This is that.
Chakraborty, take your seat. We'll just. This may take some time.
This is 10189.
Yes.
This was not heard at all. This was only for area full salary for 23 months. And this is the third page.
You are Dr. Dey, aren't you?
I am
Dr. Dey, what is the ground of your appeal? What is the wrong in the impugned order?
appeal that was heard by Justice Oshin Banerjee, that I was prevented. I was not allowed to work on 5th.
We are hearing the appeal on merit. What is the merit, the ground of the appeal?
Ground of the appeal is the same, that I was prevented. I was not appealed. After
What was done by the impugned order?
Improved order didn't give me that, the single bench didn't give me that salary for 23 months, that area's full salary. That was I wanted from the company Bond Standard. Because
Let us come to the impugned order once.
malafide and arbitrariness of few officers who are after when I was working as assistant manager, my name was forwarded for deputy manager by GM personnel, but the marks were allotted to me in the DPC committee that was tampered by officers like Vicky Pal, Shomen Mojumdar, and Golokhori Nak and others, and I didn't get my promotion. Thereafter, I wanted to resign from my post and I wanted to get VRS, but none that senior GM did not accept that. You have to work here. Thereafter, when I went on 5th September 2001 to discharge my duties as assistant manager to Alipur office, Kolkata 27, I was prevented. I was not allowed to work. My small chamber was packed up with dirty files and broken chairs, and I could not neither sit, neither I can work, neither I could sign my attendance register as a mark of presence. Thereafter, I was to save my dignity as lady officer, I was forced to leave the company. Thereafter, I made several representation, but that was not accepted. Thereafter, I made after litigation that case.
You were terminated from the company. Formally, you were terminated from the company.
Yes.
When? Date?
5th August 2003.
So now you are wanting.
That was accepted as a date of retirement by Justice Asim Banerjee's division bench on 2nd September 2007.
Justice Banerjee's division bench, the matter went up. You had challenged the termination. From that, it went up to that division bench.
Yes.
Acha.
Thereafter,
what did the division bench ultimately affirm that termination? But what about the salary?
Division bench fixed up the termination. After my request, the 2nd August 2007, 2nd August 2003, 5th August 2003 was accepted by Justice Banerjee as
the date of
premature retirement. So from 5th September 2001 to 5th August 2003, I was entitled to salary. Thereafter, I filed that case, CAN 110183 2011. After taking leave from Justice Banerjee, that company has taken by Eastern Railway on 15th September.
Dr. De, now your present claim is your salary from the period 5th of July 2001 to 5th of July 2001 to 5th August.
Your Lordship, 5th September 2001 to 5th August 2003, 23 months.
Right. This period of salary you want, and over and above that, any other benefits you are wanting?
No,
that salary.
Salary. And thereafter, the case CAN 10189 has been submitted by taking leave from Justice Banerjee, and Dr. Pal. Devi Pal appeared on 8 November for the last time. Thereafter, he became sick, and I started appearing. And
Dr. De, can you please place the order of the division bench? List. Keep the list with you. How are you interested with the list?
List I have.
Place them. We are not disputing.
The case was heard on 5th.
Dr. De, keep that with you. Show us the division bench order.
No, order was not given. The case file was lost, and file was reconstructed only on 2019. Thereafter, case was heard by Justice Somen Sen in division bench, and he has ordered that on this is the.
Justice Sen has released the matter.
No, he has heard twice.
Why was it assigned to us?
No, the lockdown was declared. He could not give the order. He has heard the case on.
Who said he could not give the order?
12th December, he has heard the order. I'll give you.
Dr. Sen, Justice Sen.
Yes, see this order. Justice Sen, para 6, page 6. See this order.
Yes, din.
12th December, he has heard the case. That's also 24th December 2000. 24th December 2019. After the case was reconstructed, case file was lost, and thereafter the case file was reconstructed only on 2019. The case was heard by Justice Robinson's division bench, and I want to say that page 19, order dated 26, page 6 para 6. Kindly see this page 6 para 6, page 6 para 6. The appellant appearing in person submitted before us that it was brought to the attention of the division bench presided over by Justice Asim Kumar Banerjee that she was not allowed to work for the period from 5th September 5, 2001 to August 5, 2003, and accordingly, her claim for salary for the aforesaid period should be considered. This was also, I have want to show this. And here is the Supreme Court judgment, which I annexed at can 12. And
You said by an order, Justice Banerjee had accepted that it is premature retirement, but that was not an order passed in court. Verbally, it was said.
His Lordship said that appellant appearing person submitted before us that Ashwin Banerjee wrote that she was not allowed to work. She was confirmed that she was not allowed to work, and accordingly her claim for salary for the aforesaid period should be considered. Thereafter, case was also heard on 24/12 when I submitted CAN 10189 of 2011. Thereafter, case was when he was
That application was misplaced.
before that the application was misplaced. Before that, I couldn't make it understand. Case was heard on 12 December 2019 after the case was reconstructed. Our case file was lost before that. Case was reconstructed on 2019, and Honorable Justice Banerjee has given that order. Thereafter, on 24 December 2019, I filed as per Honorable Justice instruction that case.
Justice Banerjee had recorded an order accepting that on the issue of gratuity, we find the proper calculation. You were allowed to retire on August 5, 2003. So that was accepted in an order of Justice Banerjee.
Thereafter,
formal order was passed.
Thereafter, case was that only the salary question. The salary was not given.
23 months salary. 23 months salary.
23 months salary. For that reason, that CAN 10189 was filed after taking leave of the court. And Dr. Paul appeared only 8/11/2011. Thereafter, I started appearing. The case was also heard on 27 June 2012. They said the case was not heard. This case was heard. You can see this, Your Lordship.
Ma'am, have you got a copy of an extra copy of this? Because this is very vital for your case.
Yes.
So for the other side, at least if not for us,
The other side has a copy because I have annexed.
have a copy.
The CAN 12.
This is the order dated
CAN 12. CAN 12.
12th of December 2019. Mr. Chakraborty, do you have a copy?
CAN 12 আছে।
12th of December is not relevant judgment. Is
No, CAN 12. CAN 12.
Whenever you cite something, you have to give copies to the other side.
A copy has been given. CAN 12, 2004. As for the order.
Doesn't have a copy. Give another copy to him.
Kindly take up.
Justice Tapapata Chakraborty on 11 December, I filed.
Anyway, Dr. Dey, whenever you rely on a document, at least in our court, you have. It's a non-negotiable factor. You have to give a copy to the other side.
Given the copy.
Now. Right now, you have to give another copy. Where is the other copy?
CAN 12 is with me, my lord. Kindly come.
We have to see you give that copy to him.
CAN 12 is a copy.
Unless you give a copy of the order to him and to my learned brother, we cannot hear you because there are findings in your favor in this order. And if you rely on this order, the other side must have a copy of this in front of us. It has to be given.
CAN 12 is the order, and where I have.
No, without a copy, we cannot.
We have the copy with them.
There are several findings in your favor in this order. This will go against them. So they have to have a copy.
They have the copy of CAN 12.
You are saying they have the copy they don't have. Let us not waste time on this. Dr. Dey, you have to give a copy to them. Otherwise, we won't hear it.
Please, for God's sake.
Give a copy.
I have filed the CAN 12 in file CAN 12. CAN 12 I have filed.
আপনি এটার কয়েকটা কপি করে নেবেন তো We'll take this tomorrow. We'll take out copies of this. 3 কপি করে নেবেন
কপি আছে CAN 12 এর মধ্যে কেন মিথ্যা কথা বলছেন CAN 12 এর মধ্যে
দেখি একটু ডিটেইলটা During hearing, the appellant appearing in person seeks to rely upon the certified copy of an order dated December 12, 2019, passed by a coordinate bench in FMA 2447 of 2007 with CAN 11913 of 2016 with CAN 5206 of 2018. Full stop. However, since
Your Lordship, kindly see this.
we do not have an extra copy for the bench as well as for the learned advocate for the respondent number 1, which is represented in court to date through counsel, comma, our officers may take out photocopies of the said certified copy during the course of the day and furnish the same with the file when we take up the matter tomorrow till when it is postponed. Eta kalke diye din liste. This will appear in the list tomorrow. We take up appellate side matters. Oh, tomorrow. No, yes, tomorrow we will be taking. We will take appellate side matters from 2 p.m. Eta 2 p.m. diye deben.
Your Lordship,
With the
excuse
other-
me, excuse me. Please see this.
Din, likhi dichen.
And 12, I have annexed and given him a copy to this as per the order of Justice Tapubrata Chakraborty.
You have a copy of this? Should have a copy. If it's annexed to that application.
Can 12 is on there, my lord, with me.
Can 12
Why are you handing over extra copies? You can rely on your application itself. Page 23.
Page 23, yes, page 23 is there.
Page 23, please come.
Your lordship, if your lordship is pleased to take up can 12, kindly see the relevant document, which is at page,
Numbering নেই এখানে?
page 36 is very much relevant, my lord.
Can 12 কোনটা? নতুন নাম্বারিং গুলো কোথায় আছে? এটা কি নাম্বার হয়ে কি হয়েছে? হ্যাঁ, সবকটি তো রিনাম্বার হয়েছে আমাদের কাছে আসার আগে।
That is the judgment of Honorable Justice Ashim Kumar Banerjee and Honorable Justice Taposh Kumar Giri.
Thereafter,
The original one.
thereafter case was heard by
page,
Justice
এটা ওনাকে ফেরত দিন এই অর্ডারটা কেটে দাও।
Yes, and
কেটে দাও, পুরো কেটে দাও।
there is
Yes, it is annexed here.
At page 38, my lord.
No, no, she's in the midst of argument. We asked you only whether you have a copy.
I have also annexed one case law of Supreme Court, Sinath versus
Where is that? Which page?
Sinath versus Bharat Art Movers.
Which page?
10-12. 10-12, I have annexed one.
Which page of CAN 12?
Page 19, page 19 to 30. Page 19 to 30. Page 19 to 30. Sinath versus Bharat Art Movers. I'm sorry, I'm getting excited. I lost my vision, that is the problem.
No, no, no difficulty. We'll check.
It's 19 to 20. And the para 30. Para 30. Page
Yes,
30. Page 9. Sinath versus para 30. Your Lordship.
we are there. We are reading that. এই সার্টিফাইড কপিটা ফেরত দিয়ে দিলেন ওনাকে? ওনাকে যিনি দিচ্ছেন তাকে তো দেবেন। ম্যাম, প্লিজ টেক ব্যাক দিস সার্টিফাইড কপি। উই হ্যাভ আ কপি হিয়ার। দেখতে পান না, উনি হাতে দিয়ে দিন না, বলছেন তো অসুবিধা হয় দেখতে।
Kindly see the para 30, Your Lordship.
We are reading that.
That we must finally admit that we are unable to afford the contention of the respondent. A similar situation has arisen in Sivasapur and a similar argument advanced by the employer. The court, however, negated the argument, observing that when the workman was willing to work, what the employer did not allow him to work, it would not be open to the employer to deny monetary benefits to the workman who was not permitted to discharge his duties. Accordingly, the benefits were granted to him. In Shantanu Murari Sinatu, so the court held that since relationship of the employer and the employee continued till the superannuation, till he is entitled to full salary and allowances on the entire period he was kept out of service. I was victimized and I had to face the arbitrariness and malafide of the officers like Vicky Pan and Bulafudina and other officers. I can show you this, Your Lordship, one letter of Provident Fund Commissioner. They wanted to give me the family pension under the Government of India Act. Nothing has to be paid by bond standard. Even they want the simple information like my year of service and date of birth and date of retirement. That also have not given to them. In spite of several times, the Provident Fund Commissioner sent their staff, their officers, and the letters. Kindly see the letter. How many times also only they have not to pay a single fine. It is only family pension of 2,000 only per month. That the family pension after retirement. That also the simple information was not given.
Dr. De, please come to page 27 of Can 12. The Division Bench of Justice Banerjee clearly observed that the appellant would be entitled to all retirement benefits available to her up to August 5, 2003. She would, however, be not entitled to salary for the period from September 5, 2001 to August 5, 2003.
The same judge heard the case again. Again, that was.
But where is the order on that, on the rehearing?
Rehearing was order was all lost. The rehearing was hard. That was hard.
No, it was specifically dismissed. That
time salary was not.
and you have got the notional benefits, including incremental benefits, that retail benefits. That you have got, but it was the specific direction of the court. You will not be entitled to salary. How can you reopen that?
For the salary, I have given a specific application on, and that was CAN 10189 of 2011. And
Have you made this is a different? You filed a new writ petition. This is not a review application of the, not a review application. So how can in a fresh writ petition you have asked for that salary to be given, right?
For that, I have not asked for that. I was asked for.
You have asked for the retiral benefits and all the other things that have now been given to you.
The salary period, I have filed an application CAN 10189 of 2011.
Salary, how can you get it? Because the division bench turned down.
After he has considered again, he has considered and allowed to submit that application.
Which order? Did that bench pass an order?
That
When? What is the date of that order?
That was that 27 June 2012.
27
June. This is the case was heard. 27 June.
Do you have a copy of that order anywhere?
Lost. They said that time that the Ministry of.
Have you got an endorsement on your brief or Dr. Pal's brief? Endorsement on the brief of that order?
No, nothing of that. You see that the case was.
That only shows that the matter appeared before His Lordship.
27.
We do not. We want to see.
See, Your Lordship, please. Can you see, Your Lordship? Case was heard.
What do you want to prove from this?
Case was heard on 2012. I want to prove that.
This does not prove it. This only shows that the matter appeared in the list on that day. We could have been convinced, Dr. De, if you don't let us speak, we won't be allowing your appeal at all. You have to let us speak. We have full respect for your age, full respect for the plight you are going through, and that being a lady, you have having to run from pillar to post. We have full respect, but we are being very clear that we won't go beyond the law. That's why you have to let us speak to understand what we are intending. This is a list showing that the matter appeared on that day. That only shows that the matter appeared before the bench. This is not a copy of that order. Do you have the advocate's brief with the endorsement of the order? Because we as advocates always take notes on our brief, back sheet, that an order is passed. If you can prove that, we can proceed on that premise. Dr. Pal's junior must have been there. He must have taken some note.
Junior was not there. I was there.
So if you are there, you must have taken a note on your brief cover. Where is that? Show us a contemporaneous recording by you. We'll go by that.
And you see that the case was heard. Thereafter, case lost, file was lost, case was reconstructed. The order was passed by Justice Somense.
Somense's order, Justice Somense's order is annexed before us. And we are looking at that only.
That order, Justice Mutation has accepted. That case file was lost and it was reconstructed.
We are also accepting it was lost. But that does not entitle you to salary after the division bench dismissed that.
Why is it dismissed? They have not dismissed. That was 2007. Thereafter, the case was heard again on 2011. And
There is nothing on record to show that any further order was passed.
And thereafter, how is Justice Mutation?
Then anybody will come up and say that records have been lost. Order is passed in my favor. Sorry, Dr. De.
Justice Mutation heard the case. Justice Mutation heard.
Sorry, Dr. De. No.
If
Just by saying that record has been lost, you cannot reopen an issue which has been closed.
issued by Justice Mutation division bench, whether he has wrong
Mhm.
he said on the 12th December that order was not on page 2, para 6 of the order. Kindly see the page 2, para 6. Page 6, para 6.
Yes, yes.
Page 6, para 6, the appellant appearing in person submitted before us that it was brought to the attention of the division bench presided over by Justice Ashok Kumar Banerjee that she was not allowed to work for the period from September.
Justice Shen records, Dr. De, accordingly, her claim for salary.
Consider
Justice Shen records his division bench that the applicant appearing in person has submitted before us that it was brought to the attention of the division bench presided over by Justice Ashim Kumar Banerjee that she was not allowed to work for the period from September 5th, 2001 to August 5th, 2003. And accordingly, her claim for salary for the aforesaid period should be considered. And supposedly, there was some assurance by the said division bench, which we, however, are unable to find out from the available record. However, a copy of an application being CAN 10189 of 2011 is produced by Mr. Mujumdar, wherefrom it appears that identical payer for payment of arrear full salary with effect from such and such said application is not in the nature of review. Under such circumstances, we direct the department to produce. So if you have not filed an application for review of Justice Banerjee's initial order, then we have no scope of reopening that. The Writ Court did not have any scope of reopening.
See this 24th December 2000, the Lordship Justice Mutation ordered me to submit that CAN 10189. See that the same order.
No. His Lordship only observed that you have filed an application subsequently for the same relief. 12th December. That is what we are reading. Let us put it before you. Dr. De, no. Just by being persistent, you cannot get a favorable order from any court. This is the last court which will give you an order just because you are persisting and on and on. We won't pass an order just for the asking. If you are entitled, you will always get an order. Justice Shen records. Please keep that with you. Please keep that with you and listen to us. Justice Shen records that you have submitted that there was an initial order by Justice Banerjee's division bench. Subsequently, that bench assured that it would be revisited. But it is simultaneously recorded there is a subsequent application by you, not for review of Justice Banerjee's division bench initial order, but for the self-same relief of salary again. Now, by way of filing another, if I am the Writ Court, you file another application for the same relief which has been turned down, without that order being reviewed, how can we allow that application? We are barred by the principle of res judicata, aren't we? Don't you feel that we are barred by the principle? We are bound by the division bench order. We are barred by res judicata. Your only scope is to have a review of that order of Justice Banerjee, which will give us the opportunity to revisit that order and come to a finding either way. But you cannot file another application for the same relief which has been turned down by a division bench. If you do that, that has been rightly rejected. Now, what is your take on that? What is your answer to that?
My salary, I will follow your advice.
Dr. De, believe us, we would love to give some portion of our salary to you at a personal level, but we cannot do that as a court of law. No.
His Lordship wants.
We are extremely sorry. In law, you are not entitled. You are not entitled.
Then don't give any negative order, Your Lordship. Kindly allow me to. Another thing which I forget to say, I made the case The company has taken over by Eastern Railway with only the properties and not that company, only the properties of one standard, the Government of India undertaking on 15 September 2050.
Mr. Chakraborty, we are giving you notice. We'll treat this application as a review application. We'll treat this application as a review application. Not necessarily that we'll allow it. No. But we'll revisit the matter.
As your lordship suggests.
Thank you for that.
One thing is that, my lord, bond standard is not in existence.
Bond standard now what? Who should be? It's in what? Who has stepped into the shoes of bond standard now?
Actually, when in
It was liquidated probably.
2018, it was liquidated.
Now
Assets were taken up by payment of a lump sum amount by the Eastern Railway.
by
Eastern Railway. And
Eastern
difficulty is that, my lord.
So Eastern Railway.
And difficulty is that, my lord. When
What
the matter
would be
was-
the amount of the salary you are asking for? What would be the quantum of salary?
3,45,450 plus consequential benefit.
Converting this application.
Really,
Dr. Dev, when did you join practice? When did you join practice? Enrolled?
2000.
Very well. Need not. No, but Mr. Chakraborty, she has mentioned in the caption Order 47 Rule 1. She has mentioned in the caption Order 47 Rule 1.
that I have seen.
It's not in format. Not in format.
That I have seen.
But
after a long.
if the court says that she is entitled to the retirement benefits, notional benefits, why shouldn't the salary not be given to her?
That was a compromise decree.
No compromise.
That was
not
recorded on basis of concession.
The relevant order is done.
Yes.
Page 36 of Can 12.
In view of the concession made by, we'll look into whether the advocate's concession can be, how far it can be. And Dr. Devi Pal's concession.
Very busy. Sometimes he's coming, sometimes.
Yes. Anyway.
And if you allow me 1 minute, I made several representations.
We are doing something, Dr. Dev, which is unacceptable in legal fraternity. Dr. Pal giving a concession, and we should not look into that. But in any event,
Lordship, kindly allow me 1 minute. I made several representations.
no, we'll treat this as a review application.
And
Do you have a copy of this? We'll treat this as a review application.
That application, yes, that is there. But one difficulty is below at the very outset.
Yes.
These old records are not available with the railway authority.
Mr. Chakraborty, we are assuring you we will proceed on the premise of, on the face of the order, which has been recorded by Justice Chen, and Justice Banerjee's division bench order is also annexed here.
Yes.
So we'll go on the face of it if it is correct, and the concession part also we are admitting the review right now on 2 grounds. The present application is in the nature of review of an order dated August 2, 2007, passed by a coordinate bench in MAT 4720 of 2005. Full stop. Next para. The review application shall be heard primarily on 2 grounds, : 1, whether the concession given by counsel on behalf of the parties is binding on the parties without there being any specific instruction in that regard, and or any power being given to counsel for giving such concession. Roman 2, whether, in view of the coordinate bench, by the order under review, having granted gratuity and notional retirement benefits in favor of the applicant, deeming the applicant to have worked till August 5, 2003, when she was deemed to have retired, there could not be any justification, whether there could be any justification for denying the salary to the applicant for the period between September 5, 2001 and August 5, 2003, comma, when she was in service. Full stop. Next para. The matter shall be heard on the review application is admitted on the above grounds and shall be heard tomorrow. Come back tomorrow. Come prepared on this. These two grounds. You prepare yourself. Shall be heard tomorrow when the matter shall be listed under the same heading. Tomorrow we will finally dispose of this application. We are treating this as a review. Two grounds we have admitted it. First ground is that whether concession of counsel is binding. Second ground is whether in view of the court having given you relief on the premise that you worked till 5th of March. Anyway, whatever. Tomorrow. Next. এটা ওনাকে ফেরত দিও। Next matter.
Get to be excused for causing you inconvenience, your lordship.
No inconvenience. What is where? This is our job. Please, but come back tomorrow. We'll hear out finally this matter. Pardon?
December 2003.
What?
Enroll my name as an advocate.
No, we'll take that into account because we have to take that into account regarding the concession part.
Yes.
That concession was given.
I'm sorry.
No, that concession was given before you became an advocate when you were an employee.
No, after.
No, the order was of 2007. You have become an advocate after that.
There was on the 2nd August.
Justice Banerjee's order was 2007. You became an advocate after that. Remind us this tomorrow. If it was an advocate, you would be supposed to know the law. Yes, next.
Item number 27.
27? Yes. Mr. Ghosh and Mr. Bhattacharya won't be over in 25 minutes. Definitely not. Why are these matters assigned to us? Who released? Who is the culprit?
These are hard.
Hard, my lord, by Justice Somen Sen and sitting with Justice Smita Das. Then, my lord, bench broke up. Thereafter, my lord, it was placed before Justice Somen Sen and Justice Sinarai. Justice Apurva Sinarai. Justice Sinarai, my lord, on personal ground.
And we submit our written notes.
We will proceed on the basis of the written note. What is the point? The written notes must be on record then.
Yes.
Written notes খুঁজে দিন।
That is the.
Yes, because you two are appearing. How much time will it? Written notes টা দেখুন তো। বা ওনার জুনিয়রদের যারা আছেন ওনাদের দিন একটু খুঁজে দিন। জুনিয়র বাবু যারা আছেন ওনাকে দিন। Please find out the written notes for us. Both sides written notes, if you can find out. It will be familiar to you. They will take much more time. এইটাও আছে এটা বোধহয় written notes না এটা order.
This is by the
written notes. Just find out if you can. Both you have found out both. Just take it separately and give it to her. Yes, right. ওটা উপরে নিয়ে দিন।
The first one is filed by the appellants.
Right.
My written note of arguments is elaborate. Mr. Ghosh's it is what?
Mr. Ghosh, what is the matter about?
Well, this is with regard to, my lord, religious endowment and the
You are the plaintiff.
pure and simple civil matter, my lord.
Pure and simple. At long last. Yes. So, you are the plaintiffs.
I am the defendant.
You are the defendant. Yes, defendants are there. Sorry. Partition suit.
Partition and cancellation of a deed. Two players are there. My lord, partition was.
Cancellation of Orponnama?
Yes.
Otherwise,
no, not the original one. The subsequent one.
Partition in a Devottar property.
Yes. Partition.
That has been negative.
That's a negative. But that second part, that was.
What was the second part?
What degree? This is Orponnama, that was.
What has been granted to you?
Granted, some
The first one.
of the he has gifted that share in favor of Mr. Ghosh's client. That is a challenge that has been.
My lord,
you have taken advantage of.
Sebaiti right has been transferred in my favor.
But that is my, that was that.
Sebaiti right can be transferred. But if it is within the periphery of the Orponnama.
Yes. Not only that, my lord, since Manohar versus Bhupendra, the leading case, my lord, which
You must have cited Manohar also.
yes, I have given that.
Yes, the first judgment.
Yes. And thereafter, subsequent my lord, Supreme Court judgment was also there.
That has been set aside by the trial court. That transfer of Shevaitship.
Yes.
Calcutta
The deed is void.
On what ground? Because it's a Shevaitship.
Orponama, on the basis of the Orponama. Orponama, it was basically mentioned.
No.
Gifted.
Transfer of Shevaitship is permitted otherwise.
This is gifted entered property. That is the Orponama.
Not Shevaitship, but the property was given.
Yes. Also property.
Let us see the gift deed.
Yes.
Cuts for the matter.
Paper book.
Deed of settlement, page 1 of part 2. No, must be something else.
Bengali.
That is the original.
It was also given.
Bengali translation.
No, the paper contains.
Part 265.
Exhibit F is that document, that gift deed.
65 page. Page 65.
Part 2.
Page 65. 96.
That is the deed of 1996.
Paper book, page 65.
In the paper book, my lord, it
Oh,
is
this bench will also have to release.
my lord.
Justice Kumar will have to release. No typed copy in Bengali even.
Yes.
Yes. But I think in the file there is a type copy.
Where is the habendum?
Yeah.
মোটামুটি ভালো হাতের লেখা
বেঙ্গলি ডিটকে কি করে ট্রান্সলেশন
হ্যাঁ
একে আর ট্রান্সলেশন তো করা যাবে
না ট্রান্সলেশন কোনো প্রশ্ন
জাস্টিস কুমার
This is Shevaiti rights have been transferred.
Absolutely.
Mr. Bhattacharya, you better show the portion where property has been given.
Yes, yes.
Just that will be the only adjudication we are required to do.
Yes, yes. Well, you also can see.
The judgment will pass later, but we'll
yes.
decide right now.
Yes. Page 66.
Yes. Show us where the transfer of property has been effected
Yes,
in
yes.
this deed. So we find Shevaitship all through.
Bengali translated copy.
Original deed, my lord, is of 1958. 58.
That permitted transfer of Shevaitship. Nothing, no bar, no permission, right? Usual Orponnama.
Page 67. While I see page 67.
Need not shout. You have found out something which you were not aware this morning. Need not shout. Get so excited.
Page 67.
Which part, Mr. Bhattacharya?
পেপার
বুক থেকে দেখছেন আমাদের বেঙ্গলি ট্রান্সলেটেড কপি দেওয়া আছে মানে ট্রান্সলেশন টাইপ কপি
মানে টাইপ কপি we have given along with the
type copy you have given?
Yes. Given in the record.
Oh,
Bengali type copy.
This Shevaiti
There are three
96.
You
This
will
was
find, my lord.
96.
There are
three.
Three deeds. 1958.
Yes. At the top it
yes,
is
this is 96.
96.
It has been documented.
Well, two copies were given.
Must be. এটা দেখুন আমি তো এটা দেখছি
My lord, it's a 1941.
96.
And
So we are looking at the 96 one.
96, yes. We are concerned with that.
You have got a type this type copy you have got.
Oh, no, that type is not with me.
Do you have an extra copy?
Extra copy.
Yeah,
My copy is very that visible, that is it. I can read it.
No, the pages won't tell
Oh,
it.
that.
Anyway, you
Copy is not with me.
you just
Yes,
place that portion will catch up. You have an extra copy?
I can hand over. Any.
No, this is something else. This is better print, computer print.
Yes. There are three deeds. All are typed copy have been given.
All are similar deeds.
No.
Three separate deeds.
First one, my lord, is the deed of Orponnama.
1941.
Then 58.
Then 58.
No, this is what has been set aside.
Yes.
Yes, 96.
So we are looking into that first,
Yes.
96.
96.
Mr. Bhattacharya, we don't find any property being transferred.
Yes, yes.
সেবা পুজো বা আমার বসবাসের জন্য উক্ত দলিল।
Transfer of property that are reached, property 58. But 68, I'm reading one of this paper book 68.
What does the paragraph start with?
বর্তমানে আমি বিপত্নিক 67.
Yes, you have got it.
বর্তমানে আমি বিপত্নিক, আমার সন্ততি নাই এবং আমার যথেষ্ট বয়স হয়ে আছে। আমি আমার কনিষ্ঠ ভাতার সংসারে বসবাস করে আসিতেছি এবং তাহার পুত্রগণকে অর্থাৎ গ্রহিতাগণকে আমার পুত্রসেনে লালন পালন করিয়াছি। উক্ত ভাতৃপুত্রগণ আমার
This sentence won't help you. পরবর্তী সেবায়িত নিযুক্ত করিলাম. It ends with this.
Yes, my lord.
This sentence, go to the next sentence.
Page 69, my lord.
Forget the page, come to the next sentence. Next sentence, after দাঁড়ি।
Prof.
উক্ত সেবায়িতগণ আমার অবর্তমানে
দেবা পূজা
সেবায়িত নিযুক্ত করিলাম ফার্স্ট, দেন আপোষে পালা করিয়া সেবা পূজা বা পাল পর্বণাদি নির্বাহ করিবে। Only at the end we find that চিহ্নিত নির্দিষ্ট সম্পত্তি যেরূপ বন্দোবস্ত করিয়া দিয়াছেন তৎসমুদের সম্পত্তি নবনিযুক্ত সেবায়তগণ সমংশে ভোগ দখল করবে।
খরচাদি ব্যয় উদ্বৃত্ত অর্থ থাকে
তার
সেবায়তগণ উহাশয় অংশে গ্রহণ করিবে এবং আমার পিতা উক্ত গৃহদেবীর প্রথম সেবায়ত মৃত শরৎচন্দ্র
অর্থ will be required for the সেবা পূজা.
সেবা পূজা যারা
What is the bar in there?
সেবা because that's the now I am reading but উক্ত
অর্থ appears to be quite substantial.
Substantial. What are coming order now? They are in possession. They are running the
dispute is between পরমার্থ and অর্থ.
উক্ত জ্ঞানে প্রথম সেবা শরৎচন্দ্র চক্রবর্তী মহাশয় দাদু 1958 সালে 19 ফেব্রুয়ারি তারিখে হাওড়া সাব প্রতি বন্দোবস্ত
of Manohar Bhupendra, আমি তো appellant.
আচ্ছা আপনি তার বলুন। My lord is asking me, my lord.
The leading case of Manohar versus Bhupendra, it has been held that it can be done. There is no bar in transferring the Sebait's right to the next line of succession.
What is your argument on this property, the right to possess the property being given and this money being given? These are the two bones of contentions raised by Mr.
My lord, I am telling you, lordship.
দ্বিতীয় অর্থ that and this সমঅংশে ভোগ দখল করিবে. Just deal with these two, Mr. Ghosh.
And the property of that will be ভোগ that দেবী
that is what we are saying.
ভোগ দখল করিবে.
This ভোগ is not mohabhog. This ভোগ is ভোগ as in enjoyment.
Property.
Yes.
Not mohabhog.
So this possession, Mr. Ghosh, possession and money, whether this could be done regarding possession in the property particularly.
That is there already. They are also, my lord, according that your lordship will kindly
that is a part of the original orphan.
Original deed, yes.
Right.
41.
As my lord, Orponnama is of 1941.
Give us the page number of the part 2 of the paper.
41 is type copy is there.
No, which page of
okay, my
type copy is the time taken 41 আছে হ্যাঁ type
1941 type copy is there.
Type copy দিয়েছে, right?
3 deeds, my lord, type copy we have given.
2 we have recovered.
41, 58 and 96. 96 is the subject matter of challenge.
58?
58 is the subsequent deed by the
first one is 41.
96, probably there are 2
96 copies. Is the deed under challenge in the suit.
96, there are 2 copies.
Exhibit 158.
58,
Exhibit 1.
sorry, 58 we have got, 96, 2 copies we have got. We will try to find out the third one, 41 or something.
41 is the original deed.
Maybe this one, must be this one.
Your lordship got it, man?
Head note is
that is also type copy is there.
Yes, type copy. Yes, got it. 41 also we have got.
See, Durga Orponnama.
Orponnama got.
May I place it?
Yes. What is the which is the relevant portion, Mr. Ghosh? You can. Otherwise, DT and all.
This is, my lord, the original deed of dedication.
Devike, yes.
My lord, kindly turn to the next page.
Yes.
Bottom.
Right.
4 or 5 lines from the bottom.
Yes, yes.
তফসিলে বিশেষভাবে বর্ণিত হইল আমি অর্থ অর্পণনামা দ্বারা আমাদের বহুকালের উক্ত গৃহদেবী শ্রী শ্রী সিদ্ধেশ্বরী কালীমাতা ঠাকুরানীকে নিগুড় সত্ত্বে অর্পণ করিয়া সম্পূর্ণরূপে নিঃসত্ত্ব হইলাম। নিজ সম্পত্তিতে আমার যা কিছু সত্ত্ব স্বামিত্ব বা হক ছিল তাহা সম্পূর্ণরূপে লুপ্ত হইয়া উক্ত দেবীকে বর্তাইল। তিনি অদ্য হইতে উক্ত সম্পত্তিতে সম্পূর্ণরূপে মালিক হইয়া চিরকাল ভোগ দখল করিতে থাকুন। তাহাতে আমি কিংবা আমার ওয়ারিস কেউ কখনো কোনো ওজর আপত্তি করিতে পারিবেন, বা না যদি করি বা তাহা বাতিল ও নামঞ্জুর হইবে। উমাচরণ চক্রবর্তীর ইচ্ছানুসারে আমি উক্ত দেবীর সেবা পূজা এযাবৎকাল করিয়া আসিতেছি। এ কারণ উক্ত দেবীর সেবায় যাবজ্জীবনকাল আমি রহিব। আমার অবর্তমানে আমার স্ত্রী কস্তুরী দেবী সেবায়িত হইবে, তাহার অবর্তমানে আমার তৎকালীন জীবিত পুত্র বা পুত্রগণ
Yes.
আমার ওয়ারিসানগণ সেবায়িত হইবে।
You came to the sons.
Yes.
And also সেবায়িতগণ ঠাকুরের সম্পত্তিতে ভোগ দখল করিতে পারিবে।
Yes. That is
So
all.
this is what has been
Original.
Why the transfer? If you claim through as sons, through the sons,
My lord,
why transfer? Who transferred to you? One of the other sons.
one of the others.
Interstate transfer between. And the judgments you are formally relying on.
Yes.
The paragraphs you have indicated, no?
Yes, yes. My lord, I'm giving in my
Just indicate the paragraphs of Monohar and
page. এই আমারটা কই? Page 4. আমার নোটটা কই? এই আমার নোটটা কই?
নিশ্চয়ই আছে।
হ্যাঁ? এই যে,
পেজ ইন্টারনাল পেজ 4
এইটি না?
না না আপনার এই পথে।
Yes. My lord, kindly turn to page 3 bottom. That note, page
Yes.
3 bottom.
yes.
The defendant number 1 to 9 preferred the present appeal against the said judgment and decree upon the ground the learned judge rightly held that the property dedicated for pious uses cannot be divided, and if a division has been made, it is void. Reliance is placed in this connection to the leading case of Monohar versus Bhupendra, reported in AIR 1932, Calcutta 791, page 27 of 44. This is how, my lord, the copy of the judgment. So the total, my lord, 44 pages, 27 and 44. That we have annexed. Then palas or term. Shall I place that page also, my lord, or?
Yeah.
Then number 2, palas or turn of ownership is bequeathable, and also gift of sevaitship in favor of a co-sevite has been recognized if it is for the benefit of the endowment. Reliance is placed in this connection to the leading case again, my lord, upon Monohar
Yes.
versus Bhupendra.
We'll find out. We'll find out.
And the alien third one, as the alienation was made by Orponnama to closely connected member of the family who seems to have more interest in the worship of the idol than anyone else, and as it seems to have been without any idea of personal gain, in order to prevent the interference of the appellant who claims herself as an alienee of the interest of the defendant number 5 to 7, we consider that the case is governed by the special circumstances to which McLean CJ Nirod Mohini Dasi versus Sivdas Pal reported in Procedural. This is also, my lord, latest judgment of 79 Supreme Court, 1782. These are the things.
Mr. Bhattacharya.
My submission before 1941, your lordship, 1941. I have no type copy.
1941, yes.
But 50 about.
My lord, he has also filed one written notes.
I will file it.
Yes, yes.
Cited-
Both were
Cited.
Cited 2 or 3 judgments. My lord, after he finishes, my lord, I shall I have also indicated
That
in
is under 97 Supreme Court, feeling
that
inquiry.
why that is not
That it has been
applicable to our case.
That is, it is mentioned for pecuniary that cannot be transferred. Feeling equal, your loss is known year 1971 Supreme Court.
This is a gift.
Yes.
This is a gift. Isn't this a gift which you are challenging? Not not for pecuniary consideration.
Oktakol and ortho that has been mentioned specifically.
Ortho is being transferred. Right to get the ortho.
Yes.
It is not the consideration.
But here our
He does not take ortho to give ortho.
But here it's a buy of inheritance. We got two inheritance. My client will get 50%. Mr. Jose's client will get 50%. That was my submission because that deed of gift, that transfer, that is illegal. That has been held by the trial judge in our suit. Yes, that
So
is
let us get the facts clear. Mr. Bhattacharya, how many sons were there? Out of them, do you have a family tree anywhere here?
Yes.
Where do you? Just give us the page number. We'll find out the family.
Yes.
Family tree chart. Genealogical thing.
Yes, genealogical table or whatever from.
Yes, that was.
Some of the Shevites transferred their right to the others. So you are who? Other heirs?
Yes.
Your rights have not been transferred. Your Shevites
have not transferred.
Then?
But it is a bio.
Not a partition even.
But the biopedas are entered by the
one section of the Shevites has given their right, transferred their right to the other.
What right? I am putting question to myself.
No, I am answering your question.
Yes,
Shevite
but
right.
Right is for enter that has.
Before I just point one thing, my lord, to your lordship. His one of the son.
Yes.
He's the eldest son. No?
Yes.
Kanai,
eldest son.
You must be Balai then. It's generally that.
Eldest son, my lord, challenged this original deed of 1941 as void and no.
In this suit?
Not in this suit. And they lost. Appeal lost.
Now Mr. Bhattacharya is relying on that deed. That's why.
No, that. Yes. Sharat Chandra was the original.
Sharat Chandra.
Then Sharat Chandra, thereafter Kanai, Sukumar. Page 23. Part 2. Kanai, Sukumar, Rajkumar.
Do you have a genealogical table? Otherwise,
page 23 of the paper book, part 2. You'll also will get it.
Part. Page 10. Is a my duty notes of argument. Page 10. No. Sharat Chandra, Kanai, Sukumar, and Rajkumar.
Is that coach is casting aspersions on you that your genealogical table is not right? Your written notes also you have given. Which page of your written notes?
Page 10. Rajkumar পরে লেখা আছে আমি হাতে লিখে দিয়েছি টিফিন 1 to 9 the petition
not proper.
Anainal not proper. I'm not doing it. Anainal Sukumar and thereafter will be Rajkumar. Thus টিফিন 1 to 9 and thus years of Rajkumar. আমি হাতে লিখে দিয়েছি Anainal plaintiffs, Karala's sons. Sukumar died issueless and Sukumar transfer.
Your genealogical table is different from that given in the judgment.
Yes.
Kosturi Devi starts from
page 23.
Yes.
Original suit.
Sukumar, Rajkumar.
That is from Exhibit A. The judgment passed in that suit, my lord. I just mentioned, my lord, that his father filed a suit challenging this deed.
So that is different also. That was this.
That is the genealogical table cannot be different.
Kanailal Sukumar.
Rajkumar.
Yes.
Kanailal Sukumar, Rajkumar.
Sharat Chandra is not there in page 23?
Yes, Sharat Chandra was there. But his name is not written.
Then what is there? His picture is also not there. Nothing. Sharatchandra is obliterated.
Kindly first paragraph of page 23.
Sukumar died
Mention is
In the
there, but-
genealogical table,
No, no, no.
Sharatchandra we don't.
The name is not there.
Then
Actually,
What I do, the Sukumar died issueless.
my lord, may I speak?
Sukumar was
there was sufficient reason for him to die after seeing this genealogical table. Should have died. Anyway, so we'll proceed on this. Whatever. Who has gifted to whom? Tell us that.
Sukumar
Yes.
transferred in favor of the sons of Rajkumar, defender of my Anas's client.
You are the plaintiffs.
I am the plaintiff. I am the sons of Manilal.
My lord, may I?
Manilal died.
May I? Sharat Chandra had three sons.
Yes.
Kanailal,
Rajkumar.
Sukumar, and Rajkumar. Now, the plaintiffs are the present respondents are the legal heirs of Kanailal. And the appellants before my lord are the legal heirs of Rajkumar.
But your genealogical table is bad then.
Yeah, that he has forgot. But I'm sorry, man. Attending my apology. He could have mentioned it's my written notes how it is mentioned.
You have made Rajkumar, Kanailal, son of each other.
I am saying him.
Both are sons of each other.
Yes.
Kanailal is Rajkumar's son and Rajkumar is Kanailal's son.
Made mistake, man.
This is the effect of
We'll make our own.
This is the effect of Writ code.
Don't say so. Mr. Ghosh, I respect you.
My lord, may I?
Please.
He also respects you.
I am.
Sharat Chandra's sons are
Always when I
Three.
start argument,
Kanailal,
Kanai.
Sukumar, and Rajkumar. Now, appellants before my lord are the sons of Rajkumar.
They are Sukumar or Kanai.
They are Kanailal. Now, Sukumar was issueless. 96.
We'll
deed-
take it from there.
96,
We'll take it from there.
Yes.
Deed was made by Sukumar.
Rest we'll find out. So who gifted to whom?
Sukumar gifted to Rajkumar's sons.
Right.
Sukumar being the uncle.
That is the appellants before you.
So deprived the other brother's sons, according to them.
According to them.
Our very vital 1958 document. That was not present.
We'll continue with this. We are keep
Yes.
making part.
Yes.
Hard in part for further hearing tomorrow.
আমি দিয়েছি
আরে যেটা আপনি পড়েছেন এখন আর বলবেন না দ্যাট ইজ অলসো দ্যাটস ফর রিড কোড ইউ আর গোইং
Is it a crime to go to the Writ court?
also in many
So what is it? It is not a crime to go to the Writ court.
but he's saying this is a paper read.
I've been coming every day to the Writ court after elevation.
Yes.
After the first few years. We come every day to the Writ court.
Yes.
So is that a crime? এইগুলো আলাদা করে রাখবেন এইগুলো একটা আলাদা ফাইল করে উপরে রাখবেন কালকে